Good morning. This is a live test to see if someone can hear my audio.
Yes,
I
I
mean, hear
can.
my audio and see my video.
Yes, I can see you and hear you.
Great. Thank you so much. Cheers.
Sure thing.
Hi, I'll do the same. Good morning, it's Alex Judd. Just want to make sure people can see my video and hear my audio too.
Yes, I can see you and hear you.
Great. Thank you so much. I'll go on mute. And Anna and Tiffany, morning to you guys both. If you just want to come off mute and test your sound, we can make sure we can hear you.
Yes. How is that?
Loud and clear for me.
Okay, great.
Tiffany, I can't hear you.
No, still having trouble.
Is that better?
Yep, that's
Yeah,
it.
perfect.
Okay, great. Thank you. I have two speakers up here and sorry, two mics this way and another mic this way. So I just recalibrated the ones right in front of me.
I know the feeling. Surround sound. Um, And just a heads up, I'm joining now just so you can see it too. I'm on my phone for the audio and the visual, so I'm just going to also join from my computer so I can actually see everyone else. So you might see me twice. I just want to give you guys all a heads up on that. It's just one of me.
Thank you.
Good morning. Can you all see and hear me?
Yes, we
Yes.
can.
Thank you.
Good morning, just testing.
Yes, I can see you and hear you.
Thank you.
Can everybody hear me?
Yes, I can hear you.
Thank you.
Good morning. We're now on the record. It's 9 a.m. on Monday, July 27, 2026. This is an evidentiary hearing in proceeding number 25AL-0538G, Public Service Company's gas rate case. I'm Eric Blank, the Commission Chair. Can my colleagues introduce themselves for the record, starting with Commissioner Plant?
Morning, Commissioner Tom Plant.
Morning, Commissioner Megan Gilman.
Thank you both. Let's go with entries appearance, public service.
Good morning. Tyler Mansholt, Counsel to Public Service Company of Colorado. With me is Liz Brahma from the Taft Law Firm and Pat Zomer from Cozen O'Connor. Thank you.
Thank you. Trial staff.
Morning, Commissioners. Justin Cox, Assistant Attorney General with the Colorado Attorney General's Office on behalf of staff. I'm joined by my colleagues, Senior Assistant Attorney General Brian Krakis and Assistant Attorney General Jennifer Hayden.
Thank you. UCA.
Good morning. This is Patrick Wittershine from the Attorney General's Office, representing the Colorado Office of the Utility Consumer Advocate. I'm joined by my co-counsel, Tom Dixon.
Black Hills, Colorado Gas.
Good morning, Commissioners. Emmanuel Koshin, representing Black Hills, Colorado Gas.
Morning. City of Boulder.
Good morning, Commissioners. This is Veronique Van Geem, Assistant City Attorney on behalf of the City of Boulder.
Morning. Colorado Energy Office.
Good morning, Cynthia Vitale, Assistant Attorney General representing the Energy Office.
Climax.
Good morning, Richard Fanyo on behalf of Climax Mogodudu Company.
Constellation.
Morning, this is Alex Judd from Dwayne Morris on behalf of Constellation New Energy Gas Division, LLC, with my colleagues Anna Rendell Baker and Tiffany Alberti.
Welcome, City and County of Denver.
Good morning. This is Annalise Kuzi representing the City and County of Denver.
Good morning, Energy Outreach Colorado.
Good morning, Chair Gabriela Stockmeyer of the law firm of Dietz and Davis on behalf of Energy Outreach Colorado. And I'm also entering the appearance of Rebecca Townsend from my firm.
Welcome, IBEW.
Good morning, Mr. Chairman and Commissioners. Francis Concilia on behalf of IBEW Local 111.
City of Pueblo.
Morning, Mr. Chairman, Commissioners. Mark Davis of the law firm Fairfield and Woods, appearing on behalf of the City of Pueblo.
Wood River Energy.
Good morning, Your Honor. Brandon Dittman of Wilson Spellman Dittman, representing Wood River Energy.
And Western Resource Advocates and Sierra Club.
Good morning, Commissioners. Victoria Mandel representing WRA, and I'm also entering the appearance of Jim Dennison with the Sierra Club.
Welcome. And Commission Counsel.
Good morning. I'm Assistant Attorney General Wendy Rosati, Commission Counsel. I'm joined by my colleague, Assistant Attorney General Alex Peters.
Thank you. Did I miss anyone? All right, with that, we'll turn to electronic exhibits. A spreadsheet marked as hearing exhibit 1700 lists the latest versions of the pre-filed and settlement testimony and attachments. With that, any objection to the omission of hearing exhibit 1700, the spreadsheet listing all the exhibits? We'll get to the hearing exhibits in a second, but exhibit 1700, Mr. Mansholt.
No objection.
Anyone else? Hearing none, hearing exhibit 1700 is admitted. Any objections to admitting all the items listed on hearing exhibit 1700? And we'll get to exceptions to that in a second, but any objection to all the exhibits on hearing exhibit 1700? Mr. Mansholt.
No objection.
Anyone else? Hearing none, the pre-filed exhibits listed on hearing exhibit 1700 are admitted. I'll call witnesses today in the order listed on the cross-examination matrix. And I understand Constellation witness Michael Russo will not be available today. We'll go through commissioner questions in a second. But are there any other updates to the witness matrix at this time, Mr. Manchel?
After we have an opportunity to discuss if there's any excusals, the company may need a little bit of time just to ensure over today and tomorrow for a couple certain witnesses what day they really have a preference for being on the stand. So maybe even after we go through excusals and go through the testimony of company witness Mr. Piquet, we could follow up with our own company witnesses if we do have any constraints we're projecting for today.
Okay. Yeah, no worries. Mr. Judd, anything to add?
Yep, just to add to that, as you noted, our company witness, Michael Russo, is unavailable today. As a result, and we did make this known, we would like to do our cross-examination of the company's witnesses tomorrow as well, so as not to prejudice Mr. Russo. We would like him to be able to hear the responses from the company as well. So that would be our preference.
That's news to me. So you think, Ms. Rosati, I think Mr. Russo may need to just read the hearing transcript or listen to the tapes. Any advice? We're going to do commissioner questions of Mr. Piquet and then call Mr. Piquet back.
Yes, the YouTube recording should be available for this. And I don't think, I mean, timing wise, I don't know how much time we would use today without Constellation Cross.
Did you know? I was not aware of this request. Were you, Ms. Rosati?
I was not. I'm checking the notifications now in the proceeding, but perhaps Mr. Manchel has something to add.
Mr. Manchel?
I don't recall that being a specific request by Constellation, and we would generally oppose that. We would not want to go through our witnesses and then bring them up again tomorrow, that ones have already been gone through the commissioner questioning process.
Which ones are expected to be questions today by the commission, Mr. Piquet?
Well, I mean, certainly, Mr. Piquet, we haven't gone through that yet, but you're the only one who has scheduled cross. So I think the expectation, certainly my expectation, was we'd start out first thing this morning. Then we'd go down through the witness list with commissioner questions. Then you would get to Ms. Lee and Mr. Freitas. And the hope was we could finish the company today, depending on commissioner questions, and then start with Mr. Russo tomorrow and conclude the hearing tomorrow.
Yep. Obviously, you've heard a request, and we're just not sure when the YouTube video would be up. And of course, to make Mr. Russo have to watch it overnight before tomorrow's hearing would not be ideal. So, again, we weren't consulted for this particular day to start the hearing. Everyone was aware of our witnesses' unavailability. And we thought there might be additional commission items to take care of today and then focus on Constellation's cross and the cross of our witness tomorrow. So that would be the standing request.
Yeah. Does somebody have a hand up? Is that you, Ms. Federico?
Yes, I was just going to let Mr. Judd and you, Commissioner, and Ms. Rosati know the YouTube video and, audio and everything. It's simultaneous. So it's up right now and you can rewind at any time and it stays up permanently. So it's available as soon as it starts, which it started at 8:30.
I think with that, Well, we'll hold your request in abeyance. Let's see what the commissioner questions are. But I think you're going to have to take this hearing as you find it, Mr. Judd. Let's go through the witness list and see where we're at with commissioner questions. Commissioner Plant, questions for Mr. Gardner?
No.
Commissioner Gilman, questions for Mr. Gardner?
Yes, I do.
So, Mr. Gardner, Ms. Commissioner Plant, questions for Ms. Famugio?
No, I do not.
Commissioner Gilman?
No.
Questions for Mr. Kanoy, Commissioner Plant?
No.
Commissioner Gilman?
No.
Questions for Mr. Copier, Mr. Commissioner Plant?
No.
Commissioner Gilman?
No.
Mr. May, Commissioner Plant?
No.
Commissioner Gilman?
No.
Mr. Wollahan?
No.
Commissioner Gilman?
No.
I have questions for Mr. Wenner. I've just a handful for Ms. Buckley. She does not have to listen to the rest of the transcripts. My questions for her will be standalone. Well, let me check with you guys. Do you have questions for
No.
Commissioner Gilman? Commissioner Gilman, questions for Ms. Buckley?
No.
Questions for Mr. Mueller? Commissioner Plant?
No.
Commissioner Gilman?
Yes.
Questions for Mr. Watson, Commissioner Plant?
No.
Commissioner Gilman?
I don't anticipate it. I feel like there was a decent amount of overlap of topics between Mr. Watson and Mr. Mueller. So I'm really hoping that I get through it with Mr. Mueller. In the case he refers me to Mr. Watson is the only case. And I think there's enough overlap there that I expect Mr. Mueller will cover it.
Okay. Mr. Dietenberger, Commissioner Plant?
No.
Commissioner Gilman?
No.
I have questions for Ms. Howard. Good enough, Commissioner Plant?
No.
Commissioner Gilman?
No.
Lovely. Commissioner
No.
Plant? Commissioner Gilman?
No.
Schweller? Commissioner Plant?
No.
Commissioner Gilman?
No.
Doyle?
No.
No.
Allison?
No.
No.
Scrub?
No.
No.
Lee?
No.
No.
Lingeman?
No.
No.
Thompson?
No.
Freitas has what?
Sorry, I don't anticipate Thompson. I do have a couple pretty broad questions on rate design. I think they're more policy focused, so I'm assuming Mr. Piquet can answer, and I won't need Thompson. But just wanted to notify you.
But maybe.
The type of question, I'm hoping Mr. Piquet can handle it.
Okay. Let's keep going. Staff witness Lay. Commissioner Plant?
No.
Commissioner Gilman?
No.
Hagland and Rivera Lugo, I have a couple questions for. They're largely standalone. Dr. Depew, Commissioner Plant?
No.
Commissioner Gilman?
No.
Ms. Marcella?
No.
No.
I have questions for Ms. Anstey. Mr. Skluzak, Commissioner Plant?
No.
Commissioner
No.
Gilman? I have a couple questions for Mr. Fernandez. Mr. Watkins, Commissioner Plant?
No.
Commissioner Gilman?
Let me just look. No.
Did the chair freeze?
Is chair blank freezing?
Can you, uh,
You're back up now, Mr. Chairman, if you want to unmute.
We don't have you on phone audio.
can you hear me?
Yep.
Yeah.
We
Questions
lost
for,
Dr. Watkins, I think.
yeah, do you have questions for Watkins?
No.
I have a couple questions for England. Questions for Kuykendall?
No.
No.
Futterman?
Nope.
No.
Lehrman?
No.
No.
Otteson?
No.
No.
Bagetta?
No.
I do.
Nussbaumer?
No.
No.
I have a couple questions for Bennett. Mayor Graham?
No.
No.
Krottenmacher?
No.
No.
Nope.
Hopkins?
I do as of right now, but I'll update you at lunch if that changes.
Okay. And I have questions for Kenny. So I think witnesses can be excused with consistent with that discussion. I think, Mr. Judd, I think we're going to start probably in a few minutes with your cross-examination, and with apologies, we could start 30 minutes later tomorrow morning or an hour later if that helped your witness prepare for his cross-examination. But I think we're going to get started with a cross-examination in the witness list this morning. So would it help to get a little extra time tomorrow morning?
To be honest, I don't think the little extra time would solve the concern that I had. So no, that's fine. I appreciate the commendation, but yeah.
All right. And
concern is there.
if Ms. Federico, if you could just confirm and work with counsel to make sure that the recording is available, that'd be great. We appreciate it.
It's going right now. I've played it back. It's going.
Okay, cool.
Chairman, I have one more issue.
Yep.
I was anticipating asking, I think it would be Mr. Bouquet, a few confidential questions on the prohibited expenses. I believe he's the witness who can support that at this point. If I'm wrong, Mr. Mansholt, let me know. I don't think it would be more than like 10 minutes of confidential. I just wanted to notify you that so you could plan the timing accordingly.
Okay. So we'll see where we're at, but we'll do it after the first break or before lunch or after lunch. But appreciate the heads up. Yeah, Ms. Federico.
I'm so sorry. I just wanted to let you know the confidential session will not be on YouTube and is not recorded. It's only transcribed by the court reporter. I don't know if Constellation is able to hear those questions, but if they are, those will not be available on YouTube and those are not recorded.
Yeah, I'm not so worried about that. It sounds like Commissioner Gomez's questions are on
Yeah, they're all
prohibited.
pertaining to the prohibited expenses with regard to Senate Bill 291. So I don't think they're entirely relevant to Mr. Judd's issue, but if so, I'm happy to modify, but I don't think they'll.
I just wanted to make sure everyone was aware, so we
Yeah.
wouldn't start tomorrow and
Well,
people
appreciate
asking
it.
why a chunk is missing. So.
Yeah, thank you.
Mr. Judd, any concerns?
Not
No.
with that. Thanks.
Yeah, I figured. I do have one preliminary matter, but any other preliminary matters on the evidentiary record or anything else before we call our first witness, Mr. Manchell?
Yes, there are some exhibits that the parties, I believe, don't have concerns as stipulating to into the record. I know Constellation has some that I'll let Mr. Judd address, but on behalf of public service, we have two in particular that we'd like to address. The first one, and this is located in our box.com, is Rev 2 of the settlement agreement. We filed this in the proceeding on July 23, but that was after the time for being posted on hearing exhibit 1700. So we'd seek to enter into the record through box.com, hearing exhibit 150, the settlement agreement, Rev 2. Additionally, we have a correction that we identified through direct testimony, which is hearing exhibit
Just
116.
One second on the settlement agreement.
Sure.
Did that change page numbers or is it just a textual thing?
It's just a minor textual thing.
Okay.
Just it changes a couple months reference
Okay.
only. No other changes to page numbers or paragraphs or anything else.
All right. I'm just worried if I start asking questions, I'm going to be scrambling.
I understand.
So let's see if there's any objections to the revised settlement agreement. Hearing none, so admitted. Commissioner Gilman.
I was just curious, like, Mr. Manchell, if you could give us any idea what dates change. Sometimes it takes a little while for those uploaded documents to work their way to us. So I was just kind of curious what type of dates changed.
Right. What kind of dates change? Is that what your question?
Yeah, I
Commissioner?
mean, that's the revision.
Yes.
The dates change?
Yes, in the revision of the settlement agreement, in the telemetry requirements section of the settlement, which is further in the bottom end of the settlement, and I can give you exact page reference. There's a change to the timing of the reduction of index pricing applicable to backup sales rate, and it changes the month's reference. And let me just give you the specific reference here. It's on page 30. And what it changes is the reference that was December through February changes to March through November. So the settlement agreement incorrectly referenced winter months when it was the intent was non-winter months to address the reduction of the index price 1, which is one of the relief terms for shippers that's addressed in the settlement. This is all in paragraph 71. I'll note that there are other red lines in the settlement agreement, but those were existing red lines from the first version of the revised settlement agreement, Rev 1. So the only change in Rev 2 is just the month's reference on page 30, changing it to the non-winter months.
Okay, thank you so much. Just want to make sure before I started my questions, I had a good idea what was in that revision.
And Mr. Judd, I assume you're aware of this change and have the modified document.
Yes, I have the modified document, and Mr. Russo will make updated corrections to his settlement testimony tomorrow as a result as well.
Okay. What was the second exhibit?
The second one deals with a correction to direct testimony for our company witness, Mr. Ferrugia. This is hearing exhibit 116, and it's now Rev 2. And the corrections there, we had some numerical errors that we, at the first time, tried to correct in Rev 1, but in prepping for hearing, we noticed that some of those were incorrect. And so we reverted some of the numbers back to what was originally stated. Apologies for the small corrections there on just some of the accuracy of our numerical values. It does not change the substance of any of the company's proposals or the settlement. But for accuracy, we wanted to reflect the actual corrections into the record. And we're raising this one only because Mr. Ferrugia appears that he is being released from the hearing. And so we would seek to enter those revisions into the record now as opposed to putting him on the stand to explain them, unless that's your preference.
That is not my preference. Any objection? Have the parties seen this? And
The parties have not seen this, so we're
Yeah,
certainly
can you-
welcome for them to review it if they, and
Yeah,
subject
can
to their
you-
review.
Yeah, can you just run it by the parties and make sure there's no objections?
Absolutely.
Any other preliminary matters, Mr. Mansholt?
Not from the company. We have one more correction, but we'll address that when Mr. Piquet takes the stand. Thank you.
All right, and if you can bounce it off the other parties, that'd be great. Ms. Consilia.
Your Honor, IBEW was a party to the settlement, and we have no witnesses and no cross-examination, and therefore we would like to be excused from attending the hearing. But I do listen in because I find the commissioner questions enlightening.
Of course. Thank you, Ms. Consilia. Mr. Wittershine.
Thank you, Mr. Chair. Thank you for the updates on witness excusals. I have one update for Dr. England's availability. He's unavailable to testify from 12 to 1 today and after 4:45. So hopefully that shouldn't be a problem, but we appreciate your accommodation.
I expect he will be on tomorrow.
Sometime tomorrow. Okay.
Yeah. So
Thank you.
we'll work around that.
Thanks.
Ms. Cusey.
Good morning. I would like to note that Mr. Vincent Fugetta, who had been called for questioning, he has withdrawn as a witness because he is no longer working for the city of Denver. So I just wanted to note that we have another witness who is adopting the pre-written testimony of Mr. Fugetta. He's here today if we need to go through that adoption, but his availability for questioning Mr. Shays, he's not available until tomorrow after 1 p.m. or Wednesday afternoon.
Okay. So let me just make a note. And I
I
was
think was that just me?
yeah.
Yes.
Okay.
So well,
I may be able to avoid it. So I think ideally I'll take a look at that by when we return from lunch today, but I could probably avoid the questions for your witness.
Okay, perfect.
we'll accommodate Mr. Shea, and my apologies. I was made aware of the switch in witnesses, but lost it. So thank you.
Oh, no worries. Thank you.
Yep, Mr. Koshin.
Black Hills does not intend to call or cross-examine any witnesses, and I would respectfully request to be excused from this hearing.
Of course. Thank you, sir. Mr. Judd.
Yeah, hi again. Just to mention, two of the company's witnesses, Megan Scheller, and Daniel Kanoy, if the witnesses we've requested cross to point to them are unable and need to essentially have us call those two witnesses. I just wanted to let you know. We hope not to and don't believe we do, but we obviously can't anticipate what the responses were. And since I did not hear any of the commissioners had questions for them, I just wanted to make a note of that.
So understood. And to the extent it's other witnesses that get referred, we would expect the company to make those witnesses available. So
thank you.
Mr. Dittman.
Thank you, Chairman. Like Black Hills and IBEW, we don't intend to call any witnesses or cross-examine any witnesses. We do intend to monitor the proceeding, but we ask respectfully to be excused.
Of course.
Thank you,
sir. I have one more preliminary matter, but anything else from council before we jump into the first witness?
As Mr. Mansholt said, we do have some stipulated exhibits. I have one request for administrative notice, but we can do that right before the first witness is called if you'd like.
Has Mr. Mansholt seen the exhibits?
He has, and he's stipulated to admitting these into the record.
All right. And have the rest of the party seen them?
Yes, we circulated them around.
Okay. Yeah, if you just want to list the exhibits, if it's stipulated, I don't know if there's any need for an extensive description, but go ahead, Mr. Judd.
Sure. And these are in the box.com folder as well. They're hearing exhibits 305 through 308, 310 through 311, 313 through 316, 318 through 319, 331, 337, 339 through 342, 345 through 347, 350, 358 through 360, 375 through 388, and 391. And they are all responses that the company provided to our discovery.
Okay. Mr. Mansholt, any objections to those exhibits being admitted?
Yeah, the company has worked with Constellation on these issues. I don't think we have any concerns, but if we could just check in box.com just to make sure that we got our numbers right. There's just quite a few of them, so we can double check quickly the box.com references, but I don't expect there to be any concerns.
So let's admit it, subject to council working with our team to make sure we're all on the same page as hearing exhibits, but admitted subject to that check.
Thank you very much. And there's one additional exhibit, not stipulated to, but that I believe you can take administrative notice of, which is the company's gas purchase plan for 2026 to 2027. This is the company's own gas purchase plan filed, and I can give you the docket if you'd like, but it was filed in June of this year and completed, deemed completed by the commission as well. And we would like to use it in our as an exhibit in our cross-examination and move that be admitted.
I need the number, Mr. Judd. I need the number, Mr. Judd.
Yeah,
389.
389. And I mean, Mr. Mansholt, should we wait until the witness cross to admit that?
That is the company's position. We oppose the stipulation on that matter.
Okay, so let's when you're doing your cross, Mr. Judd, establish a foundation with a witness, and we'll make a decision and admit it to evidence at that time based on that foundation.
Yeah, although it's self-executing because it was filed publicly in a docket, so I'm not sure we need to establish any grounds there. It's a public document filed before the commission.
I understand, but right now that's based on your assertion. Let's just let the process play out on that one, if that's all right.
Of course.
Any other preliminary matters? All right, I did have one thing. I'm intending to use hearing exhibit 1705. It's a short analysis of publicly available information drawn from PUC proceedings and government websites as a demonstrative exhibit for discussion purposes on disconnect and bill assistant issues. As such, I'm not planning on admitting it, nor am I intending to rely on it in our decision in this case. It's just intended to facilitate a conversation with several witnesses, including potentially Ms. Howard, Ms. Anstey, and Mr. Bennett. Given this, I'd like to ask Ms. Federico to add 1705, hearing exhibit 1705, to the shared hearing folder in box. And if those three witnesses get a chance to take a quick look at this before they appear, it might help speed things up. So with that, Anything else before we call our first witness, Mr. Mitchell?
Two minor things. One is that I'm going to switch to our next council, so we'll need just 1 second to change our audio.
Yeah.
And number two is with the release that we appreciate of so many witnesses. It looks like the second witness up would be company witness Mr. Todd Werner. We're just going to confirm internally his availability.
Just to be clear, Gardner.
Oh, I'm sorry, Gardner is a second.
Yeah.
Apologies. And then the third
No,
one.
and then Lee.
Oh, okay. Sorry, it looks like we got crossed on our own internal notes. I guess I would just restate my initial impressions that after Mr. Piquet, we'll follow up on the complete availability at one time.
Yeah,
for comprehensive
and
review.
don't worry, if we need to take Mr. Wenner when he's available, we'll work around his schedule, assuming he has got some availability today or tomorrow.
Yes.
I think there's a decent chance we're going to finish this hearing tomorrow.
That's great news. Thank you, Chair.
We'll see. Yeah, and if it could be after Bulkley or Mueller or Howard, so whatever works, we'll work. We'll accommodate his schedule. If the company would like to switch counsel. Mr. Piquet, you out there? I'll swear you in while we're waiting for counsel. Can you hold up your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Put your hand down. Is anybody with you or communicating with you in any way?
No.
If that changes, will you let us know?
I will.
All right, let's wait for Excel counsel. Ms. Brahma, back to you.
Good morning, Chair Blank, Commissioners. Can you hear me okay?
We can.
No.
No, we can hear you. Oh, you can't hear us.
Is that working?
I can hear you. Mr. Manchel, can Ms. Brahma not hear me?
I can hear you now. Can you hear
Okay.
me?
Yes.
Apologies. It's never smooth sailing.
I know. My internet always seems to go out like 5 minutes before 9.
I know it's the switch. I apologize, but thank you for your patience. Good morning, Mr. Piquet. I know you've been sworn in. Do you want to just fully state your name and who you work for and what position for the record, please?
Yes, my name is Jason Piquet. The last name is Peuquet, and I'm the Regional Vice President for Rates and Regulatory for Public Service Company of Colorado.
Thank you. And did you cause to be submitted into this record direct, supplemental, direct, rebuttal, and settlement testimony?
Yes, that's correct.
And do you have any corrections to your settlement testimony hearing Exhibit 150 today?
Yes, there might be a similar months change as we walked through earlier, if I'm recalling correctly.
Yes. If we could please, Ms. Federico, bring up the company's hearing Exhibit 150 Rev 2 from Box.com.
Yes, give me just a second. All of the exhibits from Constellation kind of froze my screen, so give me a second.
And I apologize, it would be 151. 150 is the settlement, 151 is Mr. Piquet's settlement testimony.
So that's what's frozen. Give me a second. I can get it a better way. Just take me a little longer.
And let me ask you, have you made this available to the parties?
We have, Chair Blank, and we've also filed a notice of this change with the change to the settlement on July, I believe, 23rd.
All right, let me just ask, do the parties have any objection to the admission of this exhibit, Mr. John?
This is Exhibit 151?
Yeah.
Nope, no objection.
All right, I think we can just assume it's admitted, and we'll, if there's any concerns, we'll pull it up and go through it one by one. But I think it's okay to keep going while Ms. Federico processes all those exhibits.
Okay, and just for clarity of the record, because I misspoke earlier, be hearing Exhibit 151, the settlement testimony of Jason Piquet, Rev 1, and the changes are on pages 51 and 52. They are mirroring the change to the settlement that Mr. Manshall identified earlier.
All right.
So with that, Mr. Piquet, I believe, is available for cross-examination.
Mr. Judd, it's 9:40 and we got an hour and a half reserved, and we may take a break maybe 2/3 of the way through. So if to give the court reporter a rest. So if you have a natural breaking point, you may let us know, but you're up, sir.
Sure. Thank you very much. Good morning, Mr. Piquet. How are you?
Good morning. Doing well. How are you?
Good. If you can't hear me at any time, just raise your hand and let me know. Same for you, counselor. So you already provided your name and your title. Did you also file the settlement testimony in this proceeding as hearing Exhibit 151?
Yes, that's correct.
And you signed the settlement agreement on behalf of the company, is that correct?
Yes.
You were personally involved in the negotiation of the settlement agreement telemetry provisions in Section 3R, is that correct?
Yes.
And you have characterized the telemetry provisions as just and reasonable compromises, correct?
Yes, in my settlement testimony, that's correct.
And you are asking the commission to approve those provisions without modifications other than the corrections we heard today, is that correct?
Yes, without further modification.
Mr. Piquet, under the settlement, the company convenes a stakeholder process to explore telemetry modernization. Is that correct?
Yes, resulting in a filing within 12 months.
Okay. And the company retains the right to oppose any modification proposals that come out of that stakeholder process. Is that correct?
Well, there'd be a filing at the end of it, so something will be proposed at the end of the day. The company recognized in its rebuttal testimony that some modifications are warranted to those parts of its tariff, but not before we work through it as a group.
It is possible that in your filing you would note that you object to certain other parties' positions and nevertheless create a proposal for you to file before the commission for approval.
If your question is right, Counselor, if your question is whether all parties will agree with the company's proposal in 12 months, they might agree, they might not agree. It's a little too early to tell.
And you as the company could oppose other stakeholder parties' proposals for modernization as part of that process, correct?
As part of the stakeholder process or as part of the filing?
Correct. Both. You could note differences between the parties, and nevertheless, you would be required to make a filing, and you could note those differences in the filing. Isn't that correct?
That's correct.
In other words, the filing made at the end of the process does not need to be unanimous or have complete consent.
It does not need to be unanimous, but just like any stakeholder process, the company works to incorporate all the feedback it receives, and it doesn't have a monopoly on good ideas. We try to incorporate things that make sense and are cost effective for customers at the end of the day. So it's a little too early to tell how that will all shake out.
But the settlement does create a process where the company can study the issue and then disagree with the stakeholders on the ultimate outcome. Isn't that true?
It's possible that we would disagree with a stakeholder or two. I find it a little hard to believe that we would disagree with all parties involved in the process, but it's all a potential outcome.
Okay, let's move on beyond this. Are there binding milestones or deadlines with the stakeholder process itself? For instance, are there requirements that certain evaluations be completed by certain dates in the settlement?
I don't believe so.
If the stakeholder process provides or produces no consensus, what happens to transportation customers under the settlement?
Well, the settlement still contemplates the company bringing forward a filing in 12 months. So a proposal will be brought forward. It's unclear what that proposal will be and who will support it, oppose it, or take no position.
Are you aware that the 2019 rate case settlement, the parties agreed to a stakeholder process to evaluate and identify an operational or other alternatives to the requirements of telemetry for small volume transportation customers?
Yes, at a high level.
Are you aware that nearly 7 years later, no alternative has been implemented?
I can't say for certain whether our tariffs on this matter have changed since that 2019 rate case or not.
Give me 1 minute. So if you can pull up hearing exhibit 347, Miss Federico, that's going to be Constellation's response 3-13. And can you just scroll down to, apologies, I'm doing this on my phone, so let me just look at the shared screen. Can you go down to the second page of that? And this is the response. Mr. PK, can you just read the response to E of this exhibit?
Response E here says the company has not sought to deploy the alternate communications equipment discussed in this request and therefore has not sought cost recovery to witness Kanoi's knowledge. I'll just note that I'm not witness Kanoi, but that's what it says.
So based on this response, do you think it's fair to say that it is the company's position no advanced metering technology has been deployed in the last 7 years since that stakeholder meeting?
Well, this is just saying that we haven't deployed alternate communications equipment. It's not referring to a specific time period, so I'm not quite sure.
I guess the question to ask differently is, what is different about this stakeholder process that gives you confidence it will produce a different result than the last stakeholder process in 2019, and the fact that you just read the company has not deployed an alternative communications equipment to date?
I'm not aware of any binding requirements coming out of the previous process. Here, we are coming forward with a filing in 12 months. We talked in rebuttal testimony about how some of these requirements could reasonably change moving forward, and we want to do so in a thoughtful way that gives us time to think through all those trade-offs and considerations. So this feels very different to me.
Has the company identified any specific technology it intends to evaluate in this new stakeholder process?
I'm not the technology expert on that subject, so I'm sorry, I can't answer that.
Who would be?
Mr. Kanoi would probably be able to answer that.
But you also just said a minute ago that there's no binding resolution, there's no requirement for consensus, there's no milestones or deadlines. Isn't that correct?
Objection
Well, there is a
mischaracterizes the
deadline.
witness's testimony.
Sorry, what was the objection?
It mischaracterizes the witness's testimony.
If you could just restate your question, Mr. Judd.
I didn't think I needed to go back through it, but does the settlement agreement create any milestones or deadlines other than the final filing?
I'm sorry, Chair Blanket. Am I answering the question, or are we ruling on the objection?
I just asked them to restate the question. If you can answer the question, that'd be great. That question was not subject to any objection.
Gotcha. So sorry, I got confused.
I'll just restate it again, which is the same question I asked previously, but apparently I need to go back through this. Are there binding milestones or deadlines in the stakeholder process itself?
There is a binding deadline of 12 months to bring forward a filing. I'm not aware of other milestones or deadlines before that.
And there's no requirement for consensus among the parties before the filing takes place?
No, there's rarely a requirement for consensus, but it's always something that the company works towards.
And the plan is a plan without any specificity to what that needs to be. So there might be, for instance, a plan for further study or for further analysis. There's no limitations or requirements in the settlement agreement about what that final plan needs to look like, are there?
I would have to review the specific language again before I answer in detail there. So I'm not sure without reviewing that.
Sure, we can pull up the settlement, which is going to be hearing exhibit 150. And let me just find the correct page. Hold on just a minute. This is going to be page 29 of 46. If Ms. Federico, you could just scroll there. Okay. Paragraph 70 outlines the process. Could you please read paragraph 70?
Okay, I've read it.
So I guess my question is, paragraph 70 talks about the requirement to submit a plan. And of course, it's addressing telemetry modernization requirements. But are there any action items that are required in the settlement? Any specificity with what the conclusions are that need to be addressed to roll out technology? Or can the plan talk more generally about what the company is going to propose to do?
I'm going to object that's a multi-part compound question. If we could keep the question to a single one, that would be better, I think, for the record and the witness.
Absolutely. Mr. Piquet, is there any specificity to what the plan needs to include other than the general topics outlined in paragraph 70?
No.
And if you can scroll down to the next page, Ms. Federico, and look at paragraph 72. And Mr. Piquet, if you could just read paragraph 72. And then my question is, the plan that is filed 12 months after the stakeholder process, does there need to be consensus based on the terms of the settlement, or can parties take their own positions?
As we state here, as the settling parties state here in paragraph 72, they're free to take any position regarding those future requirements. So no, there's no binding restraint there.
So based on everything you've just said, what is to make us believe that this process will result in any actionable items, any change in policy that the 2019 stakeholder process did not achieve?
I was not involved in the 2019 or the subsequent stakeholder process referenced. I was a part of that case, granted for a different organization at the time. So I can't speak to what went into that in those intervening years. I am speaking to what is in this settlement agreement here and now. The company and the settling parties have agreed to talk about this issue over the coming year and bring forward a filing. So this feels different to me. I can't recall a specific binding future filing that we agreed to in the past, and we're agreeing to one here in concert with the settling parties.
Mr. BK, are you aware that the company operates approximately 1,300 cellular connections in its SCADA system and has relied upon the cellular process since 2007?
I can't confirm or deny what our SCADA system relies on.
I'm going to pull up an exhibit. Let me just find the right one here. But we'll come back to that question. Let me move on to a different question here. Are you aware that Northern States Power Company, a public service affiliate and owned by Excel, has no backup sales service charges for communication line failures?
I can't confirm or deny how they treat gas transportation issues in their tariff. I do know that they have a gas system. It is much smaller than the company's system here in Colorado. That might factor into any comparison between the two states, but I'm not the expert on that front.
Give me just 1 minute. Let me ask you another question. Are you aware that Northern States Power estimates daily usage until a communication line issues are resolved?
Again, I'm not the expert on what Northern States Power does or doesn't do on its gas tariff.
So who would be the right person to talk to about this then? You mentioned Mr. Connolly for another, or Conoy for another question. Who would be the right person to ask these questions to?
Before you answer, Mr. McKay, I'm going to just state an objection on relevance grounds to the NSPM questions about the NSPM system. It's a very different system, but I just would like to make that known as we go through this question about NSP.
The objection, I mean, Mr. Judd, you can ask your question, but I don't know that I don't know that the company is obligated to provide a witness to answer about NSP. But to the extent they know, they're welcome to, you're welcome to ask, and the witnesses are welcome to answer. I don't think the question is objectionable.
Yeah, so if Ms. Federico, you can pull up hearing exhibit 342. This is the response to Constellation's Discovery 3-8. In the response, it does mention NSP, which is owned by the same parent company. So I guess maybe if Mr. PK is unable to answer, we need to bring Mr. Conoy up to the stand later for some of these additional questions.
Our objection continues to stand. Just because they asked about other affiliates doesn't necessarily make it relevant in this hearing.
Although,
I think that, well, go ahead.
I was just going to say Northern States Power Company is owned by the same parent as Public Service Company of Colorado. Isn't that true, though?
Hold on, let me just the objection's overruled. So you can ask about this if Mr. Piquet doesn't have answers to this. Mr. Kanoy is the sponsoring witness, and you can ask Mr. Kanoy. Back to you, Mr. Why don't you re-ask your question to Mr. Piquet, and we'll take it from there.
Sure, appreciate that. So, Mr. Piquet, are you aware that Northern States Power Company, which is a public service company affiliate, has no backup sales service charges for communication line failures?
I can't confirm or deny. Mr. Gardner or Mr. Kanoy could tell you more if they in fact know, but I'm not sure.
And I have just a handful of questions, Commissioner, on this. So I would say, given this and an earlier response by Mr. Piquet to maybe just for the efficiency here, we can skip over this. And if I can just have a few minutes with Mr. Kanoy later, that'd be great.
Yeah. Ms. Brown, can you make Mr. Kanoy available?
We certainly can.
Thanks.
All right, I will move on to a different set of questions. Mr. Piquet, are you aware that Public Service Company collected approximately 3.7 million annually in recent years and 9.7 million from about 2020 to 25 in revenue related to communication line failure, including trip charges and backup sales revenue?
I believe those were the figures that Constellation supported in their testimony. I'm assuming that came from the company, but that's where I saw those numbers. So I can't confirm or deny, that it's coming straight from, in my mind, coming from Constellation's testimony.
Are you aware that Public Services own tracked costs associated with managing those outages total approximately 4.5 million over the same period?
Yeah. Again, I think those figures were cited in Mr. Russo's testimony regarding the settlement agreement. Presumably that came from company discovery responses, but I can't confirm that number without seeing those responses.
All right. This was also something Mr. Kanoy sponsored in, like you said, discovery responses. So we will ask him that question. That's fine. Let's move on to another topic then. Under the settlement, the cure period increases from 30 days to 90 days. Is that correct?
Yes, the corrective period increases up to 90 days.
After the 90 days, if the phone line is still down due to carrier disconnection, the customer is placed on backup sales service?
Yes.
And the settlement reduces the backup sales commodity charge from 125% to 110% of index price one during the months of March through December. Is that correct?
March through November.
Sorry, March through November. Thank you. Is that correct?
Yes.
During December through through February, the peak heating months of the year, the full 125% penalty still remains. Is that correct?
Yes.
And interruptible transport customers receive no reductions to the backup sales penalty at all under the settlement. Is that correct?
Yes, that's correct.
If a carrier has permanently disconnected copper service in the area, how does a 90-day cure period help a customer whose line will never be restored?
Well, you're getting into the telemetry issues at issue here in this proceeding, in which the stakeholder process will cover. I can't agree to the concept that copper wire is the only solution here. We have other transport customers who are connecting to our system via other routes. So I don't accept the premise of the question.
But isn't the requirement for these particular transport customers to use copper wire in the tariff?
I believe it's more technology neutral than that. I don't think it says copper wire. So no, I don't agree.
If it was copper wire and a carrier has permanently disconnected that copper wire, I would still like an answer to my question. How does the 90-day cure period help a customer whose line will never be restored?
Objection. This mischaracterizes the testimony. Mr. Paquet has already said that's not the case, that it's required to have copper line.
Are there no customers that are required to use copper wire?
I know that there are customers that use landline connections or copper wire to meet the tariff requirements. And there's also transportation customers that don't. So it's my understanding of the tariff that it's not stated that specifically, and that there's options here already for our transport customers. So I disagree with the scenario because it's not a requirement. So it's hard for me to hypothesize, if that is a requirement.
Let me approach this a different way. The POTS, the plain old telephone service, is that the requirement in the tariff?
I don't believe that the transportation tariff calls that out specifically.
Okay, I'm gonna check on that. We'll come back to that in just a minute. But for those customers that are using the plain old telephone service, the copper wire, and the carrier does disconnect or discontinue that copper wire in the area, for those customers, how does a 90-day period help restore a line that can never be restored?
So there's options in that scenario for a customer that is relying on that technology to connect to the company's systems. I don't know if there's other carriers in the area or if that's an option or not. There's also customers that connect via cellular to our system. So there's other options here. To assume that a solution that would be available before 90 days is also available, or sorry, I reverse that. To assume that there's no solution after 90 days, I don't think is a correct assumption. That there are customers using other systems, so therefore there's not just one option available to a transport customer.
I guess I just want to understand what you're saying. You're saying that if a customer is using a landline, a plain old telephone service, copper line, and the line is down and cannot be fixed, that customer should use an alternative path to connect their meter with the company?
If there is no carrier providing service in their area anymore, that copper wire service, then they'd have to pursue an alternative route under the currently envisioned rules. right? I think we've all recognized that we can continue to discuss this over the coming 12 months, leading to a company proposal. I'm not saying that there's not other good ideas or solutions here, but under the company's current tariff, we have it contemplates a remedy. Sorry, the settlement agreement contemplates what that customer has to do. They have 90 days, which is much more time than they have currently. And we also contemplate reduced backup sales service penalties in that scenario as well.
Right. No, I understand. But I guess what I'm saying is your position, if a customer has a landline and the carrier is not restoring or repairing that line, that the customer needs to take an alternative approach to connect to the company's meter?
Well, the status quo is always an option too. They could choose to do nothing. They would face those they would face the trip charges and the higher backup sales service penalties if they exceed their MDQs during the months of December to February.
So, right, I guess I'm just a little surprised to hear this. I had thought the tariff had required certain dial-in requirements for transportation customers. And I guess I'm just wondering, what are the alternatives to a landline for dial-in that are viable at this point?
My understanding of our transportation tariff is that it's not as binding as you were describing. We have
And what would lead you? Oh, sorry, I did not mean to cut you off. Finish your thought.
As I've said a few times here, we have transport customers connecting to our system via alternative routes.
And what are those alternative routes?
Well, Mr. Kanoy could probably tell you more on that front, but I'm aware of some customers having a cellular connection with our system.
This cellular connection, in that case, a workaround for that very specific customer? I just not sure how that would satisfy the tariff requirements.
I'm not sure about that. You'd have to ask Mr. Kanoy.
Okay, we'll ask him about the technology, because I'm not certain of that, given your responses. But I would still like, I guess, a response to the question, which is for those customers, assuming there is no cellular option available to them and no other viable technology that meets the tariff requirements, how does that customer that has a landline and is doing so to connect their meter to the company, if there is a carrier that disconnects service, the plain old telephone service, how is the 90-day grace period in the settlement resolving that customer's issue?
Well, you're assuming that there's not other options on the table. So just being clear about that, right? So if we're assuming that, then what we're contemplating here in the settlement agreement is that we recognize there's a conversation to be had on this front, that it might be difficult for some customers to pursue alternative routes. And so we've got to think about how to do this in cost-effective ways for all customers. So we're happy to have that conversation. We can't do so, however, until we think through that in a thoughtful way. We think the accommodations in the settlement agreement make this easier for transport customers in the interim. But we intend, as the settlement states, to come forward with a plan in 12 months.
All right, so let's talk about the plan for a minute. Under the settlement agreement, the stakeholder process commences in 2027 and must conclude by the end of the year. Is that right?
I think the 12 months would kick off at the rate effective date, is my understanding. So it's a little bit faster than that, but that's generally right.
And the company isn't required under the settlement to submit a modernization plan until 12 months after the effective date. So that's approximately October 2027, I think. Is that correct?
That's my understanding.
Okay. After the plan is filed, there's a commission proceeding to evaluate it, most likely. Is that correct?
Yes, correct.
In 2025, total communication line failures reached around 3,000, which is a five-fold increase from the 500 or so in 2020. Is that correct?
I know that there's been an increase over the past few years. I can't testify to that exact level, but generally it's my understanding that these communication interruptions have been increasing.
Just go ahead, Ms. Federico, if you wouldn't mind, and just pull up hearing Exhibit 308. And just tell me when you can see it, Mr. PK. This, when you can, is going to be a response from the company providing the years and the number of communication line outages.
Yes, I see it here.
Okay, yeah, and this has been stipulated into the record. Can you see year 2020 has 584?
Yes.
And 2025 has a little over 3,000?
Yes.
So based on that, would you agree that there's been a five-fold increase in total communication line outages since from 2020 to 2025?
Yes, with a little bit of variation along the way, but yes, that's right.
And removal events, where the customer is actually placed on backup sales service, grew from 92 or so in 2020 to around 3,000 in 2025. Is that right?
I can't confirm or deny that. You'd have to show me the specific numbers again.
Okay. Based on the trajectory that we talked about just a minute ago from 2020 to 2025, where the outages grew fivefold, do you expect the number of communication line failures to stabilize, increase, or decrease during this stakeholder process period?
During the upcoming 12 months, I can't say if this roughly 3,000 number will increase or decrease. It looks like it could do all three of those just based on what the past couple of years look like. So any of those are possible.
All right, Ms. Federico, can you pull up hearing exhibit 376? Can you just, when it's up on the screen, can you just take a look at this article, please, Mr. PK, from the FCC?
Sure.
Let me know when you're ready to scroll down.
Yeah, I'm just scanning through this. I'm ready. You scroll down, Ms. Federico. Thank you. Okay, I'll scan through it.
So based on this, it would appear that the FCC has noted a increased rollout on modernization for telemetry and a fade of the traditional POTS copper lines. Is that correct?
Yes, that's my understanding of this document.
So based on what you just looked at with the FCC and the federal policies that it discusses, again, would you expect the number of communication line failures to stabilize, increase, or decrease during the stakeholder process when factoring in the maintenance or lack thereof from the article you just took a look at?
Well, I don't know the specific timelines of the carriers providing service here in Colorado. So if those carriers are maintaining those lines for the next few years, I believe this was a spring 2026 notice here, so it's not like this has been out there for a long time. Presumably, it would take some time to effectuate equipment changes across the industry. Then things might not change over the coming 12 months. I can't say.
Okay, can you, Ms. Federico, pull up hearing exhibit 380? And again, if you can just,
Sorry, I didn't hear a number after 3.
oh,
Maybe
three, I'm sorry, 380.
thank you, sorry.
No, my apologies. And once it's up, Mr. PK, if you can just skim through it.
Okay, yeah, just scan through here.
So from this article, it would appear that not just FCC guidance, but the individual carriers are planning to phase out their traditional POTS copper lines. Is that correct?
Yes, but again, I'm not sure on the timelines involved because I'm just seeing AT&T reference a few times, but I'm not sure what other carriers are out there, and I'm not sure the timelines involved.
The timelines for what? Apologies.
For phasing out POTS service.
Okay. Constellation currently has approximately 100 customers with active phone line outages at any given time. Is that correct? Based on the testimony of Constellation.
I can't confirm or deny that. I'd have to see the specifics.
Let's go ahead. Let me tell you. Let me take this a different way. If you haven't taken a look at Constellation's testimony, for the customers who have already been removed from transportation service and placed on backup sales service, does the settlement's 90-day cure period provide any relief at all?
For those customers already on backup sales, I would say two things. One, if they were just recently placed on backup sales and the settlement provision increasing that to 90 days, that could get them back into the transportation pool, is point one. And point two, as we've discussed previously, the reduction in the commodity penalty charges from 125% during the months of December through February to 110%. That's also a benefit in this interim period.
Isn't the 110% still punitive? Isn't there still a penalty associated with the backup sales even at 110%?
It's more than 100%. I agree to that. The company needs to maintain a reliable system. And so we've got to have tariff mechanisms in place to ensure customers are using what they say they're going to use.
Well, it's 110%, but of what? 110% of what is the base?
The index price.
The index one price. And what is that based off of?
Ooh, you're going into gas supply topics that I might not be the expert on.
Would that also be Mr.
Question?
Kanoy?
Mr. Gardner or Mr. Kanoy might be able to tell you more about our purchases of gas and what it's indexed off of. But they might not be able to as well. That's a commercial operations question, I think.
Are there any provisions in the settlement that reinstate rather customers who have already been removed from transportation service due to communication line failures?
Well, as I talked about a moment ago, the change to 90 days might help some of those customers. And it's important to point out that this is just an interim period that will bring forward a plan that we hope brings forth some cost-effective and prudent changes here to the company's requirements.
Ms. Federico, can you bring up hearing exhibit 301 and go to page 7, I believe?
Yeah, just let me give me a second to scroll down there on the spreadsheet. Sorry, I accidentally clicked 300. 1 second.
You're okay. Yep, and actually scroll back. It starts at the end of the last page. So this, Mr. PK, is Constellation's testimony. And I just wanted you to take a look at this last paragraph down to the next page, the top of the next page, where it talks about the average outage duration that Constellation is reporting. And if you can just confirm that you see the average outage duration is 344 days.
I see that.
Okay, and that's more than 90 days.
Yes.
So once again, for those customers for which the 90-day grace period has no effect, which you've just read and confirmed that you see Constellation's reported 344 days is the average, other than what you described as the 12-month settlement stakeholder process, is there any solution for these customers that are currently experiencing at or above the average outage to pay anything other than backup sales?
I think this underscores what the settlement contemplates, which is we've all got to talk about this more. The company recognizes there could be solutions put into place that are good for our transport customers and good for all other customers, and we've got to work through that thoughtfully and carefully. And so I think in 12 months we'll have a good plan for that.
But what's your answer for the customer at, let's take the average 344 days without a solution? What's your answer for that customer who cannot be reinstated because they're beyond the 90-day grace period? Is your answer for them they have to wait for a solution in the stakeholder process?
Objection. Compound question and argumentative, and Mr. Piquet's already testified that they have options.
I didn't hear him say they had options. What options do they have, Mr. Piquet?
As we've talked about a few times this morning, using the plain old telephone service is not the only option that our transport customers have to connect to our system. We have other customers who use different requirements, who have different technology connections. That includes cellular, and I think there's some other routes there that other company witnesses could tell you more about. So I disagree with the premise that there's no solution for a customer that currently has their copper wire service interrupted by their carrier.
I just want to make sure I heard you. Your solution is for those customers to use a cellular solution?
Not necessarily cellular, but they could pursue another route to connect to the company system. And to the extent that we need to explore other modifications to our gas tariff, that's what we're agreeing to here over the next 12 months.
And just to confirm, other than cellular, you don't know what those technology solutions are. You, I think, referred me to Mr. Konoy maybe for more information on technology.
That's correct. Mr. Konoy can certainly tell you more.
Okay, so these customers, from where we sit today, you're just not sure, other than cellular, what solution they might have other than remaining on backup sales service. Is that correct?
Yes, that's correct. And Mr. Konoy can tell you more.
Some of these customers are large industrial, commercial businesses that contracted for competitive gas supply with price certainty. They're now involuntarily paying a 25% premium on the highest weekly index price. That's what the index price one is, with no path back to their negotiated supply contracts. Is that true?
I'm sorry, could you restate the question?
Yeah, of course. The large commercial industrial business customers that contracted for competitive gas supply, specifically for price certainty, they're now involuntarily paying today. They're paying involuntarily a 25% premium on the highest weekly index price with no path back to their negotiated supply contract. Is that true?
Objection asked and answered as to what they're paying, and Mr. Judd has not put into the record or established what is the highest price.
What the highest price is the tariff. That is the tariffed language from the company. That is what price one, the index one price is.
My objection is first of all that what the tariff says, Mr. Piquet has already answered questions about that. And second is Mr. Judd's assertion that index price one is the maximum price, and he's not established that yet. So those are my two.
If you could rephrase your question, that'd be great, Mr. Judd.
Mr. Piquet, do you know what the index one price is?
I'm not sure what it specifically refers to compared to other index references in the company's tariff. Miss Lee might be able to tell you more on that front.
Does the settlement include any cap, thresholds, circuit breaker that triggers immediate action if the number of customers harmed exceeds a certain level during the stakeholder process?
You're referring to transport customers specifically?
Correct. If it reaches a certain number of customers, a certain thresholds on backup sales service, is there any kind of trigger, or can customers continue to be put on backup sales service during the settlement, during the stakeholder process?
There's not additional restraints or provisions beyond what we had walked through previously in the settlement agreement. So no.
Let me ask it a slightly different way. If outages double again in 2026, maybe double again in 2027, hundreds of additional customers are removed from their transportation service to put on this backup sales service. There's nothing in the settlement agreement that would accelerate or require immediate action in the interim before that 12-month plan is finalized. Is that correct?
That's correct. And you're making an assumption there, just to be clear. We don't know if there will be the same number, more or less communication interruptions in this 12-month period. But we hope that the solution that we do bring forward, hopefully with some consensus behind it, resolves these issues moving forward.
Mr. Piquet, would you agree that rates must be just and reasonable as applied to all customers, including those customers currently being harmed on the backup sales service, not just in theory at some future date?
Rates must be just and reasonable for all customers, including non-transport customers that need to rely on a safe and reliable system that also provides service to the transport customers.
Sorry, I just want to make sure I heard you said just and reasonable for the non-transport customers?
For all customers, and in particular, non-transport customers who don't control, when and where they bring supply onto the system. They're taking sales service from the company, and the company manages all of that.
How is it just and reasonable to require a customer to pay 125% of the commodity penalty for years because their telephone carrier retired their landline. How is that just and reasonable?
Objection assumes facts, not in evidence.
Overruled. You can answer, Mr. Piquet.
It's incumbent on the company to provide safe and reliable service to every customer that asks for service, whether or not that's firm sales, transport, interruptible service, all the above. And so if there's a situation in which we're not sure how much a certain customer is using from our system, we've got to have an incentive in place for them to use the amount that they've scheduled, their maximum daily quantities. And so without it's almost like flying blind at that point, right? We've got to make sure the system is balanced between supply and demand. And so there's an incentive there built into the tariff to not go above those MDQs, or else there's additional charges in place.
So you're saying I just want to make sure I understand the connections here. The 125% is supposed to be a penalty to incent customers to use an amount of gas that you're aware of so it doesn't harm the system?
To use gas efficiently, just like all other customers. Because if we're not able to meter that usage as we were before, then we've got to have incentives in place to use those contracted amounts and to use gas efficiently.
Are you aware of whether the company accounts for forecasted backup sales usage for previous years?
I'm not aware, Mr. Joe.
Do you know if the company's ever solicited bids or proposals regarding alternative communications infrastructure for the transportation customer telemetry?
I'm not aware.
Bear with me just 1 minute. Would you agree that tariff condition is not just and reasonable if compliance isn't possible?
So core to that question is the assumption that compliance is impossible, which I would disagree with here in our conversation about transportation customer requirements.
I guess I'm just asking a more general question. If a condition in a tariff, if compliance with that provision is impossible, is that just and reasonable?
If a customer cannot comply with a provision through any route, it is not by definition unjust and unreasonable, because I don't know about all customers, right? Or we're just talking about one customer in this hypothetical that they're unable to comply with a certain provision. then there are other provisions in place that contemplate that scenario. So yes, that could absolutely be reasonable.
I just want to make sure I heard you correctly. So you're saying that there can be provisions in a tariff that create impossibility of compliance with customers, and those tariff conditions could still be just and reasonable.
If the tariff contemplates remedies if a customer cannot do something, then yes, it's something that's clearly been contemplated already. So it can be just and reasonable. If we're talking about something, more abstractly, right, of all customers across the company's entire system couldn't do something, then that seems like something we should take a look at. That's not the situation we find ourselves here, just to draw us back to what we're debating about in this proceeding. So yes, I think that companies' tariffs are just and reasonable. We contemplate customers connecting to our system with the right communications equipment, and we have provisions to outline what happens if they cannot.
Did, to your knowledge, has the company ever studied whether telemetry requirements are causing customers to leave transportation service?
I have not studied that. I'm not sure what other witnesses could speak to on that front. I do know that the company is neutral between a customer's choice on that front. We don't earn a markup on gas sales. We still charge for the use of the company's system to deliver the gas to our transport customers. And so the company is receiving revenues to compensate for the cost of operating that system. So at the end of the day, we're financially neutral.
Financially neutral to what?
To a customer choosing transport service or sales service.
Right. Although not quite my question, which is just whether you've studied, to your knowledge, the telemetry requirements. And it sounds like you maybe directing that to Mr. Kanoy would be better suited.
I'm sorry, I thought your question was talking about a choice that a customer makes to choose transport service or not. But if your question is about the telecommunications requirements, then yes, Mr. Kanoy can tell you more.
So I think, Mr. Chair, the commissioners, there have been a couple of these questions that Mr. Piquet has been unable to answer and pointed us in large part to Mr. Kanoy. So I would just maybe stop here. I'm not sure quite how much, little bit of time left on the estimate. Maybe we can later on ask some of these questions to Mr. Kanoy, if that would be okay with you.
Yeah, that'd be great. All right, let's take a 15-minute break till 11:05, and we'll come back with, I guess, maybe we'll go first with you, Commissioner Gilman. Do you have questions for Mr. Piquet?
I do, yes. I have public questions, and then I have a handful of confidential questions, which are related to the prohibited expenses issue.
Commissioner Plant, do you have questions for Mr. Piquet?
Yeah, they're all public though.
All right, let's take a 15-minute break now. We'll come back. Commissioner Gilman, maybe you can ask your public questions, and we'll go to Commissioner Plant. I'll ask my questions, and then either before or after lunch, we'll go on a confidential session. So, Ms. Mr. Piquet, we'll see you at 11:05, 15 minutes. Thanks. All right, Commissioner Gilman, you're up, and then we'll go to Commissioner Plant. I'll go, and then we'll do the confidential session.
Chair Blank, before we move to questions, we just have one preliminary matter, if we could address very quickly. I think Chair Blank froze for me. Is that the case for others?
Yes.
My question maybe was for Commissioner Gilman, so maybe I'll just ask if that's okay, which was if the questions for confidential session were confidential or highly confidential, we just want to make sure we have the right list.
Chairman, we need you to mute one or the other of your sources there.
Go ahead. I'm sorry. Go ahead.
Okay. I looked at the prohibited. Chairman, I think your audio's really bad. Sorry. I looked at the prohibited expenses, which was, let me pull it up. It was like attachment JJP 15. That was hearing exhibit 134, JJP 15. I flipped through the highly confidential and the confidential version, and I'll be honest, I couldn't tell the difference. So maybe you can help me understand. It's just certain tabs that, certain tabs in there are public and then certain are not. And I was just not able to decipher what the difference was.
My understanding is the primary difference, and I'll confirm with the folks, others who know in more detail about where the issues are, but my understanding is primarily that there is in the highly confidential individual people, personal information, names, and things like that. That was the primary difference between the highly confidential and the confidential.
Yeah, if confidential gets us titles and not names, I think that's fine. Okay. Yeah, and sorry, I tried to go through and figure out the difference, but I was a little confused. Oh, let me see. Okay, no, I got word. Is it the lobbying labor tab?
I believe so, yes.
So is the oh my gosh, lobbying labor tab without names, just confidential?
That I need to check on. I don't have the different versions open either. I would ask the general question, but I will find out.
We've got some time. Let me know. I think I could avoid individual names if I get titles. So in that case, I think we can stick it to confidential, but let me know what you figure out about what particular information was highly confidential.
I will do that. Thank you. Thanks for the information.
Hey, Commissioner Plant, would you, Commissioner Gilman, it sounds like you may have a decent amount. Would you prefer Commissioner Plant to go first, or?
I think that's fine if he's ready. I don't know how much you've got, Commissioner Plant.
Yeah, I can go first. Let me pull up my notes. Yeah, and I don't think mine will take that long.
All right. Why don't we start with you, Commissioner Plant? And maybe Ms. Brahma, you can see if there's a way to accommodate Commissioner Plant without Commissioner Gilman without going into a confidential session or highly confidential session. That'd be great. Maybe Mr. Piquet can have the spreadsheet up on his screen, and we could just talk about line numbers in the spreadsheet instead of names. So,
just to clarify, I think it will be confidential, just not highly confidential.
Okay. Go ahead, Commissioner Plant.
Okay, thank you, Mr. Chairman. Good morning, Mr. Piquet. How are you doing?
Oh, you're muted, Mr. Piquet.
Thank you. Good to see you, Commissioner Plant. I'm doing well. How are you?
Good, thank you. So the Commission's GIP decision identified improvements to the MPA cost-benefit framework as sort of an ongoing need. What specific provisions of the settlement improve the analytical framework the Commission will have available when evaluating?
I lost you, Commissioner.
Oh, are you there? Hello?
I'm sorry. I think I lost you there for a second. I can hear you now.
You can hear me now? Okay, I'll start my question over again. Sorry about
Thank you.
that.
Sorry.
We're getting struck with the chair blank disease.
I didn't think it was contagious.
It's
but
contagious,
maybe.
apparently. So the commission's GIP decision identified improvements to the MPA cost benefit framework as an ongoing need. What specific provisions of this settlement improve the analytical framework the commission will have available when evaluating future gas capacity investments?
I think there's a couple considerations here when thinking about future capacity projects in particular, Commissioner Plant. That's what you're focusing on here. So for capacity investments, I'd point to two things. One, the settlement agreement contemplates, right, a whole new regime or feature here of customer requests moving forward, which is the GSIF, or the Gas Capacity Infrastructure Fee. And so now, as contemplated in the settlement, we'll be charging new customers starting in January 2027 a fee based on whether or not they're a residential or commercial customers, kind of sized to their request. And the revenues received from that are essentially an offset against the company's investments on capacity expansion projects. And so we'll have a lot of new information in light of that, right? We'll see, how do customers respond to this new charge? How does system investment respond in light of that? And we'll have to proceed step by step because no one's got a crystal ball, right? We don't know what the impacts are going to be to the company's system or to economic development, or to customer demands generally. And so that's kind of feature one, I would say. Feature two, oh, sorry.
Oh, no, go ahead. Feature two.
I would say the second thing I would point to is the stakeholder process that the settlement contemplates as well. And this is regarding how a future PIM could potentially be structured. And there's a lot of different opinions on that front among some party positions in the record. In particular, in which case, right, we'd have to figure out how such a mechanism could be structured. What's the right target set of investments? What's the right structure? How could this work? Do parties really want this to take effect? And if so, when, right? All these types of questions, I think, target this capacity and new business kind of bucket of investment from the company, which is particularly at issue in the recently concluded GIP proceeding.
Thanks. And did the settling parties evaluate the Colorado Energy Office recommendation for a standardized statewide CBA methodology at all?
So you're right that the settlement doesn't contemplate anything regarding standardized CBAs or not. I'd have to think more about that provision. It's been some time since I saw that from the Energy Office, and I just haven't given it thought in recent weeks. But I'm happy to think about that more, Commissioner Plant.
I understand. Was it not included because, if you can recall, the parties believed it lacked merit, or was it just because it was outside of the scope of the negotiations?
Well, I can't comment on the specific settlement negotiations themselves. I think in the company's rebuttal, we probably, if I recall correctly, I think we might have said that such a provision is better addressed in company GIP proceedings moving forward, and not so much in rate cases like we have before us here. But that's just my recollection.
But it would also, I mean, if we had a CBA, it would inform the GIP, correct? Rather than, discussing it in the next GIP, it would actually inform the next GIP. Isn't that correct?
Right. Yeah, I understand the sequencing there. That's right. I think the challenge is that, to determine something in a case to affect a future case, without the same set of witnesses in that future case as we have before us today, right? Hopefully that made sense. But the issue is just making sure we've got the right folks in the room at the end, and at the end of the day, Commissioner. And I think we've just got a very different set of internal experts in a GIP compared to what we, well, there's some overlap, of course, but there's a different set of experts that help us think through gas capacity planning and non-pipeline alternatives and cost benefit analysis. And we don't have those same individuals here in a gas rate case.
But you agree that overall additional refinement of the CBA methodology is appropriate?
I certainly agree. It's a central theme in our GIPs and other gas related proceedings before the commission. It's something that's got a lot of airtime recently, and something that something the company continues to improve upon and evolve as we come up the learning curve on our new gas planning regimes.
I guess it's part of the, I mean, you brought up the issue of having different parties in different proceedings, but we have different proceedings that inform different proceedings. So it's kind of going to be an ongoing issue, I would imagine.
Yeah, fair point.
So were there any provisions in the settlement that require evaluations of geographically targeted demand management before gas projects are proposed?
Nothing that specifically contemplates that provision, Commissioner Plant. I would note again that seems like a very GIP focused conversation on that. And you were just alluding to this in our discussion a moment ago, right? We have these different proceedings to talk about different elements of our gas system, right? Whether it's cost recovery or future projects or depreciation or what our customer programs will look like. You know, it seems like there could be some use in merging some of these streams in the future. We all probably have ideas on how to do that. But I just wanted to highlight that central fact, right? That this is a backward-looking proceeding we're in now to talk about the things we did over the past 2 years. GIPs talk about things we're doing over the next 6 years. And in a perfect world, you'd kind of align those conversations to say, hey, what are the things we're going to do moving forward? And here are the costs of that. And are we all on board or are we not on board? Instead, we've kind of bifurcated that.
Yeah, I understand. But we could also provide some guidance on sort of approach in the next GIP that would then inform what you're trying to collect in the next gas rate case, I guess, is sort of the
right. Yeah, I think that's the regime that we currently have in place, right? That you have a gas planning, a gas infrastructure proceeding was essentially gas planning that informs the projects we do, which then informs a subsequent rate case to then talk about the things we did. All I'm alluding to is a process where you could potentially merge those. But yes, that is the current regime, that we do incorporate the guidance and GIPs into what we're doing moving forward.
And similar to my last question, was there any evaluation of, for example, smart thermostat demand response, managed heating loads, controllable peak demand resources in the settlement?
Not specifically in the settlement. If your question is a bit broader on, the specific projects that are being brought forward for review here to be added into the company's rate base and thus base rates, if we conducted those evaluations for NPAs or other customer programs, you mentioned kind of targeted demand areas, right? That all valid questions. I would just make 2 points. One, the kind of current regime we have for NPAs, right, coming out of GIPs is kind of a new regime, right? And a lot of these projects coming into service over the past 2 years were initiated, oftentimes years before that, well before we had GIP rules. So that's kind of the first point I would note. The second point is, to the extent we thought about TDAs or other customer incentives in real time, I might point you to other witnesses on the gas projects who could maybe speak to those specifics.
Okay. If the commission approves the settlement as written, is there any reason it couldn't also direct the company staff CEO, interested stakeholders to develop a more robust, standardized MPA cost benefit methodology to use in the next GIP and CPCN proceedings.
Good question. I think that's within the commission's jurisdiction and ability to do so.
Great. Thank you. Those are the only questions I have, Mr. Chairman.
Thank you, Commissioner Plant. Commissioner Goman.
Hi, good morning, Mr. Parquet.
Good morning. Good to see you.
Good to see you too. I have a couple questions first on some of the settlement attachments. It's hearing exhibit 150, attachment 1 and 3. These were kind of generically provided. So I wasn't sure if you were the witness who would best represent these, or if I should ask someone else.
Yeah, happy to go through them. I can't remember which ones those were specifically, but I can answer what I can.
Okay, no worries. Yeah. Let's just bring up attachment 1 first. So that was hearing exhibit 150, which was an attachment, I think, to the settlement agreement itself. Okay, great. And so this shows the net revenue requirement summary. And so I just wanted to get my bearings here. Looking at line 3, so that looks at the total base rate revenue. And we're seeing a change under the settlement in total base rate revenue of 13.5%. Do you see that?
Yes.
Okay. And so that is since the 2024 rate case, in which rates were effective November 2024. Is that accurate?
Yes, that's what current base rates are based off of, was that 2024 rate case with rates effective later that fall. What we're showing here in column A is current revenues from that previous case.
Right. Yep. So
Yes.
column A reflects revenues that were set in the 2024 rate case, which took effect at the very end of 2024, just over a year and a half ago. And then
Correct.
B is the proposed revenue with regard to the settlement agreement.
Correct.
Okay. And so that is a 13.5% increase in that base rate revenue over the course of just over a year and a half between those two.
It'd be about 2 years as of the rate effective date, which is October 6th, I think, in this proceeding in front of us. So at the end of the day, about 2 years.
Okay, gotcha. And I'm curious if you're aware, in that span of time, have sales increased or decreased on the system?
I think that's a good question for Mr. Goodenough. I believe sales have increased a little bit. I know we've had continued customer growth in the intervening 2 years, while use per customer, I believe, is starting to trend down a little bit, but I believe those are pointing in different directions, but I believe the net effect was slightly higher sales after you weather normalize.
Okay. My understanding of the company's 2025 10K was that they saw nearly a 3% decline in sales, weather normalized, from 2024 to 2025.
That might be right. Sorry, I was comparing it to the 2023 test year.
Yeah.
So an additional year in there, but you might be right. I forget the net effect of those two countervailing forces.
Okay. No worries. Can we pull up attachment 3 now? So again, this hearing is exhibit 150. So with regard to the settlement agreement, attachment 3 shows kind of the rate design issues. And so let's see, hopefully this breaks apart by tab. I had the executable open, but I think it's just fine to use this. Can you go to the next page, Ms. Federico? Hopefully, yeah, this is the residential. We can blow it up just a bit. I think the far right doesn't even really have any data, so. There we go. So as we look at this is the rate design for residential customers based on the settlement agreement. Is that right?
Yes.
Okay. And as we look just below that line that goes all the way across the page, can we just shift left just a touch so we can see the words on the left? Great. Okay. So just to get our bearings in this, the class cost of service study results are just below that black line. Do you see that?
Yes.
Okay, so it breaks apart kind of the residential costs incurred to customer related, demand related, and commodity related, right?
Correct.
Okay. And when I look at commodity related on here, just confirm for me, that excludes the actual cost of the commodity that flows through the GCA. Is that right? That's just the cost of the system of base rates that are commodity related?
Yes, that would be my understanding here.
Okay. So as we look at these, we're seeing the largest single driver of cost being that demand related line at 314 million. Do you see that?
Yes.
Okay. And then if we so basically kind of the class cost of service study results that we're seeing here below the line show that if you were to just take the class cost of service study and do it out, it looks like the customer related costs about $15 a month per residential customer. The demand related components cost $18.6 a month. Do you see those?
Yeah.
Okay. And then understandably, like I get, there's a push and pull here to the rate design. You'll see up in green the proposed base rates, which are just over $11 a month per customer, but then far more in the volumetric charge, 0.46 cents instead of the 0.06 cents shown below from the cost of service study. Are you tracking with me?
Yes, the 0.06 from below, I see that. And
Yeah.
sorry, you're comparing that to the 0.46 in
For
the
the actual
proposed
rates
rate?
you want to put into effect.
Correct.
So the actual rates have a far lower per customer monthly charge than the cost of service study results show below the line, right?
Correct, because what we're showing down below is if you were to do a pure fixed variable rate design, how you would structure that. Whereas where we show,
I don't
well,
know.
not,
That's the rate design. That's the cost of service. That's the cost causation, right?
yes.
Okay. And so understandably, there's a whole push-pull here in fixed charges, and volumetric charges, and the lower our volumetric charges, we're not encouraging people to save the commodity. Like, I get it all here.
Exactly.
But it's quite the difference, right? It's like a multiple of 3 based on what your cost causation shows is kind of the cost per customer per month. And I'm trying to understand this, especially kind of in the context of evolving policy. And I think the real potential we're hearing from the company on especially partial electrification of different customers where they're essentially kind of using the gas as basically a capacity resource, just using it on the coldest few days of the year when they may need it, but not contributing a whole lot to volumetric purchases here. And so I just kind of want to discuss this honestly more for the future than even in this proceeding. I think this is really like an emerging issue and trying to think through how these different usage patterns, very different than how people used to use this resource to heat their homes, will impact rate design as we kind of carry on and see this continue. You know, I think the real crux of this could be if we really begin to see a lot of customers using it in that way and really struggling to recover the cost from those customers that they are incurring on the system and using it more as a capacity resource. So sorry for the monologue, but I'll stop there. I just want to understand kind of what the company is looking at and studying with regard to this issue, especially as we move on to the future to ensure that we can really keep a rational rate structure to recover the costs customers are imposing on the system.
Well, we're thinking about it in very similar ways, Commissioner Gilman. I think that's really important to highlight. How people are currently using the gas system might be different from how they use it in the future. Rate design is an important consideration into that, as are the company's investments, as is the revenue stability mechanism or the partial decoupling that the settlement contemplates here. All of that kind of continues to be reviewed and discussed, by us and all other interested parties holistically. I think it's hard to just pick on one piece of it, because I think these are all now interrelated questions, which the commission has rightfully pointed out in the past, that all these are interrelated and we've got to monitor all of it. Rate design is a potential lever there. If people are using this system very differently in the future, higher monthly charges could help increase revenue from customers that aren't using the system except for on those current days. And so there's cross-subsidization issues at play there. Of course, there's going to be parties in proceedings who are going to oppose a move like that. Just like you see in this proceeding, right? We argued for a $4 increase in the SNF charge in our direct case. Other parties advocated for a $2 increase, thinking about just residential customers for a moment. And the settlement agreement contemplates a single dollar increase, as you see here. And so there's a lot of equity considerations at play in this policy issue as well.
Yeah, absolutely. And so I guess maybe you can help me understand in kind of tracking this issue and seeing that as an emerging issue, probably not something that's shown up in massive numbers yet on the system, but certainly a potential to grow and become like a cross-subsidization issue with really paying for the capacity, which buttresses the vast majority of the investment on the system. What particularly is the company tracking with respect to this issue, or how will you know to raise this, or how will we have the right data in future proceedings to say, now this is becoming a problem or will become a problem in a single digit number of years? I just want to better understand what the company is doing or tracking internally to be sure we don't get way behind on this.
Right. Good question, Commissioner. I've got a couple thoughts. I'm sure some of our program or customer program folks might have additional thoughts. I know this isn't a customer program forward proceeding, so we might not have all those views here. But I think the revenue decoupling mechanism here is also going to tell us a lot. And I think this gets at what you're highlighting here, Commissioner, that if we see customer use per customer change a lot, customer counts change a lot, that revenue decoupling mechanism is going to pick up on that, right? If we start seeing swings there, or that being a consistent refund or a consistent surcharge, I think we're going to learn there. We're also going to learn based on the demand related factors you can see listed here. We're going to see on our coldest days in a given year, as part of our model verification process, we're going to see, are these relationships changing over time, where we see a lot more usage on the colder days than we used to in the past compared to a more normal kind of average winter day. Combine that with the kind of the last perspective that I mentioned at the top, which is on the customer programs front. How are we seeing participation in our heat pump and electric water heater programs, and how are we seeing adoption rates in the market generally? And I think through a combination of all of that, right, we're gonna get a good sense of what role does rate design play? What role does decoupling play? How do investment levels need to change in light of the changing ways customers are using the system? All of that.
Thanks. I just want to follow up on two of those items. First, with regard to decoupling, I don't dispute that if we have a decoupling mechanism, we'll see like right in front of us the over under collection. But it doesn't seem to me that this information was unavailable without a decoupling mechanism. Would you agree with that? Like, we would be able to track if your revenue was on track or not, to kind of look at usage trends independent of that.
That's correct. The underlying data is nothing new there, right? At the end of the day, you're looking at how many customers do you have in your system and how much are they using, right? You can have more or less customers, you could have more or less usage on average per customer. Basically, those are the two factors going into, are you collecting your fixed costs approved in the last rate case, or are you not? Of course, weather is the other third item of what we've kind of segmented that out in the settlement agreement.
Okay. So the decoupling gives the company the tool to kind of float these costs, but like the underlying data of what's happening to sales on the system existed anyway.
Well, that's right, Commissioner, but I would also say that it elevates it, right, as something that we're all going to track more closely moving forward each year to say, oh, well, how's this system evolving? Are we seeing more or less customers, or are we seeing more or less use per customer? And there's a mechanism in place to kind of tee up what that difference means.
You may underestimate how much I already track it, but yes. And then the other item you brought up was like tracking if we're seeing, say, more usage on the coldest days or something. Like I think that was something you'd mentioned in terms of tracking this as an issue to try to understand if usage patterns have changed. No, it's my understanding the company just has a few discrete metering points on the system that are actually capable of doing the sort of tracking you're talking about. Customer meters don't do that. They're not interval meters. They're read once a month. So you don't actually know from a customer's meter how much they used on the coldest day of the year. I mean, obviously you can tell they used way less. You're not quite sure when they used way less. So I guess to that point, like you have hit on one of my areas of interest is trying to track system behavior on the coldest days of the year. I just think the system's capabilities, as they've been explained to me in the past, are actually far smaller than maybe what was being implied by your response.
Well, I didn't mean to make it seem like we're tracking that at a customer premise level, because you're right? Our meters are not interval meters. We're not collecting that 5-minute increment, or even more granularly. What I'm talking about is more at the system level, and so I'm sure Mr. Gardner could tell you more about this front, about what we track system-wide, but whether these are the town border stations or other regulator stations across the company's gas system, right? Using that data to say, hey, how is that correlating with our usage and weather? And are these relationships that we've had in the past still holding up? Or are we starting to see, much higher usage on colder days in relation to the average winter day than we would have expected?
And is that a practice that the company currently has, or something you anticipate evolving as you try to track the difference?
Good question. I don't want to get ahead of my skis here, but Mr. Gardner might be able to tell you more because it's his team that now has this gas planning function, and so they're the ones, right, that look at usage for any given heating season, right? They update our internal models and they're able to assess how things are changing or not changing in light of that. So he'd probably be able to give you more details there.
Okay. Yeah, no worries. I've got him anyway. And I will just say we don't have to flip through all the tabs on here, especially because it's a little tortured because it's a PDF. But this kind of relationship repeats on the CSG, TFS, and CGL, where we've got, about triple below the line here. What the cost of service shows as what is the S&F charge. But the numbers are much closer in the CLG, TFL, IG, and TI categories. So, flip through those at your leisure, but we don't need to go through all of them now. Thanks, Miss.
Can I just ask one question on this before you move? Mr. Piquet, am I reading this right to say the residential revenue requirement is increased 33.2% from the last rate case?
Right above the black line on the right.
Yeah, the base rate revenue requirement is 33% higher. Is that right?
Yes. Sorry, I see that now. Yes, that's correct, Chair Blank. This is not because the company's investments or costs have increased 33%. This is largely a function of how we were allocating costs from the last one or two gas rate case. If you recall, we had a a volumetric GRSA in place, in which case we kept the residential SNF charge fixed, and we put those increased costs from the GRSA into volumetric rates. That had the effect of in relation to one another, costs being slightly higher on the commercial classes than residential. A full phase 2 case like what we have before us will reallocate all of those costs. And so that's why you see a higher percentage being reallocated to the residential customer class in light of those past decisions we've all made collectively.
But base rate revenues are now 33% higher for residential class.
Correct.
Sorry, Commissioner Gilman, I apologize.
No, that's fine. And I mean, we can just flip through. I mean, since you have some interest, maybe Ms. Federico, we can go to the next page. Just to show. So we have the same data. So that value you were looking at, Chair, is 34.6 for kind of the commercial, a lot of these commercial small rates, and then slightly lower on the next page. You can go to the next page, Ms. Federico. 23% for the CLG and TFL, and then a bit lower for IG and TI, which is on the next page. So point to some of that information. Okay, I think we're done with this, Ms. Federico. Appreciate that. I wanted to talk a bit about the decoupling, Mr. Bouquet.
Sure.
So in his so I'm sure you've heard the commission voice and right concerns about the growing capital spending, especially in the face of a policy environment and actual declines in sales on the system. And so this feels like a hard problem to solve, and understandably that the company is here before us with the decoupling proposal. And as I understand it, decoupling is really a powerful tool to align incentives potentially, but certainly requires some discipline on the capital spending side to ensure that we're not shocking the customers on the system, especially if we see sales decline, assuming they will make up the difference and support all of these costs. And Dr. England highlights this in his answer testimony. He said approval of the RSM, which is the decoupling mechanism, would have the perverse effect of continuing as opposed to dissuading the company's incentive to put continual investment into the gas distribution infrastructure. So, I'm trying to figure out how, perhaps even through development of the capital spending PIM, which I understand there's like a stakeholder process and settlement agreement about, if the company is seeking approval of the decoupling mechanism, how do we address these concerns with really, you kind of lose your opposition, I guess, to decreasing sales, but there still really remains a concern about capital spending, which now would kind of very squarely go to ratepayers to make up in its entirety.
So I would differentiate these issues a little bit, right? If we want to talk about capital investment and trends or incentives, right? I think that's very different than revenue decoupling. It sounds like you just mentioned a statement from UCA testimony. I'd imagine that was from answer testimony because this is a near unanimous settlement here in the case, in which weather normalized revenue decoupling is part of that. I don't think of revenue decoupling as creating some new incentive to invest or otherwise working counter to what the commission's stated objectives are. It's important to remember that revenue decoupling is a mechanism that addresses what happens in between rate cases. And so there's a lot of different ways we could think about that, right? You've got rate design, you've got decoupling, you've got how we set rates in the first place, right? FTYs or MYPs could address that as well. This is simply the revenue decoupling mechanism simply asks, what are your fixed costs on a weather normalized basis, and how are you tracking against that recovery on a weather normalized basis? It's not dealing at all with investments you've made since that last case. That's still at issue in GIPS and still at issue in future rate cases.
And so I think it was Mr. Haglund in his answer testimony had also expressed a concern that this could kind of lengthen the time between full rate reviews. Is that a potential? Or I guess what you're saying is just as sales dropped, you're still collecting the same fixed revenue from the last rate case. If your expenses went up that much, you're not getting that unless you come in for a new rate case. Is that?
Exactly. Yeah, I think, things are going to push and pull in different directions there. So in theory, in isolation, could a revenue decoupling mechanism, add a component that extends the time in between rate cases? Yeah, in isolation, it could. At the same time, the settlement agreement features an average rate base convention, which pushes in the exact opposite direction. That for all the investments we've put into place in 24 and 25, right, we're not getting that year-end value to all of that, and so with continued regulatory lag, that would push the other way. So there's give and take on a lot of these different provisions.
Okay. So on the capital spending piece, in his rebuttal, Mr. Gardner indicates that like some of the positions of WRA and UCA and answer to restrain capital spending would force the company to decide between being financially negatively impacted or neglecting kind of the safety of the system. Are you generally familiar with that?
Yes, I believe I had a couple statements at a high level in my rebuttal testimony as well.
Okay. So we wanted to get to this because also in his rebuttal testimony, Mr. Gardner indicated that he thinks it's possible or likely the safety integrity investments would not just be sustained, but would increase in the future. Are you also familiar with that?
Mr. Gardner made that statement?
Correct.
Commissioner? Yeah, without seeing the specific lines, I'm not sure what he's referring to. He probably has some discrete programs of work, like problematic pipe replacement programs. I know he spent some time discussing them.
Yeah, I think he's referring broadly to especially the implementation of advanced leak detection, the commission's new rules with regard to advanced leak detection, as well as leak repair timeline.
Gotcha. Yeah, that's another important category and something that would drive investments, right? If we're picking up more leaks based on our technology, of course, we're going to want to close those as fast as possible, that there are a cost associated with doing so.
Okay. So trying to understand this, I mean, understandably, new business and capacity expansion investments might do what they do under new policies, and we'll see how that goes. But it sounds like the company's expectation that safety integrity investments will likely increase in the future. And of course, those are basically non-revenue generating investments, across broad swaths of the system that are needed according to the company, no matter how many customers you're serving to a large extent. Is that all accurate?
I generally agree with that framing. Of course, we try to manage those costs and investments with affordability in mind at all times. But we're very mindful for our state and federal safety requirements and providing safe and reliable service to our customers, which drives those investments in the first place.
Yeah, so I'm trying to figure out where this puts us financially looking ahead, not just at like the near term few years when we're doing safety improvements, but also at the long term of the system, ensuring that we really have an economic glide path for the system that works, rather than leaving us in dire straits in 20 years, which has its own safety concerns associated with it. In this discussion on safety integrity expenses that seemingly grow year over year, and that are meant to protect the community from like a catastrophic event, the company from liability or other issues with regard to its equipment. They don't produce new revenue, so in that regard, they're just kind of adding rate pressure to the system, it does remind me to a large degree of our discussions on wildfire expenses on the electric system. And the company did agree to securitize those expenses on the electric system, I think considering all of those factors. So I was just curious if the company has evaluated securitization as a measure to ensure that you really have the ability to invest in what you deem necessary for safety, but while minimizing the rate pressure that this increasingly puts on the customer base that looks to be shrinking in sales rather than growing.
We have not evaluated securitization of gas investments for a few different reasons. One, we don't, I don't think that solution is warranted at the moment because we don't know the exact path that the gas system will take over the coming 10 to 20 years. We need to create a robust system that is safe and reliable, regardless of the state in which we find ourselves, right? We're all pushing on electrification really hard, which is great for all the reasons we're pushing for, right? Emissions reductions, customer interest. We don't know the trajectory that's going to take. And so the gas system is going to respond to those needs of customers. If we've got a much smaller group of customers in the future, then our investment is going to take that into account on every front. I know we've said a lot of these safety investments are not going to scale as directly as capacity and new business investments will if we have customer declines and usage declines, which is great for capacity and new business, right? That's kind of the first front. On the safety front, but we need to make sure it's safe and reliable, even if we've got one customer at the end of a line. But we're exploring non-pipeline alternatives to that as well, right? In our integrated customer program filing, we brought forward a service line NPA proposal to explore cost-effective alternatives there if there's customer interest in doing so. You know, combine that with the nation-leading NPAs we're rolling out in real time now. Combine that with the line extension proposals we brought forward for commission review and approval here in the settlement agreement, right? With the industry-leading gas planning process we've got in place now. I think the company is pushing on all these fronts, some of which, you know, we hope will impact the safety category into some of these, in addition to some of these other categories. And so we just don't think we need another solution to throw into the toolkit at the moment. But of course, this is something that we're going to monitor, the commission's going to monitor, others will too. And I think we can adapt in real time based on the needs of customers in the system and how people are using gas.
Thanks. I'm just trying to square kind of two concepts you brought up. One was that, you know, necessarily if we see real declines in sales on the system, declining customer base, that investment will necessarily take that into account. But then I think some of your other comments and Mr. Gardner's comments that the safety investments will not decrease, even if the customer usage or count goes down.
Well, right. So let me directly square those, and thanks for pointing that out. One, I think it's important to note that when it's cost effective to do so, we want to explore alternatives, right? That's part of the settlement agreement here is that working with the gas planning communities, we're going to see if there's cost effective alternatives to some of these safety projects that we can explore in concert with our communities that are interested in doing so. That this is specifically focused, I think, on the DIMP category of work, or Distribution Integrity Management Program, to say, hey, when we've got to replace an old line, for instance, in a neighborhood, is it more effective to electrify the folks in that neighborhood? That could avoid an expensive safety project, potentially. We want to test stuff out like that, as do some of our interveners here. But we've got to work through the details to make sure that still leads to safe and reliable service at the end of the day. That has implications for our electric system as well, and potentially other providers in the state. So we're pursuing all of that. Another point to remember is, you know, Mr. Gardner's, you've referenced Mr. Gardner's testimony a time or two Commissioner, and I think we brought forward information in his rebuttal testimony, if not in other places, to show that gas CapEx is going down on nominal dollars and inflation adjusted dollars. Gas capacity, gas capital additions are going down in inflation adjusted dollars. So I just want to push back a little bit on the idea that investment in the system continues to go up and up and up, which is not what we're seeing here in our own forecasts, and not what we're hearing from the commission, and not what we think some of our current mechanisms in place are going to support moving forward on NPAs and GSIFs and otherwise.
Okay. Yeah, I'll have to find, I think Mr. Gardner had a graph showing gas CapEx projected over maybe the next 4 or 5 years. As I
Yes.
recall, I thought that went up, especially for the next 2 years, and then perhaps declined after that. But I'm not sure if you have any chart or data that shows the CapEx has declined or will decline in the next few years.
Yes, that's what I'm referring to, is his graph showing that over the next 5 years. My understanding is that that goes down over time. There might be a year or two in the interim where it goes up because, as he's talked about a lot and our GIP talks about a lot, there's discrete programs of work that we're working on there, be it problematic pipe replacements or other safety projects. But we hope that that's a downward trend over time.
And do you have something to refer me to support that gas capital investment has decreased thus far?
I would just refer you back to those graphs. I don't know how many years of
Okay.
actuals we show there, but I believe that there were several years.
The
I think
one
it
I'm
goes back to
thinking of was
2020.
forward-looking, not rear-looking, but if you have something, I'd be happy if you let me know. No?
Yeah, his testimony would be the place, so I can't recall off the top of my head.
Okay. I will ask him. I haven't memorized all the charts, but the one I did certainly shows an increase for the next 2 years. Also curious, you had said, like kind of we'll evaluate it when we need to, or when the time is right. How do you know when the time is right, especially given these are very long-lived assets that are going into service and rates live a pretty long life for our customers? How will you know? What will be the indication that there is an issue that needs to be addressed, especially with regard to the growing safety integrity investment if we see declining sales on the system?
That's a good question for Mr. Gardner. I think, obviously, as we've talked about, the capacity investment and new business investments would be going down if there's less reliance on the gas system moving forward. How that correlates to safety investments is kind of up to customers at the end of the day, right? Are we seeing voluntary electrification and voluntary disconnections happening in concentrated geographic pockets, which would help us reduce safety investment? Or is it happening more sporadically across the system, in which case you still have a lot of people in a given area or given neighborhood relying on infrastructure, and so it's not something that you can decommission and avoid a safety project on. Of course, we're going to be testing new MPAs on this front, or want to be, with some of our communities, and so I think there's still a lot to learn there. So I'd be monitoring, right, customer electrification, voluntary disconnection trends, how those are occurring by geographic area or not, as well as how we're tracking towards state and federal safety requirements to inform, right, the pace of our safety investments at the end of the day. But Mr. Gardner could give you a lot more detail on things he's going to be looking for in addition to that.
Okay, thanks. Just getting back to securitization for one more moment. I was curious, I had heard, I think I was listening to one of the Colorado legislative committees, heard the company's CEO state that the cost of securitizing investments like this could be more expensive for ratepayers. And I was wondering if you could lay out for me the analysis the company completed, or what data kind of supports that position, or under what conditions it may be more expensive for ratepayers.
What I imagine he was referencing was in some of our proceedings on the electric side of the business, we brought forward some securitization analyses that shows that, right, instead of spreading these investments out over time, long-lived assets, right, 30, 40, 50-year lives, a securitization could entail higher costs in some of those scenarios because you're essentially leveraging a lower cost of borrowing at the end of the day, but it's it can be a larger outlay of capital. It could increase costs of capital for the company moving forward if Colorado is deemed a more risky regulatory environment for utility investments. I think those analyses on the electric side of the business took into account some of these factors. I don't have them in front of me, so I don't have the details at the top of my mind, but I think the customer impacts can be more expensive than non-securitization, if my memory serves me.
Are you familiar if the financial community does view securitization as more risky?
Well, it depends on the context. I think when we're talking about, replacing or decommissioning assets that are no longer needed for policy reasons or no longer needed because they're no longer used and useful, but they still have a remaining life. For instance, after a storm or some type of catastrophic event, securitization makes a lot of sense because it can reduce costs for customers at the end of the day. In other instances where we're talking about investments to serve customers moving forward, that presents a more risky proposition, in my view, because now you're saying instead of the utility making investments to serve customers and promote safety and reliability, we're now going to ask for those investments, but give a much reduced return on those investments to the utility provider. That's a very different question.
And did the company see that sort of negative response when it did this on wildfire protection expenses?
Well, that was established through a comprehensive settlement agreement with all parties in a wildfire proceeding a year ago. And so I think that's a different scenario in which we're trying to mitigate risks more generally. So I think the risks of particular investments over time and company return can be moderated against the benefits to all involved of making critical wildfire investments. So I think that's just a different scenario altogether.
Did you see a negative reaction from the financial community?
I'm not a member of our investor relations team, so I don't see that reaction in real time or talk to those same folks. But my understanding of it is because it was a comprehensive agreement with all parties, the commission ultimately supported that too. I believe it was a constructive outcome.
Chairman, I do have more questions, but I presume you want to look at lunch, so I will pause before I change topic.
How much more do you think you have on the public portion?
15 or 20 minutes.
You want to finish that up and then we'll start lunch with the confidential session?
Or like return from lunch with confidential or?
Yeah, I'm sorry. Return from lunch with a confidential session.
I can try. I can also start it with the confidential session no matter what, and then go to my other questions as well.
All right.
I'm getting hungry.
And how long do you think you need for the confidential session?
10 minutes.
All right. So let's come back from lunch at 1, and we'll go back into the public session at 1:15. And if we get delayed, we'll hold up we'll put some notice on. So let's break for lunch at now. We'll come back for the public session at 1:15. And did we determine if we're in confidential or highly confidential, Ms. Brahma?
Yeah, thank you, Chair Blank. That's what I wanted to raise before we broke for lunch. If I understood correctly, Commissioner Gilman's questions do relate to internal employees, either as to titles or to names that would be highly confidential. If they're external, it can be confidential, but it sounds like we will need to be in a highly confidential session.
Okay. So at 1 p.m., Ms. Federico, can you help us go into a highly confidential session? And then we'll break that roughly at 1:15. But we'll hold up notices letting people know when. Does that work
Chair,
for you, or would you say it different?
no, I can't put up a notice while we're in a confidential session. It's not possible. So just letting you know,
Okay,
the
but-
webcast is connected to Zoom and I can't do that.
Okay, but people will know because they won't be able to get in, right?
Correct. Yes.
Okay. All right. Any other matters before we break for lunch?
The only thing I was going to ask is that someone from the company, if you could hop on just a couple minutes before 1 and make sure nobody's in there that shouldn't be. And if you know you're not supposed to be there, please leave before 1 o'clock. That would help a lot. Thank you.
Yeah, and just
Does that work for you?
yes, I'm sorry, I didn't mean to jump in. We're happy to do that. And I think it'll be UCA staff and commission staff, trial staff and advisory staff that would only be present for a highly confidential session.
Perfect. So if everyone
Perfect.
else that's not those folks can sign off and come back at 1:15, that would help a lot. Thanks.
I think the
All
chair
right.
goes.
Commissioner Plant?
Nope, I'm sorry, you were frozen on my screen, but you came back. So
Oh, I'm on my phone. I can't see anybody's mouse move. So, all right, let's break till 1. We'll come back in highly confidential session at 1, and then we'll start the public session around 1:15. Thanks all.
This is just an audio test I'm doing for the stream audio test.
All right, it's 1:30 on July 27th. We're back on the record in public session in the Public Service Company of Colorado gas rate case. Commissioner Gilman, you want to continue with Mr. Piquet?
Yeah, thanks. Hello again, Mr. Piquet.
Hi.
I have just a couple more questions in public session regarding the prohibited expenses. So this is regarding HE 134 attachment JJP 15, and we can use the public version for this, Ms. Federico. Just a couple more questions on this, on the public portions. Thanks. If we can go to the dues, which is going to be, I'm guessing, why don't you start us at like 20 or something like that?
I don't know why they're blank.
Okay. If you can open the executable too, I can move on to other questions too, if it'll take you a few minutes to open the executable.
Yeah. Let me just make sure there is a public executable. Yes, I can do that.
Okay. No worries. You think that'll take a minute, or should I just go keep?
Yeah, just a second.
Okay. So we're gonna pull this up and go to the dues tab.
Hang on. Sorry, Commissioner Gilman. I misspoke. There is not a public executable of JJP 15. There's a confidential.
It has both. You just have to be careful not to click on the confidential tabs. So it's the same spreadsheet. It has confidential and non-confidential tabs.
Yeah, so just the dues tab, which is non-confidential, is what I want to look at.
Okay. Okay. Give me
If you hold on, I may be able to share my screen. It didn't go too well last time I tried this, but
it's just going to take me a second to pull it up.
Okay.
I just wanted to make sure that the first tab wasn't confidential, and I opened it up on the first tab. That's all I needed to make sure.
No, that one's not confidential. And dues is like the 8th or 9th tab. So as we open this up, Mr. Piquet, you'll see in column D, the dues have two different, the first 5 are listed in column D as industry organizations with lobbying or political, and then those subsequent to that are industry organizations not engaged in lobbying. Does that sound familiar?
Yes.
Okay. And based on tracking this into your cost of service study, it looks like the first 5 of these, which do have that label that says they're industry organizations with lobbying or political, appear to be removed from rates, but then the rest are left in rates. Is that accurate?
Yes, that's my understanding.
Okay. And we had talked a bit in the confidential session, but probably worth repeating here to understand kind of what definition of lobbying you're using for this determination with regard to organizations, I guess, in this context. Yeah, Ms. Federico, sorry.
I've got it. I just wanted to make sure what tab you said. You said the dues tab?
Dues, yeah.
Okay, give me just a second.
Thanks. Yeah, maybe you can just go to the view that makes it normal. So Mr. Piquet, yeah, just curious what kind of test or definition of lobbying you're using to make that determination with regards to these organizations.
I think this is the statutory definition. I don't know if the commission has further expanded that, like they did some of the other categories. But I think the commission, or sorry, the legislation just said organizations that engage in lobbying activities. In the last gas rate case, right, I think we were debating about whether or not that's all dues for that organization, or if we could separate out the lobbying, non-lobbying activities. I think that's where the company and the commission differed. I recall correctly, the commission said to exclude all dues to those organizations, which we've done here in this tab. And then for other organizations, we've continued to have them flow into the cost of service if they're not engaged in lobbying.
Okay, gotcha. So I wanted to look at line 13 here, Excel line 13 is call runs for energy access, and this shows a $40,000 public service company total with 10,300 allocated to the gas company. Do you see that?
Yes.
Okay. So, you know, I only really know what's publicly available, but I will say there have been several articles written on this topic. Colorado Public Radio article about call runs for energy access, which was titled "Xcel Energy Played a Leading Role in a Stealthy Plan to Defend Natural Gas in Colorado." And that article included mentions like call runs for energy access has always been an effort to present the business interests of natural gas utilities as grassroots activism. And in that article, it quotes a company spokesperson as stating that the company works with a variety of energy and environmental policy groups, but those efforts, sorry, are funded by the company's shareholders and not recovered from ratepayers. So that's with regard to, you know, at least what a company spokesperson had said for that article. But here it looks like we do see costs, at least for that organization, attempting to be passed through in rates, correct?
That's my understanding. If they've been labeled here as organizations not engaged in lobbying, it's possible that there's other company. I'd have to double check the spreadsheet to see if they're showing up in the lobbying tab or other donations tab. So maybe there's some additional granularity here that I'm missing. I'm just not sure.
Okay.
Could I just note quickly for the record too, of course, as we're talking about an article that wasn't in front of us, that we're talking about a media article, which by definition includes hearsay. So just want to make clear there may or may not be 100% accurate.
Sure. Mr. Bouquet, are you familiar with kind of the mission or role of call runs for energy access?
I'm not. No, I don't directly engage with them.
Have you ever heard of them?
I think I've heard of the name.
Okay. Not familiar with any of the work they do.
No.
Would anyone who's testifying today be familiar to help me understand the categorization here?
I don't think anyone else is going to be familiar with this organization in particular. I didn't. If you wanted to ask Mr. Freitas about some of these designations between lobbying and non-lobbying and how these costs flow through to the cost of service, he could answer that just to confirm that I'm right that these designations, right, with organizations not engaging in lobbying activities would be influencing the cost of service. Would be good to confirm that with him. But no, I don't think anyone else is going to know the specifics of that organization. They might do a lot of surveying work. I think that's the context in which I've heard them mentioned in the past of customer surveys, in which case, you know, that wouldn't be lobbying activity. That would just be market research.
You mean like customer opinion survey?
Correct.
Okay. Does the company employ them for customer opinion surveying for official purposes for the company?
I'm not sure. That's the only context in which I've heard them mentioned.
Got it. Okay. 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 I think we're done with this. Thank you. And then I think, as you mentioned, to track how these things actually do or don't come out of rates, Mr. Freitas would be the best for that.
Yes.
Okay, got it. Okay, I wanted to move on to a couple other questions in a different area. First, just one follow-up on decoupling. So per your proposal, transport and large customers would kind of just be entirely excluded from the decoupling construct, right? So they're not in the numerator or the denominator, whatever their usage does is kind of irrelevant and carved out in that sense.
That's right, because we have certain demand related, we have other ways to capture the demand related costs that they're imposing on the system, those fixed costs. And so it's less of a challenge with those customer classes to see declining fixed cost recovery in light of electrification or voluntary disconnections. All the same things we're hoping to encourage here on the residential side.
Okay, got it. With regard to the line extension policy, it's my understanding the company has not yet submitted updated language for the distribution extension policy to reflect the settlement position, but plans to do so in a compliance filing after this.
That's correct. Yes, we would make sure we had that compliance filing in and approved leading up to January 1st.
Okay, got it. I was going to ask the timing. You told me the timing. Thank you. In addition, I wanted to walk through the timing of future loads and who gets grandfathered in to kind of prior distribution line extension policies and who would be subject to, I think, as you called it, the GSIF, which is helpful because I was calling it GCIF, which I kept getting confused with GCFI, which is an electric outlet, and I was having a lot of trouble with these acronyms. So GSIF is better. So thank you for that today.
Great. Glad to help.
Yeah. I hope I'm not the only one, but I don't know.
We've got a lot of acronyms and we're just throwing another one into the mix.
It is sort of electric related, so there you go.
Yeah, that's true. Yeah.
Okay. So the GSIF will apply to applications for gas service received by the company with a service notification date on or after January 1st, 2027. Is that correct?
Yes.
What is a service notification date?
My understanding of that is a customer request for service. So it's an application for service coming in through the builder's call line.
Okay. So it's not the date I want my service to work. It's the date I tell you that I desire service. Like,
that's my understanding.
And I notify you about my need or want. Okay.
Correct.
And what sort of official apparatus is around that? I feel like in different stages of development, there could be certainly more casual notifications or more firm about my exact building, my exact loads, my construction schedule. What makes that a service notification rather than just trying to understand kind of capacity and costs? Is there some bright line there?
I'd have to check if there's other routes that would qualify there besides an official application, right, into the company, be it through the BCL or otherwise. That this is going to exclude those, any informal conversations like you just alluded to, right? If we're having a conversation with a developer, which we often do, right, to align around project needs, both current projects and things coming down the road in the future. Right. If something didn't have an application associated with it, I feel like that's what's being excluded here in this language. And that also informs the exclusion language or the exception language that we have as part of the settlement agreement as well.
So is there a certain document or signature or information that makes it a formal application versus a call in to check on capacity and figure out approximate cost situation? What makes it a formal application?
Submitting a form for service is certainly a formal route there. So customers can do that online. They can do that over the phone. But this will be based on hard information that the company receives and that can go back and check against.
Okay, got it. And then okay, so then it also says in the settlement, there will be a limited subset of applications basically collected by the company, any that come in Jan 1st to June 30th, 2027, which would also be exempt from the GSIF. So kind of, I think, I want to parse out, does exempt from the GSIF mean completely on the older line extension policy that's effective right now, or are there shades of gray in between? Maybe help me understand that.
So an application received after January 1st, before June 30th, would be subject to the line extension policy in place at that time, which could include the other changes that we're talking about here in this proceeding. There are a few other changes to the line extension tariffs. But yes, if they meet the exception for the GSIF policy, that GSIF fee would not apply. But otherwise, the line extension policy as it exists in our tariffs would apply at that time.
Got it. So they would pay the updated cost of service laterals and meters, but
Yes.
the GSIF piece particularly would be held over for them. Or like they would be exempted from that.
If they met that requirement, and that requirement means, they've gotten a approved permit, plat, or plan from their local jurisdiction
Okay, got it. And
before
that's
the end of this year.
sorry, say that again.
Before the end of this year.
Yeah,
So they
okay.
couldn't
I was
apply
gonna
for
make that
service in
clarification.
February and then have an approved, permit or something from January. That wouldn't fly.
Okay, got it. So basically they need some sort of local approval of their development plans by the
Correct.
end of this year and apply for service with you with an application basically by June.
Correct.
Okay. So if I got grandfathered into the GSIF trying to build a building that needs gas service, does it matter how long it takes me to build it once I get grandfathered in? Like if my application came in at the right time, does the duration of the construction matter?
That's an interesting question. I don't think the construction timeline is restrained there. There might be other portions of our gas line extension policy that that are not coming to mind at the moment, in which case, someone can't lock in something 20 years into the future. But for all intents and purposes, I'm not aware of a provision like that, and I think timelines are not implicated here. So there wouldn't be a restriction.
Would not be a restriction.
Correct.
Okay. So yeah, and the way I think of this, it's kind of relatively straightforward for one building or one home. But let's say I'm building 10,000 houses and they may take 15, 20 years to build out the entirety of that plan. What I'm hearing is it's conceivable all 10,000 of those houses, even those built in 20, 25 years, would be grandfathered into the no GSIF.
Well, I think it's important to remember how this actually tends to go with a development. We tend to see things in phases. So let's use this example, right? At 10,000 structure development coming over the next 5 to 10 years, not unlike some of the projects we're talking about in the gas infrastructure plan, right? Is they to first submit a request for service, right, for offsite infrastructure, right, to get infrastructure to the boundary of their property. And so that's what's going to come first, right? That's what you're talking, years down the line on. And so, yes, a GSIF would apply if they submit that application after January 1st and don't otherwise have a kind of a local jurisdiction approval on something. Let's say that they were accepted or got that in before the end of the year. What will apply in the future is those subsequent applications for that same development. Now we're talking, okay, we've got the infrastructure the offsite infrastructure bringing service to the edge of the property. Now we've got to do onsite infrastructure. Okay, that's going to be subject to the GSIF, as I interpret it, as all the individual requests that subsequently come. And so there could be portions of a given project, given the timing, that don't face the GSIF charge, but then later portions that do. And you know, I've caveated this, but that I'm thinking through this scenario on the fly, but that's how I understand it.
Okay. Yeah, my understanding of how someone officially applies is constantly evolving. But are there two applications? So like I make an application, say I'm bringing 10,000 new premises, and that's an application only for the offsite infrastructure you're saying, and then there's a separate application process for the actual premises?
That's how I believe it works in practice. Yes, I don't think there's one application underscoring everything.
Okay.
There's different components of a project.
If I knew the GSIF was coming and wouldn't like to pay it, is there anything that would avoid me applying for all of the homes ahead of time, even if it might take me 20 years to build them?
I'm not sure. I'd have to go through the tariff closer. I just don't think that's how our system currently works, because we wouldn't know what price to quote them for the service laterals and the on-site infrastructure until we find ourselves, closer to that time frame, because right, we want to provide the most accurate cost estimates possible and provide the most accurate charges that the requesting customer or customers are responsible for, and we couldn't do that years in advance. So that's why it doesn't work like that today. But your question is about whether there's something restricting that from happening, and I'm just not sure. I'd have to look at the tariff closer.
Okay. And I'm trying to understand if this kind of grace period, whatever we want to call it, is kind of sincerely intended to make sure if somebody is planning, already investing, in designing a project right now, that they are able to, actually construct it as they've designed it. So given that, am I right about the purpose, kind of the grace period?
Yes.
Okay. So given that that's the purpose of it, would it be reasonable to have some reasonable sunset? As I read through the distribution line extension policy, there are certain sunsets built in there. Say if the counterparty doesn't sign their agreement within 120 days, or of their request, and I think of 60 days of when it's provided to them. So would it be reasonable to have some sort of sunset? I'm not saying it's 60 or 120 days, on which there is an expectation that that actually meets this purpose, and beyond that does not. Sunset to the actual activation of the service.
Oh, gotcha. You meaning an end use customer coming online,
Correct.
and using gas off of
The building that is subject of the distribution line extension policy is actually built and connected.
Right. Gotcha. Thanks for clarifying. I'm trying to think. I'm racking my brain to think back to 2023 and 2024, right? The last time we made some notable changes to our gas line extensions. This was coming after 23-291, I think. I think there were some sunset provisions contemplated there in what we all collectively rolled out, right? Saying, right, there was this exemption policy, right, of needing to have an approved permit or plan by X date, but then we set up kind of a back end deadline on that too.
Right.
That wasn't contemplated by the enabling legislation, but that we all thought was reasonable. So yeah, I just bring that up as an example of when kind of a restriction on the back end was contemplated. Could something like that be useful here, is your question? I think that's reasonable to think through. I think the challenge is getting that right. of providing a sufficient amount of time, given the heterogeneity we see in customer requests, right? Some of them are much smaller and have shorter time frames, and some of them are much longer and involving much longer time frames. So what that, to have a catch-all, kind of a one policy, one size fits all, might be a little tough here. And something that might benefit from additional thought and party comments on.
Okay. And this sort of issue comes up here and there in the distribution line extension policy. I know which was submitted here as hearing exhibit 102, attachment CAL6. I'm not sure. I don't think there's any other versions unless you're aware of any in this record. I think that was it.
No, I think that's it.
Okay. And primarily that red lines in those changes to include labor in the laterals and meters. I think that's the main, and then there's some MEP, Mountain Energy Project, kind of cleanup.
Correct. Right. That is the second category. And there's a third category of a provision that lets us true up costs to estimates provided. These are for larger or more complex projects that the company builds. I think these will all be for commercial customers, or at least a commercial entity requesting it at the very least. And so I did want to highlight that too.
Okay, yes, I think I have a question on that. I'll get to that. So I will say on page 1 of the distribution extension policy, it does say that basically grandfathered applicants are those residential applicants or commercial applicants who request extensions and execute a distribution main extension and or construction agreement prior to the effective date. So that seems to have perhaps one added criteria, if I'm understanding properly what's in the settlement agreement in terms of kind of getting grandfathered in this pre-GSIP, GSIF. And what I'm seeing in the current distribution line extension policy is the addition of that signed agreement. And I was curious if that is intentional or if those really should be mirroring each other in terms of what gets you grandfathered in. We can pull it up if that's helpful, but I kind of read it verbatim.
Yeah, if you could read that phrase one more time from the current policy, that'd
and
be
we can
helpful,
pull it up
Commissioner.
too while we're at it. It's hearing exhibit 102 CAL6. It's on the first page. So the third, I guess, fourth paragraph, right there in the middle. See, it starts grandfathered.
Yes.
Grandfathered applications are those residential or commercial who request extensions and execute a distribution main extension and or construction agreement.
Gotcha.
So it seems that's a feature missing from the settlement agreement, which is the current grandfathering. I don't know if that's a verb. Practice.
Right. So good call out. Great question. I think the difference here is what we've got in the settlement agreement is high level, right? All the settling parties recognize that there would have to be a compliance tariff after this to memorialize these changes or codify these changes into the company's tariffs. I think that's where we get into these second and third level details, which are great to call out. But there's still more to work through as we take this settlement agreement and turn it into tariff language. A provision like this makes a lot of sense, as you call out, right?
Okay.
Here we've got it currently. Does this apply to the current GSIF? Probably, but would need to think that through with the team and with other parties.
Okay, but I'm hearing that was not intentionally different or excluded.
I can only speak personally at the moment, right? I'm not aware of, myself or other company representatives intentionally leaving this out of the settlement agreement. I think we're just moving fast, getting the high level details on the page, and we're going to work through the tariff language next.
Okay, just wanted to understand. And I'm curious if a customer executing a distribution main extension or a construction agreement indicates a financial obligation to pay for the customer portion of that. Is that kind of implicated in signing an agreement like that?
That's my understanding, is that there would be an obligation to pay for those costs, as to what happens if a customer backs out. I don't know, we'd have to look at the exact service agreement language.
Okay. And another question on your intention with timing of the payment. So it's my understanding in reviewing the existing distribution extension policy that the company collects payment after the construction is complete. And I wonder now, given kind of the change in amount and direction, if that is still the company's intention, or if you intend to collect this more upfront.
My understanding, Commissioner Gibbons, is that we collect payment upfront, not after the fact. But if you
That
could
may be a
direct me to-
difference between offsite and kind of service line laterals and things like that.
Yes, there might be a difference there. Yeah, right. So service levels might be different given we're dealing with, smaller sized infrastructure, smaller costs. But my understanding is that generally we require upfront payment to commence construction.
Okay, let me see. And then with regard to the distribution extension policy too, it's my understanding that the offsite portion, like the offsite credit that was 28% for offsite distribution upgrades. Are you familiar with the general concept?
Yes.
Okay. It's my understanding that that is no longer effective for any new applications. So is that accurate?
That is accurate. That was terminated after our 2022 gas rate case, I believe.
Okay. So does that mean that any offsite distribution infrastructure upgrades needed to serve a customer then are the full cost responsibility of that customer without that credit?
Correct.
Okay. And in the case where a capacity need is created further upstream, like a main upstream of a project or something like that, is that identified during kind of that evaluation of the ability to serve the customer and then kind of that cost responsibility given to that customer?
Well, you mentioned the term upstream. I'm a little unclear what you're referring to, but if you're referring to infrastructure, higher pressure infrastructure, transmission lines, transmission pipes, regulator stations, compressor stations, right? Keep going further up the system. I think that's where our debate, I think, has centered in recent years of how do we all think about that? How do we define that? That hasn't been captured in the company's distribution line extension policy previously. Because, for those reasons, right? What exact infrastructure are we talking about in the first place? And then number two, how do we think about cost responsibility or allocation there? But no, those are generally outside of our distribution line extension policy.
Okay. So do you know, like, as the company does the hydraulic modeling, you get a new request for, say, a larger development or commercial property or whatever it is. So you run the hydraulic modeling to understand system impact. If that shows that that creates constraints on portions of the system upstream, is that, I guess, considered part of, or when is that considered part of the offsite implications of the project?
Right. So if we're talking about, as upstream as it gets, right, which is, I think, about supply points and compressor stations. No, that hasn't historically been how we've thought about offsite. That's serving thousands, tens of thousands, if not more, of customers in certain regions. And so it's really hard to think about how one marginal request would implicate a investment like that. Those have been the investments that feed into base rates, right? And feed into conversations like this on a phase one gas rate case. I think when we get to, there's some interesting scenarios we've gotten into recently with projects, right? I want to call in a recent GIP project here on the Aurora new business project. or at least what was the Aurora new business project of having a certain geographic area with a lot of requests coming in at the same time. That let us think about the system a little bit differently and saying, hey, we're going to need to build a lot of offsite infrastructure, including 1 or 2 regulator stations and some high pressure pipe. Given that it was more clearly possible in this scenario compared to other scenarios to say, these upstream assets are going to be used by these requesting customers. Let's allocate a portion of those costs to these requesting customers. In most situations, it's not as clean as that, right? You've got one customer here and one customer there, right? We've got a reinforcement need we need across our system from those requests, as well as existing usage of other customers in the area, existing customers. That's why it's been a really muddy process to try to think about cost responsibility for those new incremental investments. But that's not what our distribution line extension policy has tried to solve in the past. That's all been things that are, hey, let's get this distribution pipe to the site of your neighborhood, right? It's a much more discrete ask. It's very clear who's causing that. We can assign those costs to that requesting customer. All these upstream assets are very difficult to allocate or to think about proportional shares of.
Ms. Federico, can we pull the line extension policy back up just real quick? And go to page 24.
That's that 102 CAL6, right?
24. So page 24 is about compressor stations. And I think my question is simple in that, like, you do hydraulic modeling when a new large customer comes on. To the extent system constraints are identified, where is the extent that those are identified? So this second paragraph says, in the event the company determines that a non-LDC customer requires either a new compressor station or increased pressure at an existing compressor station that requires the installation of 1 or more additional compressors for permanent service, such incremental compressor station costs attributable to the non-LDC customer may be included in the offsite distribution main extension. So it seems to me this is contemplated, in your unless I'm interpreting it wrong, like it seems like such a case has been contemplated, and at least you have the ability where you may charge a customer. And I guess I'm not understanding how and when the company makes that determination to execute or not on your may. I mean, to my understanding, you have not ever, that I understand, with regard to regulators, compressor stations, kind of given that cost responsibility, but it does appear it's in your abilities in the policy.
Yeah, I would agree with that. This does contemplate that. That is helpful. I can't think of a situation in which this happened, that you have a discrete request that implicates the need for a new compressor station, thinking about one of the largest investments we could make.
Right.
In a specific
but I will
site
say,
or
like,
specific
this is
project.
not a new construct in your distribution line policy. I don't recall this being out in the last few years. So
No, agreed.
I know, we've talked about kind of the commission's interpretations and whatever, but I think we're looking at some legacy language about cost allocation. And I'm just trying to understand how the company actually internalizes that and tries to figure out the cost allocation when and if it's appropriate, which your policy seems to indicate sometimes could be appropriate.
Agreed. Yeah, that's what it says here. I think I'm speaking from my experience seeing actual customer requests being analyzed. I don't think a single customer request has ever allowed or implicated the need for a new compressor station. But you're right, this is clearly protecting us in that instance, that if it is a large enough request, then the cost responsibility could be contemplated as this states.
I guess protecting you and thereby protecting other customers.
Exactly, protecting the system from a new expensive project.
Okay.
I think the challenge here is what happens in the normal day-to-day, which is you've got a bunch of little requests across the system over years, geographically disparate, right? We constantly evaluate the system and the needs to preserve safe and reliable service. And it's not always clean in terms of who and what and when and where are driving the need for a new capacity project.
Understood, but clearly something that has been contemplated as a possibility for quite some time now.
Agreed. Yeah.
Let's go to page 26. So in page 26, the distribution extension policy addresses right at the top the possibility of uneconomic extensions. I think there's a defined elsewhere as over half a mile or something like that. So I was curious, is it here it says the company could at its own discretion look for basically other sources, try to see if another utility would serve the customer or something of that nature. If that doesn't pan out, is it the company's position that the company would necessarily have to provide an uneconomic extension to a customer?
So in this scenario where it would be expensive to do so, another utility provider is either unable or unwilling to provide service.
Correct.
And this customer is requesting service. This kind of goes into the legal question of obligation to serve. I'll caveat that I'm not a lawyer, but it's my understanding that we need to serve a customer that requests service. So we're going to try to do so as cost effectively as we can, but I don't think we can say no if it's in our service territory.
Okay. But is it possible that the classification of that as uneconomic or economic, I don't know if by the terminology in here, but by our kind of common sense, might be dictated by how much of that cost is borne by the system versus by the customer trying to connect at this uneconomic cost?
Thinking about that from a system perspective is a common sense way to do it. Yeah, I'd agree.
Okay. Okay, and then I think some of these provisions predate some of these cost allocation discussions, so it just may be relevant. And then page 26, I will just say, or gosh, 27. This is where I was referencing those timelines for kind of the sunset of the agreements. You'll see right there in the middle of the day, the 120 days. Whereby the estimates given to the customer become void 120 days from the extension request, 60 days from the written estimate if the customer basically doesn't countersign. So I'm not sure there's an exact question here, but as we talked about timelines and is there a sunsetting ever of kind of offers on the table or current policies, I just wanted to point you to this is where I was looking with those timelines I cited previously. Page 28 gets to the changes to the lateral and meter costs. And to my understanding, the primary difference we're looking at here is the inclusion of labor, right? We can blow it up if you need.
That'll be, I think that's the biggest driver of it. Yes, but we update these costs normally in a phase one, so I can't speak to what percentage just updating the number as it would have been updated in the past for net plant in these categories or these costs contemplated. But yes, labor was the big change.
Does anyone know that who's testifying the breakdown of what's labor, what's just kind of inflation of the parts and pieces?
There's probably either an attachment or a work paper to either Mr. Klingeman's or Mr. Thompson's testimony.
Okay, I'll look. And then as you had indicated, so these would only get updated then, obviously with inflationary pressures, not only on the labor, but also on the actual parts. These would be expected to increase over time. And those would just get updated in regular base rate proceedings?
Yes.
Okay. Is that done as a matter of course, or does the company need to be kind of directed to refile and update this?
No, that's standard practice. I believe we had in the 2024 gas rate case updated some of these costs as part of that normal process.
Okay. Just a couple more questions, sorry. So it's my understanding that these include then the basically a proxy value for the capital cost as well as labor. But these do not include any decommissioning costs or net salvage costs for, say, the actual service line, right?
I'm not sure. You'd have to ask Mr. Mueller about that because that's probably a factor in our depreciation rates, if I had to guess, and not a factor of these charges. But he would be able to tell you definitively.
Okay, so he'd know if that's included in these line extension figures?
I think so. I think he'd have a better feel for that.
Okay. So looking back at 25A-0165G, which was the gas depreciation proceeding completed last year, the net salvage on a plastic service line is negative 150%. Does that sound accurate?
It sounds generally right.
Okay. Okay. I had one other question on page 29. This shows construction allowances by customer class. It was my understanding these had kind of been zeroed out. So is this all getting updated or is this some legacy thing? Just help me understand. I got a little confused once I saw it.
Yes, these should be the grandfathered provisions. I don't think these are getting updated in real time like the other provisions.
Okay, but these are not applicable to current policy.
These are not applicable to current requests.
Okay.
Yes.
Great. I think those are my only questions. Thank you, Mr. Burkay. I appreciate it.
Thanks.
Thank you, Commissioner Gilman. Mr. Burkay, how are you?
I'm doing well. How are you, Chair?
Yeah, doing all right. Just one follow-up on your conversation with Commissioner Gilman. On your GCIF, any thoughts if this commission set a hard deadline, such as like anybody that didn't come online by or didn't come in service, whatever the right language is, by January 1st, 2029, would be subject to the new GCIF and other changes we're making today. So just to directly deal with Commissioner Gilman's concern, any guidance if we were to put a hard stop in the tariff to the exemption?
Right. As we were talking about a moment ago, I totally understand the desire to put a backstop on it so that the details are clear. The only thing I wasn't clear about is, right, given the heterogeneity of requests we see, some being for single structures, others being for, multi-thousand, multi-phase developments, to pick a single year to apply to all of it is hard to think through, right? It's a policy question at the end of the day. How do you think about a single year versus differentiating that a little bit more specifically by the type of request could be one consideration. I think the compliance tariff process might present a venue to think about this with some more discrete tariff language around it. But of course, I think the commission is well within its authority to do something now or to do something later on that compliance filing. But I just note that for an example for how there's always more complexity to think through on tariff language than meets the eye.
Well, in your statement of position, you might, if you have any guidance about whether January 1st, 2029 is appropriate or another date, perhaps you can share that with us. I think I agree with Commissioner Gilman that it would be nice to set an outside date, even if it is complex. Can we pull up Hearing Exhibit 125, Attachment JJP-6, the executable version? Let me represent to you that this is your long-term rate forecast. And if we could go to the rate summary tab, that'd be great. Thank you. And maybe zoom in a little. Oh, great. And do you see how line 14 is the 6-year is the total increase, and for 6 years, it's 4.7%. Do you see that?
Yes, I see that.
Can you click on the 4.7%? And do you see how it's the formula for compound annual growth, I14 divided by C14 to the 1 to the 5 power?
Yes.
And it's a 6-year compound annual growth. Is that right? So it should be 1
Yes.
divided by 6. If you could change that to 1 divided by 6. Perfect. And if you could just hit enter. And then don't copy the formula, but copy the cell. Can you copy that up to line 11, which is base rates? Okay. Do you see that the compound annual growth rate in base rates is 9.5% from 2024 to 2030?
Yes, I see that in row 11.
Okay. And if we could do the same thing in the CHP aligned forecast, but if I represented to you that was 12.5%, would you have any reason to doubt that representation? You're just dividing the same base rate revenues by a lower sales forecast.
I'm sorry, in which row are you referring to, Chair Blank?
The CHP aligned forecast.
Oh, so a different model.
Yeah,
Applying
so
the same formula
yeah.
correction.
Yeah.
Right. Yeah, I can't recall what those CAGRs are sitting here, but yes, if it showed 1 divided by 5, it should be changed to 1 divided by 6.
And if I represented to you that the growth in base rates was 12.5% over that 6 years, would you have any reason to doubt that representation if we made all those fixes?
I couldn't confirm or deny
All right.
without seeing it, but that sounds similar to what we just did here.
Okay. In a declining sales business, can you help me understand how we can keep gas affordable, growing base rates by 9.5% a year from 2024 to 2030? It's 4 times faster than your inflation assumption, which we can see, and we don't have to go to it, but it's input cell E14 at 2.37%. How do we keep gas rates affordable, growing base rates 4 times faster than inflation?
Well, I think the most important thing to highlight is that this is not the end impact to customers, right? It's just a fraction of that, as we're showing here on line 14. What's driving investment in the gas system is not our capacity expansion and new business projects. It's our safety work, which Mr. Gardner and Mr. Ferrugia can tell you much more about than I can. We've got a lot less flexibility on that front than we have in some of these other categories, where we're trying to influence customer behavior at the end of the day to select electric options. Of course, we're evolving our gas planning to think about alternatives for some safety projects too, coming out of the settlement agreement and some stakeholder processes we've contemplated. But we just have to think of what the drivers of this are, and it's really hard to think about not doing that safety work. That's not a place that we want to be in at all. I don't think any of us want to be in. And there's state and federal regulations driving that.
So are you telling this commission if we accept the settlement agreement, gas base rates are going to grow at 4 times inflation and there's nothing we can do about it?
No, certainly not saying that this will happen. As I've tried to make clear in my supplemental testimony, this isn't our expectation, this isn't our hope, this isn't our plan. This is us trying to do our best effort based on the commission's guidance to show future trajectories. I think these models are really helpful to think about one trajectory compared to another one as we toggle various assumptions. But we could find ourselves in very different scenarios in the future. If customers are electrifying much faster, these results will change, be much closer to clean heat.
They'll grow worse.
Right,
They'll grow
exactly.
worse.
These will be higher than these numbers for sure. If customers continue to use gas and customers continue to add to net new adds to the gas system on customer counts, despite what we're working on efficiency, electrification incentives, and also the GSIF charge contemplated, then these numbers could be lower than what we're showing here. So we just don't really know as we stand here today. We're still all very much in a learning phase.
But this model is based on your 5-year capital and other plan. Is that fair?
It's based on our 5-year capital plan. That's correct. And we're making assumptions about future sales and customer counts and commodity charges.
You can take this down. Can you pull up what has been marked as hearing exhibit 1701? Let me represent to you that this is the initial order in the GIP proceeding. If you can start on page 1, that'd be great. Do you recognize this as our order in GIP?
Yes.
Can we turn to page 89, paragraph 214? And I just, let's see, on the third line down. And I'm just going to read some portions from this. The commission says that the evidence increasingly supports the commission finding that the company's approach to many of the disputed issues, and it lists them, maybe is based as much on the company's financial incentives as the public interest. If you go down to paragraph 215, in the first sentence, it says that the net impact of these misaligned incentives is that the total cumulative capital spending being proposed by the company appears comparatively too large for the revenue base and is not likely in the public interest in a declining sales business with modest levels of depreciation. Assuming I read that right, what is your response to this concern that the company's proposed growth in capital spending and rate base is too high for the likely sales and revenue base in Colorado, and that the company has been unable or unwilling to manage capital spending down to more lower levels to help maintain affordability?
Before Mr. Paquet answers, I feel like from a legal perspective, the company just needs to note that this is an ongoing proceeding. It's not yet completely final. And so we would be responding to something in this proceeding about something that's happening in the other proceeding. I also think it's important for us to note that the GIP was looking at forward-looking planning processes compared to the test year in this case, which is 24 and 25 capital investments. So I think we just have some concerns about going down this path that we want to put on the record before Mr. Paquet has a chance to respond.
All right, can we go down to paragraph 2018? 218, sorry. On page 91, third line, do you see where it says, given the limited options available in this proceeding, however, the commission intends to explore these options in future proceedings, including upcoming rate cases? Do you see that?
Yes, I see that.
With the understanding, well, we're through RRR. The commission has deliberated on RRR. So I'm not sure it's really an open case. I don't know if the RRR decision is out yet, but any general, I mean, clearly a capital spending gap, which I'm going to ask you the next set of questions on, is a disputed issue in this case, but any comments on this notion of misaligned incentives and the company's ability to manage them down?
Yeah, a couple of thoughts. Thanks for the question, Chair Blank. I think it's important to note all the things the company's doing to be responsive to the commission's feedback on this front. Right, we've got nation-leading NPAs in place through the Mountain Energy Project, others up in Boulder and Aurora, where we're trying to avoid new gas infrastructure in pursuit of outcomes that are more aligned with state goals of pursuing efficiency and electrification and emissions reductions. And so we've got to see how these things work, and of course we want to add new ones to the list as they become cost-effective to do so. I'd also note our gas planning continues to evolve. We're working now on coming out of the GIP, right, of doing NPAs much more broadly. We don't want to just be limited to these larger ones that issue in those cases. We want to have a team and funding available to dive into wherever and whenever we encounter a project that could be better served with an alternative. And then we all seem aligned on that, which is great. These things take time to effectuate, and we're also adding new provisions here with this gas settlement in front of the commission with a GSIF in particular, and future conversations about a possible PIM. Combine that with the average rate base that we've agreed to here on the gas business, right? We try to differentiate our gas business and our electric business on this front. In light of the commission's directives that, gas in particular is something we're trying to minimize investment in, push folks into less emitting alternatives that can be cost effective too, when they align with the customer demand. And so we've got to see how all of these play out now, moving forward. I think that's a lot on the list, and all of that should help bend the curve here on investment. The second bucket or the second piece here I'll touch on is if we look at the actual work that the company is doing on its gas business. Absent one project in this case, no one is taking issue with what the company is doing. The vast majority of this is safety related, and Mr. Gardner and Mr. Ferrugia can talk a lot more about why we're doing that and on what projects. But that's driven by things and somewhat outside of our control. We're trying to operate a system that is as safe as humanly possible, also managing costs at the same time. And it's hard to think about alternatives to the vast majority of that investment. And we'll think about alternatives when it certainly makes sense to do so. And we look forward to working with our communities on that front. So besides the Keystone Hotel project in this case, not a single party has had an issue with a single project. Maybe I'll say lastly, oh, sorry, Chair.
No, please. I'm sorry.
Maybe I'll say lastly is the whole paradigm we're operating under here in Colorado and most states is that infrastructure serves the public need, whether that's electric infrastructure, gas infrastructure, steam infrastructure, water utilities, of course, are a big part of our lives, that there is public benefit from having financially healthy, safe, and reliable systems that utilities operate. If this commission thinks is going down a different route, we should have that conversation. But there's a reason we entered into this paradigm 100 years ago, along with all other states. We build infrastructure to serve the public good. We think we're doing a really good job of that, and we think we're better than any other operator out there if you just look at our gas rates, our gas bills, and our gas wallet share. And we also operate it really safely, and Mr. Ferrugia can talk about our gas emergency response and the number of incidents we have per year, which are really low, knock on wood. We think this paradigm serves us well and serves our customers well. Wholesale changes to this make us really concerned. And we think all the incentives we put into the settlement agreement and all the things we're doing writ large that I've touched on will help bend this curve downward in alignment with what we're hearing.
Ms. Brahma, subject to all the caveats you mentioned previously, any objections if the commission took administrative notice of the GIP decision?
Subject to the items I noted earlier, we don't have an issue with administrative notice. Thank you.
Thank you. You can take this down. Let's turn to your rebuttal testimony, hearing exhibit 134, page 41, line 3, where you say that Mr. Kenny's symmetric PIM proposal based off capital additions is more thoughtful, some of the other proposals on this record, and then you respond.
Sorry, I've got so many up, they're taking a long time to load.
No worry.
So
I'll just
it'll take a minute.
Yeah, I think Mr. Paquet can answer. I guess you say his proposal is more thoughtful than some of the other proposals in this record, and maybe you view that as a low bar. But is it fair to say that you then respond to several individual pieces of his proposal, offering recommendations and improvements? Is that a fair characterization of your rebuttal testimony, or would you say it different?
On the CapEx PIM front, Chair Blank?
Yeah, option 4.
Right. I might characterize it a little bit different, but essentially, I think we're understanding that similarly, that they threw out several options. We thought one of them was more workable than the others, but a lot of detail and thinking still has to go into that more workable option. So I think we're saying something similar.
All right. I want to bounce a modified version of Mr. Kenny's proposal off you, largely driven by your comments in rebuttal testimony. First, assume we set a baseline PIM target based on actual historical 2024 capital spending instead of triggering the PIM off capital additions as Mr. Kenny proposes. This seems responsible to your comments on page 43, lines 15 to 22 of your rebuttal testimony. Second, assume we set the baseline capital spending as flat from 2025 levels instead of 3.3% decline suggested by Mr. Kenny. Third, assume we set a 5% deadband above and below the baseline as you recommend on page 43, lines 2 to 3 of your rebuttal testimony. Fourth, assume we cap the reward penalty at $5 million, which would be less than 1% of revenue requirement and less than 2% of earnings, consistent with your rebuttal testimony at page 46, lines 4 to 7. Fifth, assume we implemented this PIM in this rate case, starting with rewards and penalties on the capital spending growth in 2027 as compared to the actual 2024 capital spending baseline and continuing thereafter until the next rate case. I think this is consistent with Mr. Kenny's recommendation at page 44, lines 15 and 21. Six, assume any capital spending that was securitized would not count in any way towards the PIM. Given this, the stakeholder process in the settlement could then be used to adjust the PIM adopted in this case, either prior to or within the next gas rate case. Any guidance if we went down this path? And I just say it's consistent with your comments. It's no radical change to the existing regulatory structure. It's capped at $5 million a year. It's probably not even a huge change to the revenue requirement, but it is responsive to commission concerns that we've been expressing over years. It sets a baseline capital spending that's at the center of this case, and at least gets some structure on the dialogue. So we're not, starting from scratch on a new record based on the outcome of some stakeholder process, which I personally have some skepticism that'll really resolve the issue. So any guidance, thoughts if we were to go down this path? And again, we could look for more guidance in the statement of position. I know I'm hitting with you this cold. So I appreciate the difficulties. But I'll talk for another minute so you can think. But
Can I ask a clarifying question? Oh, sorry.
Yeah, please.
Thanks for laying out your thinking. Just so to make sure I'm tracking you, it sounds like all the components that I talked about in my rebuttal were incorporated in this hypothetical.
I wouldn't say that. I would say I incorporated many and tried to find a middle ground between you and Mr. Kenny. But I didn't incorporate every recommendation. I think I took like 3 or 4.
Gotcha. Okay, yeah, because it sounded aligned on the dead band. It sounded aligned on the cap. I think I missed you in the beginning where you talked about what the actual baseline is. Is it
2024 actuals?
All right, 2024 actuals. So we differ there a little bit. And then what's included in that? Is it all CapEx categories or just capacity to do business? Right. So I think those two elements are of particular interest to the company, right? When are we starting this? Or based off of what year and what parts of our investment? As you clearly saw, right, in rebuttal, we were saying 2026 and a more limited view of things that we can more directly control that aren't subject to state and federal safety requirements is a good place to start. I think there's some synergies to think about there with the new GSIF charge contemplated in the settlement. So I would have to push back on a PIM like that here and now in this case. To be clear, right? All settlements require a lot of give and take, and so this was just like any other topic, a central part of the discussions. And the company had to put things on the table to create a stakeholder process here. I don't think I can go into more details than that. But there's value to the company, there's value to other parties to adjusting things here and there. And this would be no different. So that's why I think, based on the need to get the incentives right, particularly if we're expanding out beyond just capacity expansion and new business, got to make sure there's not unintended consequences there that we're worried about. Stakeholder process is a really good place to have that conversation. That's why we're more comfortable with that outcome. But those are just my quick thoughts here, Chair Blank.
All right, but you understand it's capped at $5 million. So
right, that would greatly help with that scenario.
All right. Can we go back to the GIP order, page 70, paragraph 166?
Is that
and you mentioned
is that 1701?
Yes, thank you. You mentioned that the only project that people had concerns with was the Keystone one. But I want to ask you about Farmstead HB 22 and 2023. Do you know if they're included in the rates in this case or not?
Off the top of my head, I'm not sure. If we had an in-service date, that would answer the question, but I can't recall.
Yeah, the GIP said it was October 2025. But it for the purposes of this conversation, I'm not sure it matters. So let's see. Do you see 7 lines down where it says, for example, the Farmstead HB 22 and 2023 project appear to support only 300 residents at a cost of $5.1 million, which equates to a potential subsidy to the single development of approximately $17,000 per household. Although this type of subsidy for new growth builds rate base and earnings for the company, it comes at the expense of existing customers and maybe another example where the company's financial incentives are not aligned. Would you accept that I read that right?
That does appear to be the lines on the page here, Chair Blank. I'll just note that I don't think we performed a financial analysis on these 2 projects like we had on some of the new business projects in our last gas rate case, where we looked at revenues coming in from these projects over a given time frame compared against the upfront costs to think about which direction the subsidies were flowing one way or the other. I think we found in our last gas rate case, right, that 2 of the 3 projects identified, or at least one of them, was a subsidy from that new construction or that new project to existing customers. Of course, it can flow the other way too if it's a particularly expensive project and not very many customers. So it's just a little hard to say without doing a more complete analysis what this would show at the end of the day.
I think in the GIP, this was only 300 new customers. So the likelihood of those 300 customers providing enough revenue to offset the $5 million seemed unlikely. Assuming that to be the case, under the settlement agreement tariff structure, I think as you talked about with Commissioner Gilman, those costs would be socialized across all customers. Is that your understanding?
If this is a net investment amount of $5 million, I'm not sure if it's net or gross, but yeah, the net investment, less any customer contributions, would be socialized and then allocated out in a phase 2 case.
Okay. And I can pull up hearing exhibit 101, JGP-1 Appendix 5 from the GIP. But basically, it describes the farmstead projects in detail, and that most of the costs were for 2 new regulator stations in Larimer County. Would you have any reason to doubt that representation, subject to later check? And it's page 14, first sentence under 2A. But basically, this project required 2 new regulator stations, and that's what drove the cost. Would you accept that representation?
Right. I vaguely recall some regulator stations with most of these new business projects. Can't confirm or deny without seeing it on the page. But generally, it seems these costs tend to stem from regulator stations and distribution main.
Okay. And the reason that it's socialized across all customers is because the tariff doesn't include regulator stations in the contribution in aid of construction portion of the current tariff. Is that right?
Right. It's not directly contemplated as part of the charge. Of course, I walked through a scenario before with the Aurora project where the company has built in those charges when it's clear how to allocate those costs. I think in a lot of situations it's unclear where the regulator station might be providing benefits to existing customers in ways that are hard to totally differentiate.
Okay. You mentioned the last GEDS rate case. Can we pull up hearing exhibit, what has been marked as hearing exhibit 1703? And do you see this is the order, the commission order in the last GEDS rate case from October 25, 2024?
Yes, I see it.
Can we go to page 97, paragraph 266? Yeah, if you could scroll down a little more. If you can just read that paragraph to yourself.
Sure. Okay.
And you see that part of the reason for those costs is the new regulator station.
Yes.
Can we go to page 98, paragraph 268? And do you see at the end of the second line where the commission repeats its considerable concern? We repeat our considerable concern over both the company's incentives to spend capital. And then if we go to the last sentence on page 98, right, go up a little. Yeah, it says these concerns are exemplified by the Coal Creek Canyon project, where record evidence clearly shows that the revenues from the new customers associated with that specific development did not come close to offsetting the cost incurred by the system to serve that new demand. Did I read that right?
Yes.
Can we go to the end of the third line on page 99, just down one? And you see where the statute says at the end of the third line, a gas utility shall not provide an applicant an incentive, including a line extension allowance to establish gas service to a property. Is that what this quotes the statute as saying?
Yes.
So I guess in the tariff we're being asked to approve today, my understanding is that this concern still has not been addressed with respect to regulators and other non-pipeline transmission equipment. In other words, the cost of the regulator station additions at issue in both the Farmstead and Coal Creek projects are still not included in the kayak tariff and provisions. And I guess, just how is this compliant with a statute or really even the public interest that says a gas utility shall not provide an applicant an incentive to establish gas service to a property? Aren't costs in excess of revenues and incentive?
I think the challenge is we've never we've never defined an incentive and over what realm of the gas system are we talking about? I think that's the basis behind the new GSIF presented in the settlement agreement here, right? Because regardless of what piece of infrastructure we're referring to, a regulator station, high pressure pipe, compressor station, anything that's not covered by the distribution extension policy is now got a charge behind it, right? And so this is going to reduce net CapEx on capacity and new business moving forward in a way that avoids having to go through the extremely difficult, if not impossible, process to tease out what share of all of that upstream infrastructure a particular applicant is responsible for. It says, hey, we're all paying into this new fund, or it's not a new fund, but it's going to offset CapEx. We're all paying into this new fee moving forward. So I think that addresses the challenge here, right? That we hadn't defined this in the past. The settlement agreement brings forward a solution to make this more workable moving forward by standardizing it across residential requests, having it float based on the size of the commercial request, so that we can more directly live up to the guidance in statute. But until this time, we've never defined, what infrastructure is in play and what we all mean by an incentive.
Well, I mean, for these two, I think the Canyon Creek project had 100 customers and a multi-million-dollar subsidy. So $1,000 GCIF would have raised another $100,000. I think Farmstead had 300 customers, so that would have been $300,000 off a $5 million cost. So, but let me, you can take this down. Can you pull up what has been marked as hearing exhibit 1708? And I want to read a proposal to try and address this concern. And starting January 1st, 2028, for gas service requests at premises not connected to the company's distribution system, or for an increase in services to premises already connected, applicant or applicants shall be required to pay prior to construction a non-refundable construction payment for all estimated construction costs for any additional facilities necessary to support the connection of the distribution extension facilities to the applicable transmission mains and existing distribution infrastructure, including any new regulator stations. So, and I think we have to modify estimated construction costs similarly to make it work. So do you have any comments or guidance? And again, I know I'm hitting you Cole with this. So this may also be a statement of position thing, but this would close the gap. So I mean, and in these, at least in these two cases, it was very clear that the regulator station was attributable to these two customers. So any thoughts if we were to try and modify the tariff language in this case to close probably not all of the gap? I mean, I'm not talking compressor stations or further upstream. All I'm talking about in this proposal is the facilities necessary to interconnect the distribution facilities to whatever the applicable component of the company's existing system is. So thoughts, guidance?
I'm sorry, Chair. Could you explain again this document that we've got in front of us? It looks like it's from the GIP, but I'm having trouble.
No, it's language that was drafted to try and close this. So it would be in addition to the tariff. It'd be I mean, I don't really understand the tariff books perfectly, but I think it would come at the end of R73 maybe. And it'd be a new provision that says transmission extension facilities.
So, okay, thanks for clarifying. So it seems like this would be in addition to the company's current extension policy, right? Current charges to customers.
Correct.
It'd be in addition to the GSIP we've already contemplated with settling
Correct.
parties. So it's kind of in this a third category of costs that are now increasing for requesting customers. So I'd have concerns on it for that basis, right? I tried to make it really clear. Oh gosh. In rebuttal testimony, yes, but I think I also talked about this in settlement testimony to show all the changes in these costs over the past 4 to 5 years. So if we're now adding an additional category, right, the commission could choose that as being good policy and a reasonable next step. I think the important thing to note is just how much of these costs have shifted from company investment in the past to now the customer responsibility. I'm not raising that as an issue of company investment, right? The company's got a lot of things it needs to invest in moving forward across its electric business for sure, and also the safety work we need to do on the gas system. I'm not trying to preserve that here as an investment opportunity for the company moving forward. I'm concerned about the customer impacts at the end of the day from what was a small subsidy 5 years ago. Now that we've eliminated these explicit incentives and contemplating new charges like the GSIF, it's now a several $1,000s charge. We've got to find that sweet spot between having new customers pay their share and then some in economic growth at the end of the day. And that's where, that decision is up to the commission, of course, and other policymakers. But that's where I start getting a little nervous.
I mean, assume for purpose of this conversation that the Canyon Creeks project was a multi-million-dollar, each home was multi-million-dollar residential development, and your findings clearly allocated the two new regulator station or the new regulator station to that new development. Can you help me understand, well, in that, call it an assumed set of facts, they shouldn't pay for it instead of socializing it over all customers?
Right.
It's really tough.
I can appreciate that scenario, right? And if we could establish it was, luxury homes and a willingness to pay, I agree. It could be good policy to have increased contributions in that scenario. The hard part is applying a policy like that writ large, because now we're talking about housing affordability across the state of Colorado, just given that we serve a lot of different communities across the state, and how this affects the housing market more generally. The hope is that it wouldn't, but I'm not sure. We're just starting to test that elasticity of demand here with these recent changes. As we've talked about grandfathering provisions and other exceptions, these take time to fully implement. We're still in that implementation mode. Of course, that'll take another year or two on the GSIF as well. And we're just starting to get information on how price responsive construction is to all of this. To add another component, I think, is moving too fast.
And even if any thoughts, given that this has the same language that you do for your distribution extensions, that it's only if it's to support the connection of the extension facilities to the applicable company facilities. It's the exact same language and approach and concept you have for your distribution line extension. And so it's just limited to costs that these customers impose on the system.
Right. It does look very similar to that language, which is good, right? If there is to be language, we'd want it to be similar in that nature. But I just need to think about that more, Chair Blank. Maybe we can talk about that more in our SOP if that's okay.
Yeah, I understand. I appreciate you're in a tough spot. That's all I got. Why don't we take a 10 or 15 minute break? Let's take do you need more than 10 minutes, Ms. Brahma, or
Well, Chair Blank, I'm okay, but Mr. Paquet has been testifying all day. If we could make it 15 minutes, that would be great.
Yeah. All right, let's come back at fair enough. Let's come back at 3:15.
Thank you.
Ms. Brahma, redirect for Mr. Piquet.
Thank you, Chair Blank, Commissioners. Mr. Piquet, thanks for continuing on with us here. I do have some redirect for you on the variety of issues that you touched on this morning and this afternoon. I'd like to go back to some foundational questions that touched on some questions from both Commissioner Plant and Chair Blank in particular. First of all, there was some discussion about the GIP proceeding outcomes, whether it's NPA, CBAs, or sort of broader discussion in the GIP decisions. Could you please address, Mr. Piquet, how the timing of the test year in this case and therefore the capital investments in this rate proceeding relate to the timing of outcomes in the GIP proceeding?
Yes, as I believe we noted briefly in that discussion, the timeframes are very different. GIPs are forward-looking. They deal with the next 6 years, I believe. There's a 3-year action period, 3-year information period. And the whole intent is to align around the big projects the company is working on moving forward. And in rate cases, in very much contrast to that approach, are backward-looking here in Colorado. And so this gas rate case looks at the years 24 and 25 and all the capital investment and the 2025 year operations and maintenance costs we incurred to run the gas business and to create a safe and reliable system for customers. And so they're dealing with two very different things, right? One's forward-looking, one's backward-looking. We have forward-looking discussions in each of them to some degree, but the GIP is really where we get into how are we planning this system and thinking about it moving forward.
Has the company expressed interest in the past in a more forward-looking rate-making model that would align better with GIP planning?
Yes, certainly. The company has at many times proposed a forward test year or multi-year rate plan to help address some of this. That's one option that could help bridge the divide here between backward-looking cost recovery on the gas business and forward-looking planning. I would differentiate this a little bit from our electric business, just given the number of rate riders on the electric business, kind of doing a lot of that forward planning to some degree. Of course, electric generation planning processes are different. So I think it's a particularly acute problem here on the gas business that a lot of our discussions are forward-looking, whereas recovery is backward-looking.
And so just more specifically to state probably the obvious, but how, if at all, was the company able to incorporate the outcome of the GIP HRR that just was issued last week into the investments, let alone the testimony or settlement in this proceeding?
Right. So specifically at issue there is an inability from the company to incorporate guidance from this most recent GIP into the investments that were made in 2024 and 2025, right, by definition. We had filed our GIP in May 2025, so a good chunk of the way through the 2-year period of capital additions at issue in the case. Of course, we had come off of the company's first GIP and some other workshops we've held. And so we incorporated as much guidance as we could into these projects. But as I think I stated previously, a lot of our gas projects are planned years in advance, take a few years to construct and in service. And so it's a long-lived process that we're now getting ahead of in GIPs, but it's a transition.
You referenced a couple different times in Commissioner questions some of the many things the company is already doing to reduce capital investments in the gas system over time. Did you provide a more comprehensive list leading up to the settlement in your rebuttal testimony?
Yes, I believe. I think I had a page or two of highlighting all the things the company's doing that could put downward pressure on the company's investment levels in the gas system. I think I touched on NPAs and the Mountain Energy Project, line extension changes in recent years, and there might have been another item or two.
And I won't go through all those because they're in your rebuttal testimony. I just thought it might be helpful to call attention to your rebuttal has that kind of a list. There was a lot of discussion from commissioners about additional things the commission might like to do with respect to bringing down capital spending. I'm wondering if you could speak to how the settlement already brings incentives to the company to decrease spending beyond those that have existed, predated this rate case or are forthcoming in the GIP itself.
Right. I think the settlement gets into all these topics from, from the perspective of regulatory lag. The company has agreed to an average rate base convention here in the gas case. That means that our investments in 2025 we're only picking up 1/13 of however many months they were in service. That is a notable cost that the company is financing these projects without a single customer dollar for quite some time. To fully bake them into rate base and thus base rates, we'll have to wait for the next gas rate case. We think it was appropriate to do so here in the gas case based on guidance we've heard from the commission and intervener positions, and trying to manage our CapEx levels down. That's a one way to think about it for the gas business. We think that's very different than our electric business, which we all think needs to pick up much of this end use to energy use as possible for customers to help bring down emissions. And so we think it should be thought of as very differently across both of the company's businesses. So rate base convention is certainly a big item there. We contemplated PIMs, as I talked about with Chair Blank. There are a couple proposals in the case for how to think about this. We worked through that through the settlement process and agreed on the need for further conversation. There's a lot of details that need to be worked out there, and we certainly want to avoid unintended consequences that could come out from a CapEx cap or PIM structure that isn't structured appropriately. So I think across those two items, and then maybe the third being the GCF item that we've talked through already, providing some additional customer contributions to put down net CapEx spend from the company. So all these will work together to bring down CapEx a bit in the future, or at least put downward pressure on those levels. And the company certainly hears what the commission is saying on that front.
So to build on that briefly with respect to what's already happening around capital spending and bending the curve on capital spending, I had some discussion with Commissioner Dillman about the company's data about capital additions and capital spending trajectories. Do you recall that?
Yes.
Could we please pull up hearing exhibit 147? This would be the rebuttal testimony of Mr. Gardner.
Yes, it's just going to take me a second to find it. Just bear with me for a second.
Thank you. We're looking to page 14. Thank you. So, Mr. Paquet, directing your attention to figure ARGR2, is this the cap expenditure graph that you were referring to in the discussion with Commissioner Dillman?
Yes, this is exactly right. We were discussing trends on CapEx and also on cap adds. So this is the CapEx graph. I believe has another one a few pages down, looking at cap adds, which is a different view of the world. But here on CapEx, you can see there is a slight increase in the near term. That's largely driven by some discrete safety work we need to do on PVC replacement, as well as I think in the forecast is also the SPEAR project. I know that's gotten a lot of attention in our recent GIP, as well as our Mountain Energy Plan, which was approved by the commission less than a year ago. And so there's some discrete items, keeping us steady or pushing us up on CapEx in the near term. When you look longer term over the 5-year period, it's a downward trend. And we're hopeful to see that actually come through in reality year after year. When you adjust for inflation, the trend is clearly downward. That just doing the same amount of stuff, of course, gets more and more expensive on a nominal basis, given inflation for materials and wages. So when you control for that, it's a very solid downward trend.
What does that tell you, Mr. Paquet, about whether or to what extent it's important to consider inflation and any kind of capital spending, Tim, that might come out of the stakeholder process?
It's really important because we've shown that if we can, we're doing a pretty good job managing things on a nominal basis, but of course, year to year, there are emergent needs that you've got to address. But on an inflation adjusted basis, we are on a downward trajectory, and that's really important to consider. So any PIM or cap would need to take into account how you think about inflation that might interact with other parameters of any mechanism. Certain parameters can create more or less risk, and you want to make sure that any mechanism appropriately balances that up across all decision points there.
Thank you. Could we also briefly, we can take this down, but briefly bring up hearing exhibit 117?
Yes. Can you tell me, is that his direct?
Correct. That's Mr. Gardner's direct testimony. And while we're doing this, Ms. Federico, I can tell you that the next thing I'm going to is hearing exhibit 150, schedule 3. So I'll give a heads up now. Maybe that'll make it easier for you. If we could turn to page 13 of hearing exhibit 117. Just really quickly, Mr. Paquet, was this the other figure that you were alluding to with respect to capital additions and the trajectories there?
Yes, this is the other figure I was referencing in my conversation with Commissioner Gilman. Sorry, I thought it was also in the rebuttal testimony, Mr. Gardner, but it's in the direct testimony. And as you can see here, cap adds on a nominal basis are largely have an upward trend over the past few years. This is largely because capital additions are lumpy. Some of these projects were started years ago, as I've talked about, and just depending on when their in-service date is, whether they're hitting rate base and rates at any given time. When you control for inflation, however, that's a pretty clear downward trend over the past 4 years. And so again, just another point of evidence that whether you're looking at CapEx or cap adds, these are on a downward trend. We're managing our gas projects and spend as closely as we can. We hear the commission on this front, and we're responding in kind.
Thank you. We can take this one down. Before we go to hearing exhibit 150, schedule 3, I'd like to just take this one step forward and how it translates into rates and rate forecasts. So you had a conversation with Chair Blank about the long-term rate forecast in your hearing exhibit 125. Do you recall that?
Yes.
And we don't need to pull it up. My questions are more general. But just to level set and what we're looking at with that, is that long-term rate forecast starting from the company's direct case and the 5-year capital plan at that time?
Yes, that's starting from our direct case. So we would have filed supplemental direct, I think, in the March timeframe. So well before the settlement agreement brought forward here for commission review and approval. So it'll be different than the settlement, right? The settlement contemplates very different rate-based levels, cost of capital, all of which will affect the cost of service moving forward. And so those pretty low rate increases over time of the 3 to 4% range would be even lower under the settlement agreement.
And why did the company provide the long-term rate forecast?
Provided in response to commission directives. We don't use these long-term rate forecasts to plan our business. The commission finds them constructive, and so we're going to continue to provide what they think is helpful. So we're listening to the commission's directives there.
Does the company consider the long-term rate forecast to be a valid basis on which to evaluate future rates or future planning and likely outcomes in those regards?
No, it's not our explicit view of the future or goal or selected path. It's simply one way to think about the future, there are other ways. And the company brought forward several different long-term rate forecasts in this proceeding to be responsive to the various commission requests. And that's the core use, as I was speaking about before during the cross-examination, comparing scenarios against each other is really the core function that they provide to see how a different assumption on one front can change outcomes in 5, 10, or 15 years. But no one individual scenario is an endorsed company vision or necessarily commission vision.
I'd like to take this now to talk a little bit about what we actually are expecting to see as a result of the settlement. I think there might be a little confusion about what the rate impact of the settlement is likely to be. So if we could bring up hearing exhibit 150, schedule 3, and the public version will be just fine. So if we could go to page 2, please. Do you recall, Mr. Piquet, your discussion with Commissioner Gilman regarding this schedule? This is an attachment 3 to the settlement agreement in this proceeding.
Yes, I recall.
Okay, and do you recall your discussion over the 33% change in base rate revenue?
Yes.
So if we look at the current base rate revenue column, does that include revenue collected through the GRSA that is already currently part of customers' bills?
No, it does not. And so I might have confused that in my conversation with Commissioner Gilman and Chair Blank before. So it's important to note that that's current base revenue from the last phase 2 case, which would have set that for the residential class. And so we had a GRSA applied to those levels in our 2024 rate case. And thus, we're also here in a combined phase 1 and phase 2 case. So there's another GRSA or full allocation here via the phase 2. So kind of 2 rate cases added together feeding into that 33%. So it's a better way to think about that is about half of that is at issue or is new. Here in this case, the other component will be a holdover from a prior case.
Okay. So when you say about half of that is new, can you relate what that means for the 33% number here?
33% will be closer to 15 or 16%, if I can recall, the actual change in base rate revenues for the residential class. Plus or minus similar percentages for some other classes too. But it'll be much less than that 33%. This is because this is a phase 2 case, reallocating that GRSA.
Okay. And so just really briefly, if you see that current base revenue, the RG total of about 479.6, do you see that?
Yes.
And so if we go to page 10 of this schedule 3, if you look at the 4th column to the right, we might have to zoom in a little bit. We should see the 479 million. There it is.
Yes.
479.583. Yep. That was on that first page.
Yes, that's the same 479 million, 480 million on page 2. And you can see that that does not incorporate the 22.95 GRSA that's currently in place today.
Okay, thank you. And so is it fair to say that we have both a movement of existing GRSA into base rates as well as a general reallocation of costs happening in this combined phase 1, phase 2 rate case?
Yes, that's correct.
And so 2 more quick data points. If we could go to hearing exhibit 151, which is Mr. Piquet's settlement testimony. Page 9. We talked about a roughly 15% base revenue increase. Can you speak to the bill impacts of the settlement based on this table for residential customers, Mr. Piquet?
Yeah, so the ultimate bill impacts for customers are well below the numbers we were just speaking about, of course. So those are just focusing on base rate revenues, right? We had a 22-ish% change from the last gas case, and in this case, adds a bit on top of that to get up to that 33% level. At the end of the day, that does not translate to the bill impacts here. For here, we've got to compare a customer's current bill, incorporating the commodity charges that are part of their bill, which is roughly half of what a customer pays at today's commodity charges. And so the ultimate impact for a residential customer is going to be about 8.6% in your average month. Of course, this is averaged across a year. It'll be slightly more in winter months, slightly less in cooling months. And so it's a much lower percentage there.
Then just one last data point, if we could turn to page 10 of the same document. Could you speak, Mr. Paquet, from an affordability perspective, how public services proposed rates in the settlement, not really the settling parties proposed rates in the settlement, how they compare to other utilities' wallet share across the country?
Yes, happy to. The company continues to have a really competitive wallet share, which is a factor stemming from the company's below average rates and below average bills. And so compared nationally, our gas wallet share is about 34% lower than the industry average. We're well below 1% here. Of course, this changes in real time year to year, but we continue to expect to be below both the Colorado average and national average moving forward, even with the settlement agreement that's brought forward for approval.
Thank you. So I think we can take this down and like to just really briefly, this is a bit of a side question, but you asked some questions about donations of late payment charges to EOC. Do you recall that?
Yes.
Do you have information about past commission decisions that have directed the company to make those payments?
So in my conversation with Commissioner Gilman, I noted that I thought that those were voluntary based on my personal knowledge of Colorado regulatory history over the past 10 years. We've been trying to do some quick digging here during the breaks to see what we can find. I think there's as I alluded to, there might be a longer history there, potentially going back into the early 2000s. There could have been some settlement agreements or commission decisions regarding the treatment of those late payment charges from customers. But that's as far as I've been able to get. So yes, I think there are some commission decisions on the subject, but I'm not sure exactly of the details.
That was a little bit off track from some of the other conversation about capital spending, but I thought we should clarify the record. So I'd like to come back to the chair's questions for you about a potential PIM and some of the terms that he suggested based on yours and witness Kinney's testimony in this proceeding. You mentioned the potential for unintended consequences associated with a PIM that could occur if not carefully planned out. Could you elaborate on what you mean by that?
Yeah, so the thing about the worst case scenario, right, is a scenario in which we've got a hard cap or a PIM with significant risk around it. And so the commission, so the company could potentially be in an untenable position of having to choose between financing a new project that could be bring a new customer online where there was net company investment needed to do so after taking into account customer contributions, or there was an emergent safety project on the system, an emergent safety event, or even a prior approved commission project, be that safety related or otherwise. And we've got to make the decision, hey, do we move forward with what the system needs and incur a penalty in light of that? Or do we respond to the incentives and the penalty and not do that? Of course, that would entail other risks to economic development or to safety or otherwise across the state of Colorado. And I believe in rebuttal testimony, both I and Ray Gardner talked about what an untenable position that is for the company and something we should all want to avoid. So that's just an example of a reason why we'd have to we'd want to make sure to get a PIM or a cap right. And that likely entails more than just thinking about what the cap is, what the deadband is, how the structure works, but make sure we're focusing on the right investments, that we've got a process to think about emergent needs and how that flows into or not into any cap or mechanism. And so there's a lot of detail to work through there, just like there is on, GCIF tariff language, like Commissioner Gilman and I were walking through. There's important language to think about, and we've got to have the time to do so thoughtfully.
Are you able to speak to any concerns the company may have about who bears the risk if the company is simply limited in what it can spend on capital without reference to specific system needs or the needs of customers that may arise in 2027 or beyond?
Well, today that risk is with the company. I guess in a future framework where there are penalties or hard limits, right? That's an interesting scenario to think through on how that risk could potentially be shared. But today that stands with the company, and the company thinks that it's our responsibility to provide safe and reliable service, and we certainly wouldn't want to do anything to compromise that.
Could the company and the stakeholders who are interested consider the chairs or WRAs or the company's PIM proposal or discussion as part of the stakeholder process contemplated in the settlement?
I'm sorry, could you repeat that? I missed the start of that.
Sure. Could any of the proposals raised in this proceeding through an exchange of testimony be further fleshed out in a stakeholder process contemplated in the settlement?
Yes, certainly. And I think that's the purpose of it, to say, hey, given some of the feedback we heard from WRA and the Sierra Club and some of the company's own rebuttal and some of the comments we're hearing from the commission in this proceeding and others, how do we think about this moving forward? How could this work? What would the mechanism look like? How could we address emergent needs? What's the review period? How long would this be in place, right? All those type of design and implementation and oversight questions that we think would need to be worked through. And the settlement contemplates a process for that.
A few questions for you about new business in particular, and some discussion you had with Chair Blank regarding both the GIP decision issued last week and the last gas rate case decision. Do you recall that conversation?
Yes.
To what extent does the company think that cost per household is the only or the correct measure of the value of a new business development?
Right, it's one component of any analysis, but there's other components to think about too. We've also got to think about, I think I talked about at a high level, the impacts to economic development, but there's a lot of pieces underneath that, right? There's property taxes at play. There's what that structure will be supporting moving forward, whether it's a residential structure, or if it's a business, nonprofit, or it's something else. All these developments impact our communities and our economies here in Colorado. And so we'd want to make sure we're casting a holistic view of the costs and benefits of new development there to make sure we're capturing all of that.
And how does those considerations, or let me say that better. How do those considerations relate back to your comments earlier, Ms. McKay, and during commissioner questions about the public interest nature of what the company is delegated to accomplish, not just for customers, but for the public good?
Right. The company's business is affected with the public interest, just like all fixed utilities are. It's a task that we take very seriously, and we've got to think about things holistically. We've got to think about cost to customers, at the end of the day, net cost to the company, how this supports our local economy and businesses, and ultimately supporting the choice that our customers make. I think the company and this commission and our interveners here are really pushing on a lot of levers to support energy efficiency and electrification, rightfully so. We think there's a lot we can learn and a lot of benefit to be had there on emissions reductions and cost effectiveness, and we're going to continue to support that. It's my understanding at the same time that customers still have a choice for their energy source, and we have an obligation to serve that when it's in our certificated service territory. So we've got to make sure we're thinking about all of this holistically.
There was some discussion about the extent to which the company has already removed incentives and required customers to pay their full incremental cost of joining the system. Do you recall that discussion?
Yes.
And can you speak to the extent to which public service has gone as far or farther than any utility in Colorado, both to remove incentives and to ensure customers are paying their full way to the extent possible?
Yes. I'm not aware of any other utility in the country contemplating a charge that would capture some of this upstream infrastructure like we're contemplating here with the GSIP charge. We're setting new ground here. Of course, the settling parties entered into this thoughtfully, recognizing we've all got a bit to learn here about price elasticity and how this affects or doesn't affect the market for construction here in Colorado. But we need to monitor it. In terms of other Colorado utilities, I'm not aware of any other utilities that directly contemplate upstream infrastructure charges for regulator stations, high pressure pipes, or compressor stations. And so I think we're leading the charge.
And do you have testimony in your rebuttal, Mr. Paquet, speaking to this, as well as to recent commission decisions addressing the question of what types of gas infrastructure are appropriate to allocate to new customers?
Yes, there is an ongoing miscellaneous docket addressing cost causation. This is stemming from a 2023 statute from Colorado lawmakers, 23291. And we just recently had a workshop with Commissioner Gilman to explore several capacity and new business projects in the past to explore this issue in more detail. So there is an ongoing forum to keep talking about these topics.
And Ms. Federico, do you happen to have hearing exhibit 134, Mr. Paquet's rebuttal handy? If we could turn to page 54. I thought maybe this would also help, Mr. Paquet. Does this refresh your recollection about another proceeding where the commission recently addressed the types of gas infrastructure appropriate to allocate to requesting customers?
Yes, I'm just scanning through quickly. Yes, there was a recent case involving another utility provider here in Colorado, Colorado Natural Gas. There's a litigated proceeding addressing their line extension policies. And as part of that process, I believe the debate has focused on construction allowances for distribution extensions and explicitly ignores from the conversation or leaves out from the conversation all upstream infrastructure apart from the distribution system.
Just to tie some pieces together, does Mr. Gardner also discuss regulator stations and how they play into new customer business in his testimony?
Yes, he does.
Lastly, on this topic, how does the GSIF in the settlement help further increase costs to be borne by new customers, whether for any particular infrastructure, compared to the incentives and the additional costs the incentives removed and the additional costs imposed in the past?
It's a whole new category of costs. So as I believe I was talking with Chair Blank about this, we've in recent years been adding a lot of costs onto the new requesting customer and away from the company's side of the equation. This stems from commission directives to methodologies for construction allowances to legislative direction on removing construction allowances and adding in meter and regulator costs fully to the requesting customer. The GSIF is a whole new addition to that to say, hey, not just within the normal distribution extension policy, let's think about all other costs further upstream and adding in a standardized cost to help address that moving forward.
Briefly on the GSIF, would you like to elaborate, Mr. Paquet, on why it is important to have a grandfathering provision for developers as set forth in the settlement?
Yes, it was very important to incorporate that because we're in many ways trying to mirror the guidance that we saw from Colorado lawmakers as part of Senate Bill 23291, which first contemplated these, removing of customer incentives from the company's gas tariffs. And so a lot of our construction and development projects in Colorado, just like in other states, take a long time to plan and to build. And so to inject a large new charge towards the end of the process could be really hard for those developers and then use customers to accommodate, given that it wasn't part of their planning. And so we want to make sure that folks have a little bit of time, right? We're talking about 6 months here, potentially of in between a request coming in and them having approval from a local governing authority. And so it's really just a pretty narrow window here where an exception could apply, but we still thought it was important.
Last topic, I have a few brief questions for you on telemetry and communication lines, Mr. Paquet, and then we'll call it a day for you. So going back to some of the questions from Constellations Council, could you just, again, to level set, whose responsibility is it to maintain an adequate communication equipment at a shipper's customer's premises?
It is the transport customer's responsibility. We are acting as the transporter for that gas on our transmission and distribution system here for gas. And so we've got to make sure that we're balancing supply and demand. And the only way we can do that is if we know what customers are using. Without a connection, a telecommunications connection there to monitor that usage, we're flying blind a little bit. So it's incumbent on them to be telling us what they're using.
And does the company dictate what technology that the shipper or the shipper's customer must use to connect to the company system?
We do not dictate that with specificity. It's their responsibility to connect to the company's system. And we've agreed we can work collaboratively here moving forward to figure out some solutions if solutions are warranted to make it easier for those customers. But it's absolutely on that customer to bear that responsibility. And it has implications for the company on potential investments and costs moving forward. And so we want to do so thoughtfully.
Mr. Judd asked you some questions about the 2019 stakeholder process. Do you recall those questions?
Yes.
To your knowledge, was there any consensus from that 2019 process as to whether or what system changes the company would or should implement for shipper communication line purposes?
I can't say. I can't remember the details of that 2019 process.
That's fair. You also were asked some questions about timelines in addition to the 12 months to file a plan. Do you recall that?
Yes.
Does the Public Utilities Commission have deadlines and procedures for company filed plans, particularly in proceedings where stakeholders are specifically anticipated to participate?
Does the commission impose conditions and deadlines? Is your question, Ms. Brahma? Yes, sometimes the commission does impose that. Other times, no. And so we think we've got a reasonable deadline here with 12 months to bring forward a filing. That's action forcing at the end of the day, and we think that's sufficient.
Does the company dispute that landlines are less the focus of telecommunication now than in years past?
No, we don't dispute that.
And did you review Mr. Russo's answer testimony with respect to where Constellation would like to go with respect to communication line options?
Yes.
Is there a reason why the company would not want to just immediately make communication investments now before a stakeholder process and without a PUC process?
Yes, absolutely. We want to be cognizant of the costs this could impose on the company and thus on customers, be it retail customers or transport customers at the end of the day, depending on how this gets allocated. And so we want to make sure first that we've got our arms on the options. We want to make sure we're talking to as many folks as possible, not just Constellation here, and identify a good path forward. And the stakeholder process is a great way to do that.
And finally, does the company believe, as with other capital investments, or to what extent does the company believe, as with other capital investments, it's important to take a close look at what's needed and the extent of spending needed in order to make an investment like the one the shippers are supporting here today?
Yes, absolutely. You know, thinking about communications and metering requirements across our system, we could be contemplating large investments here, either for customers and or the company. And we don't want to do that without considering all the options. We don't think anyone else wants to do that either. And so we're mindful of the costs that we invest on every project, and this one is no different.
Thank you. That's all the questions I have.
Thank you, Mr. Piquet. You may be excused.
Thank you.
Is Mr. Gardner out there? Can you hold up your right hand, sir? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I sure do.
You can put your hand down. Is anybody with you or communicating with you in any way?
No, they're not.
If that changes, will you let us know?
Yes, I will.
Over to you, Ms. Brahma.
Thank you. Good afternoon, Mr. Gardner. Thanks for being here today. Just briefly, could you state your full name and spell it for the record?
Yes, Ray Gardner, RayGardner.
And what is your position and for whom do you work?
I am Area Vice President of Gas Engineering. I work for Xcel Energy Services and testifying on behalf of Public Service Company of Colorado.
And did you cause direct, supplemental direct, and rebuttal testimony along with the number of attachments, including the gas operations overview document, to be submitted in this proceeding?
Yes, I did.
Do you have any additional corrections other than what has been pre-filed as we're here today?
I do not.
All right, with that, Mr. Gardner is available for questions.
I think Commissioner Plant, you said you did not have anything for Mr. Gardner.
I do not.
Commissioner Gilman?
Yeah, thanks. Hi, good afternoon, Mr. Gardner.
Good afternoon.
A few questions, some of which will sound familiar because a few of them were sent your way from Mr. Piquet. So I'll start there. I was asking Mr. Piquet about what the company is doing to kind of track new usage patterns, especially given the thought that we may see a significant number of customers begin to partially electrify, use the gas system kind of more as a capacity resource. And that could lead to cross-subsidization issues down the line. So he had sent me to you to see, I think we were talking about, well, when there's a problem, we'll talk about it. And I'm trying to understand what sort of tracking or internal intelligence the company has going on to, rather than wait until we see the problem, really try to get a better read on the growth of this and how things are transpiring.
Yeah, so I'll just kind of elaborate a little bit. So first, like was mentioned with Mr. Piquet, we don't have like flow data coming from individual meters. We don't have smart meters throughout our system. But what we do have is that the majority of our regulator stations do have pressure monitoring information that then feeds back to our SCADA system. And so whether it be electronic or ones that don't have electronic would have pressure charts, pressure reporters. And so when we think about our modeling on the system and we think about, like, for example, a cold weather day, right? So we would collect the pressure data across our system on that cold weather day, and then we would use that to really calibrate back to our models to better understand the usage across our system.
Okay, thanks. So that would be correlating that back to your hydraulic modeling at that same temperature to see how we do with regard to kind of the forecast. And then, so you had said this is a capability contained within most of your regulator stations. Give me a ballpark how many regulator stations we're talking about on your system.
Yeah, I believe the number is just in rough numbers is roughly 2,600 reg stations.
Okay, so that's kind of the most granular level, I guess, that you would understand more kind of temporal usage as it relates to ambient temperature.
Correct. We would monitor those regulator stations. There are other points in the system that we would monitor. So if you're looking at like our transmission system, we'd be looking at things like suction pressure, discharge pressure on our compressors. There's various different valve sets that might have pressure monitoring information as well. So there are data points throughout the system in addition to that. I don't have the number off the top of my head of exactly how many data points we have in our SCADA system, but it is a very large number. But regulator stations is more the downstream point. And so that's kind of what we're generally truing up to. We have gone and put in monitoring at what we refer to as like tail ends that guide us to looking at how that system is performing too. That's not in every case, but in generally, if you're looking at a system as a whole, so one pressure system or a system that's fed from a regulator station, we'd be monitoring that inlet pressure to the station. And then ideally, not at all of them, but at some of these, we would have a tail end pressure monitoring. The location would be driven generally by modeling, but then that would tell us how that system is holding up. So if you're looking at, say, a pounds medium station, we'd be looking for a tail end pressure at a minimum of 10 pounds that allows the actual customer equipment to function properly. And then on the upstream side of that regulator station, we'd be looking for a minimum of 90 pounds to make sure that that regulator station can continue to function.
Thank you. That's very helpful. Help me understand what's going on. And then is this a practice that you regularly go about, kind of going through and pulling all of this data to compare? Is this something that is a possible tool moving forward to try to like better monitor changes in usage? Help me understand what goes on now and how you envision kind of the use of this to trouble spot.
Definitely. We go through this process annually. So ideally what happens is that we're collecting data on the coldest day of the year. So when we have, say, a forecasted weather event coming up, one, we're making sure, obviously, as usual, that all of our pressure monitoring is in place and functioning well. But then also we would go, if there's regulator stations that don't have electronic monitoring, we would want to make sure we get a new pressure recording chart at that regulator station so that we're getting the best information we possibly can. And then we bring that data back and work with our modeling team to calibrate the model. And that would be an annual process.
Okay, thank you. Very helpful. And then just one more question, I guess, on that. If you see differences than what you, I guess part of my question is, are you seeing differences, like different behavior than you had seen or expected? And then what is kind of the protocol? Do you go back and update the hydraulic model? Help me better understand what happens next.
Yeah, so I can speak to it at a high level. So which is, and I'm sure our gas modelers are watching me and will pick on me later, but from a very high level, they would be collecting that data and then going back comparing. If there is a delta, then it's really digging into why the delta. And then that's commonly what can drive a capacity project in the case that, say, the tail end pressure is much lower than we were anticipating. Say you're actually eclipsing that minimum tail end pressure, then that would drive like a capacity project in that area. If there is a delta, then between the model and our real live expected data, then that's where we would true up the model and make modifications to the model to make sure that we're modeling as close to reality as we can.
Got it. Okay. Thank you for that. I also asked Mr. Piquet about potential issues with declining sales and steady or increasing investment, particularly in safety integrity investment, which you kind of indicate in your rebuttal testimony, maybe a fair assumption will increase rather than even stay constant. He said that was kind of something we'd have to watch for, to look and modify and take the necessary actions as that transpired. So I think that also sounded like something you might be able to address. I'm curious to know what will be the trigger that the company is looking for. You know, if we are seeing declines in sales already, if we are monitoring different customer purchasing trends in declines in, you know, percentage gas furnace, boiler, things like that. You know, it's my understanding many of those things have kind of turned the corner, if you will. And so I'm trying to understand, like, at what point are you like, oh, that's a lot. Now we need to think about how investment decisions kind of better correlate to changes in sales.
So I think the first thing to look at is really comparing or really looking at separating throughput from customer counts. So when we talk about safety investment, we're really paying attention to customer counts. If we decrease the throughput on a line, it doesn't materially change the safety investment that's needed to maintain that line. So just because they're running less gas through it, it's still holding gas. It's still holding gas at a prescribed pressure that's needed to operate the system. And so as a result, we still have to maintain it. The risk still exists, right? Independent of the actual throughput of molecules through the line. The customer count is the one that we pay close attention to. And so when we talk about comparing that with safety investment, what we would really need to be seeing is declining customer counts, but not just broad-based. They really have to be geographically like centered such that you could abandon parts of the system rather than replacing and maintaining. So that's kind of the key element. If you have one neighborhood and one customer chooses to electrify, it doesn't benefit us nearly as much from a safety standpoint because we still need to maintain the gas main and all the other services in the neighborhood. But if the entire neighborhood electrifies, in that scenario, rather than maintaining that gas main and all those gas services, now we can actually abandon those. And that benefits us not just on the capital side, but very specifically on the O&M side. It's pipe that we don't have to leak survey anymore. It's pipe that we're not risk modeling. It's pipe that we're not concerned about doing replacements on at a later date. And so that's really what we're looking for is the customer counts to decrease, but decreasing in groups basically that allow abandonment of the system.
Okay. Thanks. That's very helpful. So I guess if what you're looking for kind of is this magic trigger, I'm hearing geographically concentrated declines in customer count. Is that something you are tracking? And is that something you are tracking geographically to understand when this magic point happens?
I think our tracking could certainly be improved. I'll say that, but we are to the extent that we're aware when services and mains are abandoned, and specifically services. So if a customer chose to leave the gas system, let's say they chose to remove their meter, the process for us from a safety standpoint would be that we would go out to that premise and we would actually cut off that service back at the main. And that's from a safety perspective to make sure that we don't have we call it a sleeper service, but a service that goes to a house for which it doesn't serve gas to. Because that alone can present a risk because you have a customer that doesn't have gas, so their inclination to call, say, 811 when they're, say, putting in a new fence or a new sprinkler system is much less because they may not be thinking about the fact that there's a gas service there. So it presents a hazard. And across our industry, we've actually seen risks associated with exactly that scenario. So from our side, we become aware of it because we would need to cut off the service.
Okay, got it. So that your standard practice is to cut the service at the main and cap it there rather than just capping the meter.
Correct.
Okay. And is there a customer cost for that, or is that done at the company's cost?
That is a great question. I think Mr. Paquet probably could have answered that better than I could, because I'm not positive on how that cost is allocated when we actually do the service cutoff.
Thank you. Okay, wanted to get some of the safety, integrity, investment discussion you have, especially in your rebuttal testimony. In your rebuttal, you had said it's difficult to imagine a scenario where the company can meaningfully reduce safety capital spend and continue to operate a safe gas system. And you point to some of the legislative, and kind of PHMSA foundations for a lot of this work. And I was curious now where, the Pipeline Safety Improvement Act passed in 2002, or DIM stuff in 2009. Has the company seen a pronounced decrease in safety incidents per year? Especially, I would say those non-related to, construction activity, whatever. That in that time frame, is that something that you track and have available?
Yeah, so I'll speak to it from an industry standpoint first, which is that the industry tracks those incidents, and specifically PHMSA does. And so those are all like publicly available on the PHMSA website of all the reportable incidents that they've had, and you can sort them by class. So that data is fully available. I don't have the numbers off the top of my head, but I am positive that we have seen a substantial decline in those catastrophic incidents really since the implementation of the rules going back to 2002. And so one thing I would like to talk about just a little bit as we talk about like that capital spend, and you mentioned, it's hard to imagine a world where we bring the capital spend down. What we've seen across the country, as well as with the company, is that we saw a lot of accelerated capital spend up until roughly 2022. And in the company's case, since 2022, we've seen more moderation in that spend. And that's really reflective of the implementation of those new rules. So if you look at like the 2002 rule, where we invested a lot in making our system piggable. And I think we're really seeing the benefits of that now, because we invested the capital and now we're more into maintaining that system, and we're able to use advanced technology, which allows us to repair versus dealing with replacements on, large chunks of our system. So there's a lot of benefits from that. And I think you're starting to see that really in the capital spend, that it's a little more moderated. And similarly on the distribution side, initially we spent a lot of money through, like, say, the PSIA rider of replacing cast iron, replacing a lot of these vintage plastics. We obviously still have PVC that we're working to get rid of, and it's really driving some of that capital spend in the near term before 2030. But we're really starting to see some of that spend moderate more. And I think that's what I was really trying to explain in some of my rebuttal testimony is it's hard for us to imagine a world where that safety spend declines, because we have all of these outside pressures of PHMSA regulations that are driving us to do more and more and more. But at the same time, we are seeing some moderation, which is, I think, a positive sign.
Moderation means a slower rise or a decrease?
Slower rise, and in some cases actually level to declining. So I think as Mr. Paquet talked about a little bit, there's a couple plots in my supplemental direct, and then in my rebuttal that kind of look at that view from both nominal and inflation adjusted spend. And you can see the inflation adjusted one is definitely going down, especially after you get past 2022. But that it can also be, generally speaking, levelized. And so that's kind of what we're looking at when I make that statement.
Okay. And then just with regard to some of your explanation just previously, talking about how because the lines are piggable, or maybe, in part due to that you now may be able to repair instead of replace. Are there like trends on that we could understand, especially with regard to like the DIM spending? Is the company trending up in repair and down in replace? I have trouble tracking any data to really understand any changes in kind of behavior or expenditures in a more kind of broad sense like that.
Yeah, so I should clarify. So when we talk about inline inspection, I'm referring specifically to the gas transmission system.
Okay.
So when we talk about inline inspection, it's really running those tools through our gas transmission lines. But the idea is, if you go back to the beginning of like the PSIA, we had a pipeline called the West Main pipeline that we did a very large replacement on. The fact that we can now do inline inspection allows us to repair those lines so that we don't end up in a world where we were with that West Main pipeline, where we had to just carte blanche replace the whole line. And that's one of the huge benefits, is that we're able to monitor the condition of a line, make repairs as they're needed, and truly maintain the line versus really having that asset deteriorate over time. On the distribution side, it's a little bit different because there's not inline inspection tools that can be utilized on a distribution system. And so a lot of our DIMP spend is really tied back to things like, these vintage plastics that are known to be brittle, that are really driving a lot of that replacement spend, as well as some of that vintage steel, specifically going back to the 50s when it's really construction practice driven. And so they have like mechanical fittings, screw type fittings that we simply have to replace to address. But I think as we continue to look forward, we look at, modern day materials, and the expectation is obviously that they will function for much longer than their predecessors. And similarly, when we look at steel, when you get to post-70 construction, you're getting into more eras where they started with cathodic protection in place. And so the lines would be expected to last much longer than what we saw in some of those early vintages in the 50s and 60s.
Okay, a follow-up on West Main. It sounded like you're describing it as a safety integrity project due to kind of the condition or age of the line. It was my understanding that was a capacity expansion project because the infrastructure was not able to meet the peak design date. Am I wrong?
I think it may have had capacity elements for
West
sure.
Metro, is that what I
Oh, you're referring to West Metro.
Are we talking about two different projects? Maybe that's why
Yes.
I got confused. Okay,
Yep.
thank you.
So,
I was getting really confused as you were talking because I interpreted the wrong word. Okay.
yeah, sorry, I went way back with the West Main. That's many years ago. That's more like 2013, 2014 era.
Okay, I'm less confused than I was. Thank you.
Okay.
Sorry about that. And then you had mentioned that starting in the 1990s, PHMSA identified PVC was a significant risk. And you just show progress in your testimony, I think, of PVC removal since 2015. I was curious what progress there was from the 90s to 2015.
So for the company specifically, we focused a lot in those earlier years, really predating PSIA, on things like cast iron, which were larger risks on our system at that time than PVC. So we worked very hard to get rid of cast iron. We got rid of its CAB, but there's multiple different material types at that time. Bare steel, for example, that we worked very hard to get rid of, that were a higher risk than PVC at that time. What we saw with PVC, especially in those early years, was that it didn't leak very often. If you looked at the leak data then, it was actually it performed very well. The problem became that when it failed catastrophically in that it would crack. And so when you try and make a repair, it was difficult to repair. But we really started seeing the impacts of that around 2015 and forward. And then even more recently, we ran into more material availability issues of being able to get like gas rated PVC from our suppliers to actually be able to make repairs and maintain it, which then further drives the need for replacement. So it's kind of a combination of things, but it became a lot more prevalent here in the last 10 years.
Okay. I've just one more while we stay on the safety issue. So you'd indicated in your rebuttal that in part due to the advanced leak detection rule, the leak classification and repair requirement timelines that are now in commission rule, that it should reasonably be expected to increase safety related expenses going forward. Sorry, do you have any comment?
Oh, I was just going to say, I think the intention of really what I was trying to articulate is the fact that regulations continue to come out, and so that drives additional expenditures. So, we're rolling out advanced mobile leak detection. That provides a lot of benefit to our customers. The goal is really that we're limiting the methane that ever gets out of our pipe, but even more so that when it does get out of the pipe, that we're aware of it as quick as possible so we can make repairs and frankly keep the gas in the pipe. But there's also rules, like PHMSA is currently working on a rule related to gas distribution piping, that really is somewhat of a distribution version of the gas transmission mega rule and the MAOP requirements that are found there. And so what we sit there and see is that we have additional regulations that continue to drive pressure on, cost pressure on our system. And so that's really what I was trying to articulate.
Okay. Yeah, and I'm trying to understand if the introduction of these different rules and things necessarily is always additive in capital costs, or if instead it kind of reshuffles the priority deck, where by being that my understanding of most of the PHMSA stuff is to know your assets, prioritize the highest safety problems first and address them. And so to the extent like you have an introduction of a new higher priority safety problem, I'm trying to sort out in my mind, is it necessarily that the chunk of things you were already planning on doing is immovable, or really do we just get higher priority things that may bump something to next year? Like, I think my impression of your testimony was these would necessarily be additive, and I wasn't sure if instead there would just be some reordering of priorities to ensure we're just addressing the highest priorities first, and that may look different with more information.
I would say for the most part, they are additive. And so that what happens is that PHMSA doesn't remove requirements for, say, the DEMP regulation or something like that. But what we have seen as a company, what we really seek to do is to implement these efficiently. So for example, when we have a MAOP reconfirmation project that also aligns with where we are doing a transmission integrity assessment, we try and leverage those two with each other. So if the MAOP reconfirmation project requires, say, a pressure test, then we would try and utilize that pressure test for our integrity assessment so that we're offsetting some of that work. So we're kind of getting the 2-for-1 type of scenario. Same thing with inline inspection. We've had cases where we have an MAOP reconfirmation project that requires additional data that would come from an inline inspection tool. And so we seek to align that with our transmission integrity assessment that was already scheduled so that we, again, get more of a 2-for-1 so that we make it, while it's still an additive regulation, we're trying to drive as much efficiency out of that as we possibly can to make it less additive.
Okay. Question on some new business. I'm trying to make sure I get all of the lingo appropriate. So I'm trying now to understand service notification date. It seems we have a prime example here. So with regard to the Keystone Hotel project, which you discussed in your rebuttal, this customer called the builder call line in 2019 to inform of the project. They didn't finalize plans for the project until 2022. What's the service notification date?
The service notification date would be 2019. And the reason that it is the reason I think is probably very confusing to understand is that depending on the customer and what they're building, that can change. Like it can be confusing because they can either do one service notification or in some cases they do multiple. So for example, in a Keystone Hotel project, it's really serving this one hotel. So they submit one service notification. However, if I have a developer that is developing, 1,000 homes over a period of a couple years, what they might do is they might submit their service notification for, say, the upstream side, the offsite piece, or even just the first phase of their development. And then they might submit a second service notification for the next phase of their development. So it can vary. And I think that drives some of the confusion around that service notification date, because it does depend on the size of the customer, depends on the individual customer. But in the case of Keystone Hotel, service notification date would be 2019.
I've heard in other proceedings the term formal application. Is a service notification and a formal application the same thing?
I would say yes.
Okay. I'm trying to make sure I have my lingo right, because I run in circles.
The other thing that can complicate it is if we get a service notification and then say a customer sits on it for an extended period of time, and say the system changes substantially, and then we might request that they submit a second service notification, say if it's 3 years later or something, and because then it would allow us to quote to that new service notification. For the most part, I would say that initial, like in the case of Keystone Hotel, it would stay as that 2019 date.
Now, I have in your rebuttal that I think that's where I got it. They didn't sign the service agreement until 2022.
Correct.
Okay, so that has no bearing on the service notification date. That is just the application.
Correct. So they would have submitted their service notification or their request for service from the builder's call line in 2019, and then they wouldn't have signed their agreement until 2022.
Okay. Okay. So if line extension policy had changed in the interim between 2019 and 2022, it's my understanding they would be in the 2022 version, because it requires both the service notification as well as a signed agreement.
I believe that would be correct.
Okay.
Yeah.
Feel pretty good about that because I read it a few times today. But I don't know. I'm trying to confirm. It seems like there are a lot of little pieces I'm trying to put together what makes an agreement or a certain milestone in this process. Okay. In response to testimony, I think it was WRA testimony, I can't recall, that criticized the company's budgeting versus actual costs on this project. You mentioned that a $1.8 million portion of the project or something needed to serve this project was not in the GIP because it was another project, kind of. It sounds a whole lot to me like an interrelated project that was needed to get the job done. So, what's done is done. That GIP has long passed. But wouldn't that kind of be an interrelated project that should, moving forward, be reported together?
So for the purposes of like this rate case, we really tried to do exactly what you just said, is put those pieces together, because you're exactly right. The way this project was executed was as two separate projects, because there was an upstream side that was the intermediate pressure portion, and then there was a pounds medium portion, basically the portion downstream of the regulator station. And so in our system, they were executed as two separate projects. And so to your point, what's done is done, but those two are interrelated projects. And I think the intention and the way that we really attempted to display it in this filing was to show them together, because they are interrelated, both supplying gas to that hotel.
And is the company of the understanding that that is what should be done in GIP filings for interrelated projects?
Yes, that is our understanding.
Okay. So the 1.8 million is this intermediate pressure?
So there's, I believe the cost estimate for the intermediate pressure portion was 5.1 million.
Okay.
And then the pounds medium portion would have be like 3 million, I think.
In actual cost or forecasted cost?
I think in actual cost.
Okay.
I have to pull the record to verify exact numbers there. I'm trying to give best off the cuff I can here.
Okay, that's I can go back and trace the two, the 1.8 and the 3. And did the customer have some customer responsibility for both portions or only one portion of the project?
They did. So they had a total customer contribution of 3.3 million. And we attempted to clarify some of that through both my rebuttal as well as in discovery. Because in attachment, it was ARG4. We actually only had the upstream portion, which was the $1 million, or roughly 1 million. And then we really tried to capture the rest. But we tried to kind of true that up through rebuttal and the discovery process to show that the total customer contribution there was 3.3 million.
Okay. 3.3 million out of 8.4.
Yeah.
Total.
Correct.
And how does the company determine what portion of that is paid by the customer?
So this one would have been driven by the line extension policy going back to 2019. And so
2019 or 2022? They hadn't signed an agreement until 2022.
It's a good point. So I think it would probably go back to 22. In that case, there would have been a construction allowance as well as a offsite credit that applied to their project, and that's what would have driven the calculation for their cost.
I thought the offsite credit was like around 28%. Is the credit back? So then the customer responsibility is like 72%.
It was, I don't know the exact numbers. And so this is, again, I'm a little outside of my area of strength here as far as talking about the service line extension policy at that time. But again, Witness Piquet probably could have talked about that better. But I know the numbers, that it was roughly $1 million for the IP side, and then it was what is that, like 2.3, yeah, for the pounds medium portion is what they paid.
Okay. Okay. I know, I think WRA had also brought up kind of the link of this project or potential link of this project to the Mountain Energy project. And I read the whole faucets versus hoses analogy that you drew there. And I get what you're saying, but to me, the point they were making is if you let more water out of the faucet, you also need a bigger hose. Like that is a contributor to having a supply constraint upstream. Isn't that also the case? I feel like that was a little talked past maybe in the analogy. That like, well, I don't think they were saying it was the exact same thing. At least I don't interpret it as the exact same thing. But I kind of took the point that clearly when you add more capacity and use downstream, especially at the tail end, this contributes to the greater supply constraint.
It could contribute to it. I think there's a couple of things that are important to remember. So one is timing. So this project really predated Mountain Energy.
Right. And I'm not
very much so. Yeah.
I'm not picking on the timing. Okay. I was just more talking like technically speaking, the two feel more related to me.
Yeah, and it adding to your point, adding additional customers contributes. If let's say the capacity constraint, let's say we weren't capacity constrained, we were solely supply constrained, adding more customers contributes further to that supply constraint, which is I think what your point is. And then but in this case we were really functionally, we're both supply and capacity constrained. So independent of what you do with the faucet, you'd still have to relieve the capacity constraint so that you could get gas to the end use customer.
In order to serve that customer, yes.
Yeah.
And I wonder how many people are looking back to see what the faucet and hose discussion was now, but that is in your rebuttal testimony.
Yes.
Okay. A few other questions. To some of the discussion on if it could ever be the case where customers could or should pay for, say, upstream regulator stations or other items. You talk about how other customers could benefit from regulator stations. I know the configuration's a little different, but I'm trying to understand kind of the corollary on the electric system where, we often will charge a customer, say, if they tip us over, straw that broke the camel's back, now we need a new feeder. And in that case, it seems to me in that case, other electric customers also can benefit from that new feeder. So this is not like a new issue, but it seems as though we're drawing the line kind of further downstream here with regard to that. And so I just wanted to kind of understand the relationship there and also understand your view on, often this is not based on who is the sole beneficiary, but who is the cost causer that has caused this investment to be necessary. And that seems a little different than some of that differentiation.
I think the thing that makes it complicated, and I can't really speak to the electric side very well, but if we go back to what we were just talking about with Keystone, that we could agree that the Keystone Hotel would be a contributor to that, but are they the straw that broke the camel's back, or is it somebody else, right? And I think that's what gets really difficult when we look at regulator stations, is that you may have a large development, you put in another regulator station, and that regulator station really serves all of those customers, not just the one customer that tipped it over the edge. Because if you swapped those customers around, it could easily be, you could say it was the one before that. So it becomes, with an integrated system like we have, it makes it very hard to trace causation back and go back to individual customers. And so I think that's kind of why we draw the line the way we do, is because it's when we put in an additional regulator station, there may be one customer that tripped it over the edge, but the reality is you put that regulator station in and it benefits a very large number of customers. So you may have, say, a development of 300 customers that triggers a regulator station, but in reality, that regulator station is serving, more than 1,000 in that geographical area.
Right now they use it, but if there was not that growth, it was not projected to be needed, right? To serve the existing customers.
Correct. It wasn't deemed to be needed before. And so then, but that's always dependent too on, okay, as long as their usage stays exactly the same, if you go right up to the line, right, then just got to be careful that nobody tips you over.
Sure, but you're declining in usage per customer, not increasing, right?
Fair, as long as nobody's putting in new commercial ovens or something like that. So
does not seem to be the trend your usage data is showing.
Yeah.
Would you agree with that?
Not the trend, but it certainly happens. And in fact, we do see it with some regularity that you have, say, we've had a bakery in Breckenridge that went and put in new commercial ovens, right? And so that's, that has an existing customer that triggers additional need on their system. So
okay. I don't know if their new ovens triggered a regulator station, but in general, your usage per customer is declining as all of this is going on around it, right?
Fair. And I think the point that we're trying to make is that really that regulator station, while it really serves a reliability benefit for the other customers, right? So while your statement is accurate that before those say 300 new customers came on the system, we didn't need that regulator station, but it provides them a huge reliability benefit being there.
Okay. And then Mr. Fugetta in his testimony gets to examples where several new business plan projects required more than one regulator station. So it's not just like we just tipped over the edge to need the next one. We needed 2, 3 going in these circumstances. Does that seem like more obvious and more discrete that this is caused by those large new loads if they're triggering not even one, but multiple new regulator stations?
Well, I think that really illustrates the complexity of what we deal with, because the majority of the time, that's not the case, right? And so the causality can be difficult to trace. But to that point, if you have a very large development in an area that's driving multiple new regulator stations, then the causality is very clear. And so that makes it a lot easier to chase those costs back. But in the case that you have a new development that may have multiple different builders, multiple different developers involved, and let's say I need 3 new regulator stations to serve this area, and let's say there's 6 different developers there. Who pays for which? And it becomes kind of this trick to sort all that out as to exactly whose developments are driving the need for which regulator stations and what percentage of said regulator station that each developer then drives. I mean, arguably you could say, well, just sum up the developers, divide it by the number of developers and call it a day. But that's easy for us to say, and not so easy if you're the developer that's paying that cost and wanting to make sure that what you're paying for is fair as compared to your peers.
Right. Okay. And then just in reviewing some of the on-site and off-site distribution, extension, and equipment language in the line extension policy, I'm not seeing anything in the line extension policy that would prevent. I'm actually seeing it building you the opportunity to assign costs for not just regulator stations, compressor stations, transmission mains that you may determine to have been caused by that project. So when I asked about the complexity of the system, but like there is nothing standing in your way of interpretation that's already allowed in the distribution.
To some extent, I would agree with that. And in fact, we do have a couple examples where we've built new compressor stations on our system that were then billed directly to a downstream customer, where we had a very large downstream customer that was seeking either more gas, a higher gas pressure, a specific gas pressure. And so we were able to allocate that cost very directly. And so we've done that. Off the top of my head, I know of two compressor stations and I know of a regulator station that was exactly, a similar scenario, that is a very large regulator station that we built specific to a customer, and we charge that customer for that entire regulator station.
Okay, thank you for anticipating my next question, if you'd ever done it. In that circumstance, are those assets still part of the looped system configuration, or are they literally kind of islanded to the specific customers that they serve?
The 3 examples that I gave there are more islanded to the customers that they serve.
Okay. Okay, just a couple more questions. I read, I'm trying to figure out, I think you referenced it, a discovery response CPUC 1.8 that indicates that the average gas cost of removal expenditures totals approximately $15 million a year if you look either over the 5 or 10-year time frame. Does that sound familiar?
Vaguely. Do you have the response there handy so I could look at it?
No, I couldn't find the actual response. I only found the reference to it.
Okay.
And the information. Are you aware of the general annual decommissioning costs or cost of removal that the company is seeing on the gas system?
Very, very high level.
Okay. I'm like, maybe I had intended this for another witness, but I have it here. Anyway, I had read that that's been $15 million a year, whether you look over the 5-year or 10-year time frame. And I was just curious, with the cost of everything else going up, why is that one thing staying, which seems very tied to the cost of labor and the cost of materials? It seems curious to me that that is not increasing in cost over the expanded time frame.
I think it's probably a better question for witness Moeller.
Maybe that's who I intended to ask, and that's why my notes are bad here. Okay, I'll ask him these next few because they're kind of related to that. And let's see. Okay. I think I can get to that. Maybe, and apologies if my notes are bad about who said this, but did you address the reporting requirements that Mr. Rivera-Lugo discussed about retirements in your rebuttal? Or maybe I really am on Mr. Mueller.
I think you're on to Mr. Mueller.
Okay.
Yeah.
Thanks for solving
I
that
think
mystery for me.
I did talk about it a little bit around the reporting as far as I think if what you're referring to is the desire to say look at the depreciation life and then say did the asset meet or exceed that depreciation life and talking about reporting around that and studies around that because I think my testimony talked about how we currently do like integrity management modeling that really guides us to, when that asset is at end of life, independent of what the depreciation life is. So if that's the nature of your question, then that is definitely something that I talked about, but otherwise it'd be more towards witness Moeller.
Okay. Okay, there's Mr. Mueller. Sorry for confusing you there at the end. I appreciate it. Those are my only questions. Thanks.
Thank you, Commissioner Gilman. Good afternoon, Mr. Gardner.
Good afternoon.
Just a couple questions. Can we pull up hearing exhibit 117? In this case, it's your direct testimony at page 11. Do you see how actual capital additions were $477.7 million in 2024?
Yes.
Can we pull up hearing exhibit 147 at page 14 again? I think this was, yeah, there. Can you go down? I got the wrong page. It's the, oh no, that's it. That's it. So do you see how basically in every year nominal capital spending is close to $680 million?
Yeah, so first I think it's important to note this is forecasted capital expenditures, not capital additions. So I think that's important that we are comparing apples and oranges there. But yes, I do see that capital expenditures are greater than 477.
All right, and I have your exhibit from the GIP ARG1 marked as a hearing exhibit in this case, and I can pull it up. But if I represented to you actual capital spending was 461 million, would you accept that, or I'm happy to pull it up?
If you could pull it up, that would be appreciated.
Yeah, can we pull up what is hearing exhibit 1709? Do you see 461?
Yes, I see the 461.5.
All right. So you can take this down. Mr. Piquet's oral testimony seemed to suggest that capital spending, proposed capital spending is somehow decreasing in nominal dollars. But when you look at 2024 compared to the 2026 to 2030 forecast, it looks like capital spending is consistently up by virtually $200 million a year. Is that a fair characterization of the exhibits we just discussed?
Well, I think the exhibits that we discussed are comparing a little bit of apples and oranges there because one of them is CapEx and the other one is cap additions. They're also based on different forecast models. So I think there's a lot of variables there. And I think really what Mr. Piquet was really trying to refer to was if you're looking at, say, my supplemental direct testimony, there's a figure there that walks through historical spend going back to 2020, I believe it is. That gives you a little bit more perspective as to what our spend has been from a capital perspective. And so and similar to the conversation that I had with Commissioner Gilman, I think across the industry and what the company has really seen is that we've seen an increase in capital spend more aggressively up until 2022. And then from 22 going forward, we've seen a lot more moderation in that spend. And I think that that's better depicted in my supplemental direct testimony there, as well as compared to the figure that we looked at in my rebuttal testimony.
And if the concern of the commission, which we did express in the GIP, is that there's a 30% increase in capital spending from 2024 to 2026 and beyond, that concern is more or less consistent with your oral testimony and the tables we just discussed. Is that fair, or would you say that different?
Well, I think when we talked about this in the GIP hearing, and then when we talked about it, going forward, really as part of my discussion with Commissioner Gilman as well, when you look at what we've seen from a spend in this near-term period, we do see an increase there in that near term of, say, 2027 and some in 2026, where you're seeing the impacts of things like PVC replacement. You're seeing the Mountain Energy project. You're seeing the Louisville to Rollins project. You're seeing Tiffany compressor, multiple large capital projects that kind of skew that trend and make it a little bit more lumpy. But I think the point remains the same, is that when you look at that trend, really from 22 going forward, you see more moderation in that spend. And then as you get into those out years, you actually see more of a decline.
I'm still not sure I'm tracking. And maybe there's a different exhibit in this case. I couldn't find it, but it looks like in 2024, capital spending was, somewhere under 500 million. And it looks like from 2026 to 2030, capital spending is in excess of 660 million. So it looks like starting in 2026, and I'm not clear exactly what happened in 2025, it looks like there's a sustained long-term substantial increase in capital spending compared to what we've seen in 2022 to 2024.
I think there's an exhibit in my supplemental direct that we can follow up with, and maybe it's something that that we can cover even in my redirect with Ms. Brahma, if that's easy.
Yeah, that'd be helpful. All right, that's all I had. You want to see if we can get redirect in tonight, Ms. Brahma?
Sure. Thank you, Chair Blank. This will be pretty brief. Mr. Gardner, I'd like to go back the discussion you started with Commissioner Gilman on the company's current capacity and system planning methodologies at the very beginning of your testimony today. Do you recall that?
Yes, I do.
And there was some discussion about the difference between throughput and customer count to the extent they drive system planning. Do you recall that as well?
Yes, I do.
For the 2024 to 2025 period of capital investments at issue in this case for setting rates, to what extent did the company see significant concentrated customer count reductions that would have materially reduced or changed the need for system safety investments?
At this point, we really have not seen that occur really at all.
And then you also referenced a couple different times the need for near-term investments in PVC safety remediation. And you referenced early on that when PVC fails, it fails catastrophically. Could you please elaborate on what you mean by that?
Yeah, so when we experience a PVC failure, the PVC, typically we see cracks that develop axially down the pipe. And so that makes it very difficult to remediate, such that when we go to actually try and expose the pipe and expose the leak, that it can actually get worse because we're disturbing the soil, resulting in a true blowing gas scenario. By contrast, with a steel asset, if you have say a corrosion leak, it's really it's more commonly like a pinhole leak, something that leaks at a slow rate. And as you expose it, you don't really see a huge change in the leak, in the amount of gas escaping the pipe. And you have different alternatives that allow you to isolate that leak. When we're dealing with PVC, those alternatives are not available, which means that we're putting our people a lot more at risk, and or we have to move back much further to isolate greater lengths of the system to allow us to cut off the pipe and actually make repairs, which again gets very difficult because you disturb the soil and you're trying to make repairs to a very brittle piece of plastic.
And what does that mean for public safety in particular if you have something happen to a brittle piece of plastic gas pipe?
So at the end, you get a lot more gas out of pipe, which means it's a much more hazardous leak. So it has environmental impacts as well as much more, frankly, risk of ignition or explosion because you have a large quantity of gas that could be escaping from a leak from a PVC pipe as compared to, say, a steel.
Okay. And then lastly, I just want to talk for a minute to try and clarify some of the numbers in the record around capital additions and capital expenditures and forward-looking models. First of all, could you just explain your understanding of the difference between a capital expenditure and a capital addition for purposes of your testimony?
Yes, so a capital expenditure is cost that you're incurring through the project. A capital addition includes the entirety of the project, including things like carrying cost of capital that were undertaken for that project. And so a capital addition is something that is seen when the project in services versus a capital expenditure is something that's accrued over time. So capital additions tend to be very lumpy because they're all the cost hits at the time that the project goes in service.
And if we could look at hearing exhibit 117, we just looked at a moment ago. This is Mr. Gardner's direct testimony at page 11. So directing your attention, Mr. Gardner, to hearing exhibit 117 at table ARGD2. Can you identify what these totals represent? And we don't need to go category by category.
So these are capital additions. And so this for 24 would be actual capital additions. And then for 2025, we're looking at a combination of actual capital additions as well as forecasted capital additions for the period of July 1st through December 31st.
And can you explain if these numbers are built on a project by project basis versus bigger picture CAGR models, or how these particular numbers are derived? Again,
So
so
these additions would come through from projects that get in service in that period, which would then flow into those models to show the actual expenditures, or the actual, sorry, I used a terrible term there, but the actual additions.
Thanks for clarifying that. And were you listening earlier, Mr. Gardner, when Mr. Paquet spoke to the company's long-term rate forecast model appended to his testimony?
I was, yes.
So if we can look at your rebuttal testimony, let's see, I'm trying to find the right hearing exhibit 147 at page 14, which you also talked about with Chair Blank. So this table, first of all, you noted already it's capital expenditures and not capital additions. So timing difference, is that fair?
Yes.
Okay. And then to level set, if we scroll down just a little bit, there's a footnote reference on line 3 of this page, footnote 12.
Yeah, that this would be driven from the long-term rate forecast model.
Okay. So how is that different from from a project by project buildup of the actual amount included in rates?
So the long-term rate forecast model, like Mr. Paquet spoke to, is really something that the company put together at the request of the commission. That was really a kind of a modeled view of what the world might look like, and doesn't necessarily reflect actual projects planned to go, actual project planned expenditures. It would be more, it's a modeled approach versus you could think of it as more of a top-down versus a bottoms-up.
And did you also hear Mr. Paquet's discussion of the extent to which this long-term rate forecast model, which is based on the company's direct case, has changed by the settlement and other factors that may have changed since then?
Yes, I did hear that. So
just to kind of summarize here for purpose of this figure of CapEx, do you consider this to be at a high level a reasonable directional indicator? Or how would you characterize this versus the company's data that's actually included in the rate case?
Yeah, this figure really provides overall a directional view of how the company's spend is trending. And thus, I think the trend lines are important to note here, probably more so than the y-axis dollars, because it really depicts the idea that of what we're truly seeing in the system, which is that in the really 26 to 28 period, we are seeing some degree of increase in forecasted expenditures due to some of those large projects. I mentioned PVC, mentioned Mountain Energy, Spear Canal, Louisville to Rollins. There's significant projects there that are driving those near-term capital expenditures up. And then at the tail end of that, then we're seeing a trend downward. And then from a inflation-adjusted CapEx, we're actually seeing an overall decline.
And then just one other point of comparison, Mr. Gardner. Do you know the difference between sort of common investments for the companies through the company's gas business versus gas operations investments?
I do, yes.
Can you just at a high level indicate what the difference is between common and other gas operations investments?
Yeah, so other gas operations investment is more related to things like system safety and investment in the individual assets, versus common would be looking more at things like tools and fleet and facilities, things of that nature.
And do you know whether common CapEx is typically included in GIP filing data?
I don't believe it is.
Okay. Thank you. That's all I have.
Thank you, Mr. Gardner. Gardner, you may be excused. Appreciate it.
Thanks.
Any final comments before we break for the evening, Ms. Brahma?
I would just note that to our knowledge, we haven't received any opposition to the admission of hearing exhibit 116, revision 2, which was witness Perugia's corrected direct testimony. So I'd like to confirm that that can be admitted into the record.
Any objections? So moved. Oh, Ms. Mandel, do you object to that? If you have something else, we'll wait.
Something else. Thank you.
So moved. Anything else, Ms. Brahma?
Not to my knowledge. The company will be ready in the morning. I think maybe we should just confirm who's up next, but we will also be evaluating after hours to see timing of witnesses.
So I have Lee, Bulkley, Mueller, maybe depending where we are, Mr. Wenner's available, then Howard and Freitas.
I think the only addition we would have, Chair Blank, is that Mr. Kanoy would probably be next on our list, given.
Yes. Sorry.
That sounds good. And then Mr. Weiner will confirm his availability. We're hoping he can be available a little bit before late afternoons, but we'll update in the morning.
Okay. I think we're going to be going into the afternoon, so.
And just to confirm, sorry, I just want to make sure I heard it right. For Mr. Kanoy, was that first before Ms. Lee or after Mr. Freitas?
It'd be before.
Before Lee?
Yes.
Thank you.
And Mr. Judd, other than Mr. Piquet, it looks like you'll witness will get to hear the other cross. So
that's what I was thinking too.
Yeah. Ms. Mandel.
Yes, Chair. I'm checking on the interest in having Dr. Hopkins testify and be available for the commissioners. His was hearing exhibit 1201, which covered the GSIP and the issue of the infrastructure costs that should be or appropriately included into allocation to existing customers, which has been brought up a couple times today. So because I'm bringing that up is because he has limited availability tomorrow. He's in a hearing in DC. We're trying to determine whether he could testify after 5 p.m. DC time, so it'd be available after 3 tomorrow. But he also, according to the cross-examination matrix, witness availability, he's also available after 10 a.m. on Wednesday, definitely.
Commissioner Gilman.
Sorry, did that again with the video. I think I can do without questioning him. I mean, it sounds like he's got some complications, so I think I can just ask Mr. Kenny some of my questions and he should be able to answer them.
All right, Ms. Mandel, Hopkins is excused.
Thank you.
Mrs. Kusi.
Can you hear me?
Yeah.
Oh, perfect. My question is similar. I know Councilwoman had suggested that she had possible questions for my witness. It was the same issue with the original
Shea.
witness. Yes, Mr. Shea, because Vince Fugetta has left the city of Denver. So I was curious to hear what your thoughts were on questioning whether he needs to be available, considering Mr. Shea has limited availability.
Yeah, I was planning on still questioning him. I wrote down he is available after 1 p.m., which should be, I don't think he's going to get up before 1 p.m. Does he have limited availability Wednesday also in case it comes to that, or?
I'm pretty sure it was anytime after 1 tomorrow and then Wednesday all day.
Okay. I do plan
Wednesday afternoon, excuse me.
Okay, I do plan to still question him, and I don't anticipate need to speak for the chair, but I don't think we're getting to him before 1 anyway.
Okay, sounds good.
Right, very unlikely. Ms. Mandel.
Sorry to bring up Dr. Hopkins again. I wanted to clarify also because of the time difference and what's going on in the DC hearing. For Dr. Hopkins, he can also testify first thing tomorrow morning. Just wanted to make that clear in terms of availability. It seems like there were a bunch of questions that had to do with what he testified about. So I wanted to also make that clear. He's available first thing in the morning here.
Unless I think Commissioner Gilman seemed okay with letting him go, but Commissioner Gilman, any further comments?
No, I don't think it's necessary. Thank you. Appreciate the clarification. I did have one other thing for you, Chairman.
Yep, go ahead.
Probably a request for Ms. Brahma. Just as it's come up, I'm not entirely clear on the Keystone Hotel project, and I think it's a good example to run through since it is already quite comprehensively in this record. I would really love to be more clear on a few things. First is which vintage line extension policy the company interprets that customer is actually bound by or grandfathered by. And then just an overview of the calculation that dictates the customer's responsibility for the offsite distribution extension and improvements. Not entirely clear upon what the 3.3 million out of the 8 million is based, and would really benefit from some clarity on that. So I don't know if that's Mr. Bouquet really briefly, or if Mr. Mueller knows that, or how we can go about just getting more clarity on that.
I think I'd like to follow up on that, because I think it's actually a conjunction of a couple of different people potentially. And so if it's all right to circle back on that in the morning, we'll take that.
That's fine. I just wanted to flag, I mean, those are really the two questions, like which distribution extension policy are they under, and what date and action dictated that? And then just kind of break down the math for me on what the customer contribution was and why.
Okay, and just to be clear, Commissioner, are you looking to speak to someone about it, or are you just looking for us to put a document into the record, or some combination? Or leave it to us? I can do that too.
Depends if the document causes me more confusion or less. I hope it will cause less, and then I don't have to ask any questions about it.
Okay, we'll see what we can do and circle back in the morning.
I think it might be good if there's a future witness that could present the document. I think that would be best.
Okay.
All right. Anything else before we break for the evening? See everybody at 9. Thanks all.